So close to not boomering that. And good afternoon, good evening, and good night, and welcome to day 2 of Aussie Overlawd's Kyle Rittenhouse Watch Party. Today we have Nick and Uncivil Law going through the opening statements and a few other bits and pieces, so this should be a little bit fun. It looks like I'm not receiving any analytics in the background at StreamYard, so it looks like it's going to do that stupid thing again where YouTube says that I'm not live. So I've already put out a tweet, I've already put out a post, but if you need to, feel free to share the news that we're going out live. In the meantime, where are we? Did you watch any of the trial live? No, I didn't. That's why I've gone back and doing this. Oh, look, now it's showing the numbers. Excellent. Hopefully that means that I'm showing us live on YouTube. That would be very nice. Okay. Present the screen. Share the screen. There we go. Okay. All right. Full screen that for when we're ready. And let's get into it, shall we?
What the hell is this?
Oh, crap.
You are here and watching this stream to receive commentary and analysis from me.
And me.
And we will be joined at some point by Uncivil Law. Uncivil Law is another legal YouTuber. So that's why you are at this particular channel. If you do not want commentary and analysis, if you want someone else to, you don't want someone talking about what happened or what's going on in the courtroom or anything like that, go watch a different stream. Just go, that is fine. You'll be happy there. You can watch this whole thing on Court TV. You can watch it on Yahoo Finance, and there will be no dummy sitting on the screen talking about what's happening and trying to help translate what's going on for you. That will be very easy for you to do. But you are here for the commentary and analysis, or you shouldn't be here at all. There's not much else to it. And so if you tell me, don't talk over this or don't talk, the answer is no. The answer is no. As a preliminary matter, just to get things out of the way. Okay, let me tweet this out. Kyle Rittenhouse trial coverage resumes now. I'm joined. In case people didn't see the link yesterday. What are you talking about? Oh my gosh. Okay. Almost ready.
Time to get the cage ready.
There we go.
Okay, I wonder how that's going
to work. I think I'm set. I think I am now set for this show. Oh, I just got out of the shower. So nice to be freshly showered. And whoo!
I'm not going to lie, watching him boom with this sort of stuff makes me feel better.
As a recap of yesterday.
I invited him. He's more than welcome to
join.
Jury
selection in Kyle Rittenhouse's case. Oh my! They did finish jury selection in Kyle Rittenhouse's case. The jury is paneled and they are ready to go. Today will actually be the opening statements for the prosecution and the defense, and we'll see how far we get with that. But to
answer that question, we're going to get about 4 hours into the stream. Going forward, I wanted to get the jury selection out of the way because I know a lot of people found that boring. But going forward, so that I have time to get sleep and do work and live the rest of my life and all that sort of crap, I'll be doing roughly 4 hours a day of the video. But so we'll get roughly about halfway through this.
Well, that will set us up for this trial. These opening statements will be how we discern the sort of framing that each party is bringing to the case, how they are going to set the tone. They will be setting the outline of their case, and we'll get the basics of their argument, what they plan to show as evidence as this trial progresses. And so that will help us discern kind of the posture. My initial impressions of this case are that Kyle has the stronger case here. Kyle has a pretty strong self-defense claim. There are not a lot of holes in the self-defense claim. Kyle is also charged with 2 criminal acts that they might actually be able to stick on him. And they are both small criminal acts. But as a refresher, Kyle is charged with carrying a gun illegally as a minor. So it's actually minor in possession of a dangerous weapon, or possession of a dangerous weapon by someone under the age of 18. Now, I believe there are certain legal exceptions built into that law, written into the statute, that should disqualify him from being convicted of it. However, the judge has not at the present time chosen to dismiss that charge. Though I fully believe it should be dismissed, I'm not sure if it will be dismissed. And if the judge does not dismiss that charge, it is very possible that Kyle Rittenhouse will be found guilty of that charge. Because if it goes to jury, the basic jury instructions is Kyle Rittenhouse under 18 at the time that he's carrying the gun, which the answer is yes. And then, is he carrying what qualifies as a dangerous weapon under the statute? And the answer there would be yes. A firearm of any type is considered a dangerous weapon under the statute. The reason I don't think it legally applies at the end of the day is because the statute itself has an exception built in for long-barreled rifles and long-barreled shotguns, which long barrel just means not short barrel, which means standard issue barrels. And all evidence indicates that Kyle's carrying a standard AR-15 style weapon. And so if that is the case, then he should fall under this exception, which would then change the reading of the law a little bit. But the jury instructions remain the same. So if the case is not dismissed as a matter of law, it will go to jury with the basic jury instructions of, is this a dangerous weapon? Is he under 18? Both of those are yes. And then he would presumably be guilty. Now, the other thing that he would likely be found guilty of if it goes to jury would be the fact that he was in violation of the city's curfew order. These are both misdemeanors. The curfew violation may even be a petty misdemeanor, which would be just a small fine. The other charge might carry with it the potential for jail time, but as I believe Kyle's a first-time offender, he probably would not get jail time from that. That just seems a little bit harsh. He would probably get probation. It would also not preclude him from owning guns in the future. It's not a violent gun crime, and it is not a felony. So that being said, the other charges, I do believe he can have fully justified self-defense claims. Now, I think there is also the possibility that a jury would nullify all of this or would nullify those 2 charges as part of the overall self-defense claim. Remember, the jury has a lot of power to make Kyle not guilty of any of these issues. And all Kyle needs is one juror who says not guilty to the charges means Kyle Rittenhouse wins effectively. As he would, that would then be a mistrial, and he would probably not be charged again. Zypher Warrior says curfew can be argued against since they never sought to apply it to anyone else. Not effectively. Selective enforcement and selective prosecution are fully allowed under the law.
Very happy.
You do not have to charge anyone
given
else
that we now have over 50 people here, I'm going to stay awake.
Who is,
so excuse me, I'm going to grab some
guilty
caffeine,
of the, or who has probable cause to be guilty of the crime. You're not required to charge anybody else to charge one person. If 50 people are speeding, police officer only has to charge one person ever. They don't even have to charge that one person. So that is not an effective defense. All right. There are also super chats available for interacting with the show, and I will try and tackle those as we go today. we'll see how that happens. Oh, and finally, I will be on Adam Krigler's show right after this. That'll be around 5:30 p.m. Central Time. I'll be joining Adam Krigler to give a recap of what's going on in the case over there. Because I'm a moron and will be choosing to go on yet another show after streaming for approximately 8 to 9 hours on my own. Next, Viden the Cold One says, been in the hospital almost a week. I'm tired too. Oh, okay. Sure. Upstage me and my sleep schedule with your hospital thing. Got it. Okay. NGE fan says, how trashed are you and Uncivil gonna get? I don't want to get trashed at all. It's the daytime. So hopefully not. Hopefully zero. Angry Baneling says, so the judge came back yesterday after all. Yes, he did. They stayed and finished somewhere around between 7 and 8 p.m., I believe. Very, very long court.
I'm sitting here regretting my life choices.
Yesterday, at the end where we had stopped watching,
it's all for the entertainment
they
value,
actually
people.
went and did private hearings with some of the jurors. The jurors could voice their reasons that they maybe wouldn't be able to be qualified as a juror privately to the judge. If they had some,
up in terms of speed,
some embarrassing family issue or
terrible. And I'll turn it back down once we get to the actual trial and commentary. Oh, come on.
Actually went and did private hearings with some of the jurors. The jurors could voice their reasons that they maybe wouldn't be able to be qualified as a juror privately to the judge. If they had some embarrassing family issue, or if they had some really private medical issue they didn't want to talk about, they could go ahead and do that. And that they did come back after that. It wasn't really clear at the time that they would. C Goody 564 says the only holes in the self-defense case are the holes in the ones that got self-defensed. But yes, Kyle the Perforator. Kevin Dorr says Barnes talked about how critical in these types of cases jury selection is. Are you worried about the jury being seated in one day? I don't know. I don't know who they seated. We're not really able to tell who was there. I was not in the courtroom taking notes on the jurors and keeping track of their answers. So it's hard to say. And ultimately, I don't know who got seated at the end. Plus, the lawyers in the case would have been privy to those private discussions about why jurors would maybe not be qualified to participate. So we just have to hope that the jury selection was done effectively by Kyle's lawyers. I know there's a lot of controversy surrounding Robert Barnes' removal from the case or whatever. However it's framed, I don't, that is a side discussion that is no longer relevant to Kyle's case. Right now we'll be left with the speculation of what could this have changed? We don't know because we don't know the outcome yet. So let's see. Bill Bonius Bag of Donuts. Welcome to the membership status. Very, very happy to have you here. Ibney00 says, I'm a mock trial competition. Your coverage of Dr. Black really helped me format my questions for our expert on witness perception. Thank you. Oh, hey, cool. Glad to be of assistance. Hopefully you just said, whatever that guy said, I'm going to do the opposite. Scrape says, hit a deer on the way to work this morning. Wish Kyle would have gotten it first. Padria says, how long do murder trials normally take? Depends on the murder. I would expect this one to wrap up in the middle to the end of next week. They have given 2 weeks of time. They've given 2 weeks of time as an estimate. The judge was hoping that was conservatively estimated on the long side. So we will see. Let's see. Waiting for the stream to start here. But yeah, the estimates in this one is 2 weeks. Those times are based on witness lists typically. How many witnesses do we have to get through? That's the question. Okay, I'm going to switch feeds from Court TV over to Law and Crime because it's actually there. All right, here we go. Oh, hey, my man.
How you doing, man?
My headphones on so I can hear
I
you.
want to switch over.
Excellent.
Welcome to the party, pal.
Fair enough. So they actually managed to see
hang on. Oh, Natalie is in the chat. Thank you for joining us, Natalie. For the record, jury selection trader limited the questions we wanted to ask in Overlaw'd by about 65%. Holy crap. Okay. Well, so chat, for anyone that doesn't know, that means that oh, wow, okay. So you were significantly limited in what you could and couldn't ask the jurors in order to weed them out. Don't like that. All right, okay.
the jury yesterday. I'm kind of impressed that they were able to do it in a day.
The judge said to the media they were going to do it in a day, so he was like, "I'm going to make it happen."
I guess, but still.
Let me welcome to the stream. Uncivil Law. How's it going, man?
I'm doing fine, thank you. I just built a new computer. We had a 4-hour live stream of my struggles in torturous ways, but yeah, just built a brand new PC. So I'm very excited about that. It's running. I'm talking to you from it, so that's nice.
That's good news. Did you do it like I did, where you were drinking whiskey and pouring the whiskey into the glass over the open motherboard?
No, I had enough. I had enough issues with it to do it. So I was reusing the old case, and it took me like 3.5 hours. And there were many technical issues involved. The worst of which was one of my hard drives, one of my SATA hard drives. The data plug in the hard drive itself snapped off.
Oh,
so the pins are still there, but the little plastic thing that holds the thing in place is gone. So it's now being held in place with pressure and zip ties, and it's working, sort of. So, yay.
You should get that fixed.
I'm working on it.
I'm assuming you did that.
Okay. Let me read these last two super chats that have come in real quick, and then we're just waiting on coverage to begin here. 200 Watt Studio says, Nick, been on the SCOTUS website looking for oral argument audios from before 2009. Site only goes back to 2010. Any help where I should check for those? I don't know that they have them anywhere. Do you know of anywhere?
Oh, I take it the ice cream killer case is not going well
either. For oral arguments of SCOTUS?
Oyez.com or oyez.org, oyez.org.
Oh, okay. Yeah, they I didn't realize they kept the oral audio or the oral argument audio there.
Yeah, I think they have all of it. So since they started recording, I think they have all of it.
Well, there you go.
And what's really nice about OYEZ is that, at least for the modern cases, I don't know for all cases, but for the modern cases, they have the transcript and they sync it up with the audio, which is really, really nice.
Perfect. Oh yeah, we've done that commentary, and that's awesome. Okay. Yeah, because it like highlights the lines as you're going.
Yeah, people are talking about the SATA cable. They don't understand the issue. The problem isn't the SATA cable. The problem is the.
It's like some things never change. It's like I was watching. Thank you, Vince, for the coffee fund. Dub Bears. Some things never change. Nick last night on Locals was talking about how he won't tell anyone what his technical issues are because everyone floods the chat with ideas and theories as to what it was what's wrong or whatever. It's happening to Kurt here too. It's hilarious. Worth watching back? No, nothing on that case. No clue. I didn't pay any attention to it, so I mean, it may be worth going back. Not a clue. Tweety, good to see you. Petty B Photography, behind on everything. Well, look, you don't necessarily have to go back and watch day one. Let's face it, it was jury selection. I watched that purely for my own enjoyment, really, and some people enjoyed it, some people found it boring. But at least today we're getting into the opening statement, so this should be good. Got to turn it off and on again. Another shit show trial in Florida. I'm shocked. All right.
Drive itself. The SATA cable has nowhere to clip into because the little plastic bracket on the hard drive has snapped off. The problem isn't the cable. The problem is the drive.
You're making a
$3 or $5 SATA cable. I have SATA cables. It does not solve my problem.
You're making a critical error right now. You're accepting tech recommendations from the chat.
There you go.
Yeah.
Never do it. Never do it. They're always terrible. They're the worst. The chat is not helpful on tech issues ever. That's a rule.
I adore chat. I love chat.
But for those of you interested, I got an AMD Ryzen 9 3900X. I have 2x32 gig of memory on an MSI Tomahawk Max board. And I just got an M.2 drive, which is the 980 Samsung which I'm still at this moment still running from my SSD. I've got the operating system installed on the M.2, so I'm switching between switching between drives as I'm migrating. But yeah, that's the setup. So it should help a lot with.
Ooh, Natalie, if you're still listening, we've got a super chat specifically for you. If Natalie's still here, how was it when you got the not guilty? You were right there for Kyle. It must have been something, mainly emotion, and thanks for staying, Aussie, you rock. Yeah, for anyone that wasn't watching earlier, guys, there were like 18 people at the start, and I was like, if I don't crack 50 in the first hour, I'm going to be sleeping on stream. Needs water cooling, throw it in the bath. Yeah, well.
With the rendering time.
Yes, that's a big one. Did you get a graphics card? Do you have
I'm reusing the same graphics card. So I have the 1070 Ti FTW edition. So I'm still using that same graphics card. I'd like one with RTX, but finding new video cards is hard. And the one I have is sufficient for my needs at the moment.
Yeah, it's a mess trying to get anything new. Frega Boom says, looking good, pal. Hey, what's up, man? How you doing? Oh my gosh, I owe that guy pictures of me in Fear.
Hey,
damn, sorry.
How you doing?
I was gonna do them, and then I got COVID, and then I forgot. Dapper Wolf says Nick chug whiskey. No, no thanks. BG Willie at 21207 says Army Sarge present.
Guys, you're all very welcome. It's just
sound reveal.
It's very tiring doing this.
CJ says, have uncivil, wash it in warm, soapy water. Oh, yeah, that's how you fix your hard drive issue. You just wash it with warm, soapy water. It's perfect.
It doesn't seem like that would be productive to my mind.
Look, the chat is the worst tech support by default. Because they can't see the issue, and then you'll get 500 suggestions on how to fix it. All of them are terrible. And then you do something that is similar to one of the suggestions. Like someone's like, see, I told you, idiot.
Yeah. What the chat may not know or may have forgotten is that I actually do have a computer science degree. It's my undergrad is computer science. So
shit.
There you go.
There's that.
See, chat. You're terribly wrong.
You're
terribly wrong.
Yeah. Farm cocaine. Yeah, that means you have to have access to.
Wasn't your undergrad in writing or something like that?
Literature and creative writing. Thank you.
There you go.
I didn't actually tag you in the video.
That's very rude.
But I am tagging you. I'm changing it right now. I didn't mean to not tag you. It's because I started it on StreamYard and then didn't edit it in.
Also, got another 3 minutes. We can sit through another 3 minutes.
President-elect Austin M says Binger is either masking his power level or he's king clown at the circus. Hopefully, there's no more whamming moments. Pray for Bruce and his cough too. Pablo Castaneda says, stop insulting chat tech skills. We're the best.
That's more or less
also
the
uncivil.
plan,
Have you tried to turn it off?
I'm going back and watching this from start
several
to finish
times.
the way that I would watch anything else.
Yeah, and also one of the reasons I broke the
HDMI
HDMI connector on my camera, so now I'm running it off micro USB. So that was the thing too this morning.
Oh, good. You're breaking ports and connectors all over the place.
Yes, apparently.
All right, so give me a rundown of the case so far. What have you seen? What do you think? Where are you on this issue?
So I share your continuing confusion on the gun possession charge because the way you've read the law seems right to me.
Awesome.
I would consider myself open-minded on the issue though, because I'm willing to hear a good counter argument, and I really haven't heard one. So I think you're right, but I'm maybe not as sold as you on it ultimately, because it's like maybe there's an argument somewhere I haven't thought of, but none of them so far have made any sense. As to the underlying issues though, I think the self-defense claim is pretty rock solid. As you pointed out yesterday, the issue is subjective and objective. So we asked two questions. Did Kyle Rittenhouse experience a fear of death or grievous bodily harm? Probably. Yeah, sure. I mean, he just, in the first shooting, a gun had just gone off and he's being chased. Pretty good. And would a reasonable person in that position...
Nick said yesterday that he was either going to go back and redo his own over the thing because it was a good idea, or he was going to sit and watch my stream and comment on my stream of watching him and commenting on him. And eventually it's just going to be, we're not going to be covering any new trials. It's just going to be people rewatching over rewatching over rewatching.
Position feel the same thing. It's like, yes, probably. Yeah. So the self-defense claims look pretty solid to me. Again, waiting to hear any sort of counter argument. Because we only have the videos, but so maybe some eyewitness will testify to something that we somehow haven't come to our attention. That would be nice to understand the prosecution's case better. But so far, I think Kyle Rittenhouse is in the clear. Given what we presently know, a judgment of guilty would, in my opinion, not be legally sustainable.
Thank
you. It is not legally viable. A reasonable jury, based on what we know, cannot come to the conclusion.
Appreciated. It really is. And guys, everything that is said comes through.
I agree with that. Sort of thing. No, I got no reason to change your mind. I actually wanted your opinion on a different issue related to what you just said. So let's say we do get a jury who makes that decision.
Sure.
Do you think, from what you've seen from Bruce Schrader, the Honorable Bruce Schrader so far, that he would be open to a JNOV.
You know, I can't really say. I would say as a general proposition, I think many judges are very reluctant to a JNOV. So if you had to predict, you'd predict against.
Yeah, I think that's safe. He just seems there is no audio yet.
He's got a MRS.
It's not just you guys that it's muted for. It's muted for me too. Yeah. Okay. So JNOV is a judgment notwithstanding the verdict. It's a way that the judge can basically say, okay, the jury said this. However, like, come on.
So the chat's saying it's 11 women. Is that the right demographics? Do you know?
I have no idea.
I've got to see whether or not the
we can look that up somewhere.
Lauren Cut Cage fits over this, or if I'm going to have to edit it. Give me a second, guys.
Jury, Kyle Rittenhouse.
It's certainly possible.
Yeah, I mean anything's possible. Let's see. Seated. Let's see. And they selected 20 people, which I don't quite understand. Oh, okay. So the 20 consists of 11 women and 9 men. So, yeah. We don't know. Are all 9? Yeah, it doesn't say which are alternates and which are not. So it isn't that specific.
Set forth what
okay,
is to
can you hear them
how
now?
the court is
I can.
when there is an alleged exception, which we are alleging here.
Okay.
And I think that exception has to be put into and part of the instruction. And as it reads now, I don't think there is an exception. So I think that has to be included in the instruction if the court does not grant our motion for reconsideration.
Not what I meant to do.
Okay, this is on the gun issue
is that
as a minor.
I have not been able to complete what I wanted to do on your motion for reconsideration. I didn't get it until later last week.
Mm-hmm.
Didn't mean you didn't file it. I mean, I didn't get it. And I didn't have a chance to look at it somewhat, but not all of it. And there's one other thing I would definitely want to check, and some other maybe. So I'm not in a position to give you a final ruling on that. I think I should instruct on it. But what you're asking for is actually exceptional language, which the instruction is not going to be frozen at the time that it's given this morning. So I think in order to acquaint the jurors with that particular case, well, I don't know, maybe I just should leave that one alone because I'm leaving the ordinance violation of the forfeiture action alone. And I can just tell them on something on everything at the end of the case. How do you feel about that?
Judge, I feel as though we got a little bit lost in the weeds here. What the defense is alleging is an affirmative defense. If they want to raise that as an affirmative defense, they're welcome to do so. It's not subject for a motion to dismiss. The complaint need not deflect or address every single affirmative defense. And so I believe there's no basis to challenge the complaint to actually.
But even if it's an affirmative defense, doesn't the state have to prove it?
They wish.
Yes.
Mm-hmm.
And if it's a matter of law,
yeah,
there's no issue of material fact in question here.
But I do like that the judge seems to be keeping an open mind on this issue. He didn't just slam him down.
The certificate of completion that the
this man
second
is
part
not good
of
at wearing
that
suits.
third part of that section calls for, they can do so.
What's going on with his neck line?
Why that should be in the jury instruction. We don't have self-defense in the jury instruction because that's another affirmative defense, and they should raise that. And if they raise that, which they certainly.
What do you mean you don't have self-defense in the jury instruction?
Be in the charges at the end, or in the jury instructions at the end. So no, I don't believe that at this point there's any basis to dismiss it. I do have a brief that I could submit. I did not
and
want
it's
to.
barely for educational purposes. Let's face it.
Why we believe it's an affirmative defense and not subject for a motion to dismiss. In terms of,
I think you submitted that brief.
Curfew violation. We're wondering how we're going to do that because that would be a 6-person jury, not a 12-person jury.
I don't think anything's precluding you from having a 12-person jury.
Sever
is
it. No, sever it. That'd be funny.
Proof.
Sever it.
Anyway, I can submit this brief and send it to the defense if the court would find it helpful, but it's an affirmative defense. I mean, it's clearly what it is. I understand the defense may not want this to be addressed at trial and may not want the evidence in front of the jury, but we've met our probable cause. We've met our.
That's a hell of a combo too.
And
let's not forget that. That is a hell of a combo.
Also, just
defensive.
I don't like his posture, and I don't.
I disagree that being 17.
And also, what's with the sitting? I don't. While talking to the court, that's weird, isn't it?
Present the certificate of completion.
He's sitting very strange.
Under safety permit as called for in statute. Thank you.
Okay. Yeah, I think what I'm going to do is refrain from giving any instruction on either count 6 or count 7, and tell the jury that I'm not going to give them an instruction at this time on those.
Yeah, I'm not sure why you would give any jury instructions at the start necessarily.
Well, I don't know if that's probably not the
Well,
best.
you're not gonna
Other than
try and
the
colour
standard
the
instructions
jury
of
like that.
you can't talk about the case,
Um,
that kind of stuff. But why you would give
well,
legal instructions as to
what's your
law
reaction to the claim that it's an affirmative defense?
seems
Not an affirmative defense.
Yes.
For 16 and 17-year-olds, it's not an affirmative defense. The information that I've provided to the court
That's part of the
Affirmative
that's
defense
part of the
through
charm of this.
legislative
Miami
history
school.
makes it clear it's an exception. It's not an affirmative defense.
It's in the
It
statute.
is an affirmative defense for people under the age of 16. I'd agree with that 100%. But if you look at the Senate Bill 7 and the 1991 Act, in
All right,
three
question, guys.
different
Do
places,
you feel
it
that I need
tells
to
you
slow this down
in
now because this
plain
guy's talking
language
really
that
fast?
it does not apply. Not for hunting purposes. It does not apply, period, to 16 and 17-year-olds.
on just a purely presentational basis. Kyle's lawyer is much better.
That
He's
is-
looking at the
and I
court. He's not
provided
hunched
that to the
over.
court, both in
I mean,
Yeah, fuck it. I'm
the
I'm
Act
selling it
and
now.
in the Senate Bill, Judge,
Hang on.
and in the Legislative Reference Bureau information.
Well,
So-
It's insane
I'm
to
going
suggest
to-
that an
instruction
exception written into the
stated it.
statute is an affirmative defense.
These are
If it was an affirmative
these
defense
are
written into the statute, it would
educational.
say
They don't
it
get
is an
over-
affirmative
and
defense
they're-
to this crime.
just so they know what we're talking
Yeah.
about when we talk about these charges. And at the close of the case, I can add whatever language is necessary, if assuming that the motion is denied, which you shouldn't assume, but if the motion is denied, then I'll add the language. That,
Unfortunately, it does mean that we've got Bruce
clears
at a
what-
regular
clears
speed,
up
but
what exactly the full scope of the charge is, but I don't think
if Kyle's lawyer is going to be talking that fast,
Facts,
and
the
Nick's going to be
defense is
talking that
Harris.
fast,
Nice.
I don't want to leave them uninstructed on the
attention.
one hand, and I don't want to misinstruct them on the other, but no matter what it is exceptional from the general language of the statute.
No, it's
Voted. I
it's
just-
in
it
the
makes it a
language of the
strict liability
statute.
offense today. If you're under 18 and you have a gun, you're guilty. And I don't think that's what the law is. So that's the problem that I have. The statute clearly lays out exceptions for that. And to just say he's under 18 and he had a gun, those are not in dispute, then he is, the way the instruction reads, there is no affirmative defense, whether it is or not, there is no
No,
defense.
unless he has the.
No.
That's the last part of the statute. In
Yes.
Wisconsin, if you're under 16, you need to be accompanied
Wow,
by
so
an
this
adult
early on, and there was
hunt,
already
as long
fuckery.
as you have hunter safety. If you're 16 and 17,
That's how you read it.
That's not how we
That's how
read
we
it.
read it.
Ooh, nice little burn there.
that's how they cite it.
On you,
Yeah,
Bruce.
okay.
So in
all right.
16 and 17-year-olds, you can hunt alone with a hunter safety permit, which is what the last part of that statute calls for.
It's not
And
what the
that's
statute
completely
says.
ignored.
Not at all.
In Mr.
If
Troff's
you didn't catch
argument.
the stream yesterday, you
Okay,
didn't see me putting together a
um,
model as well.
I am going to
Grant the motion to dismiss. That'd be funnier.
give some very incomplete language to acquaint them with the fact that there's a charge on the information respecting the possession of a firearm, and that I will instruct them concerning the elements of that offense at a later point. Okay, and the same thing will happen with respect to the forfeiture action. So, any other objections or problems with the proposed instructions?
Judge,
Yeah.
I didn't see on count 5 that you, on 1, 2, 3, and 4, you put an except, or you give the self-defense instruction in some level. I didn't see that for count 5, however.
Didn't I have a general instruction on self-defense?
You listed them specifically for the charges or for the counts.
Did?
That's what I saw.
Boy, it was early this morning. It says.
Judge is writing Jerry instructions this
Counts
morning.
1 through 5. No, that's not it. You're right.
Nice. And I like the way he did it, just very respectfully, where he said, I did. He said, that's the way I read it. Instead of saying yes, there's something more demanding.
Yeah.
That was smart.
Self-instruction as, same self-defense instruction as count.
Also, nice spot by the defense lawyer, to
Doing their job, at least.
Doing their job.
That's good news.
we'll give credit.
1, 3, and 4.
Very good. I just wanted to make
Yeah,
sure that.
you were correct in your observation.
Well, you tell me when you're ready, Judge.
I think he's cutting and pasting as we speak.
Yep.
Okay, what else?
One last issue, and that's the court has included, as it relates to, I think it's count 3, Mr. McGinnis. Count two. I'm sorry. Yeah, 820. Jury instruction 820 is mentioned in there. So I guess the language in there that I'm having, maybe it's just me, difficulty kind of coming to some type of congruence with is the first full paragraph. The last sentence says the defendant does not have a privilege of self-defense as to Richie McGinnis. I don't know if you see that. However, later on in the instruction, it says if the defendant was acting in lawful self-defense, his conduct does not create an unreasonable risk to another. So I guess the concern I have is one portion says he doesn't have a privilege of self-defense. Then another portion of that same instruction says he does have the privilege.
I stumbled over the same language. And what I ultimately decided was intended, and I think I might add correctly, intended by the instructions committee was that he does not have a privilege of self-defense as to the third person, but the fact that he was, if he was, in exercise of his privilege of self-defense is a factor for the.
Why doesn't he have a privilege of self-defense?
Because it's reckless endangerment.
Was criminally reckless. And also was a factor for them to consider in determining whether it was done with utter disregard for human life.
But the problem is the self-defense would flow because intent follows the bullet, right?
Should.
So therefore, the privilege of self-defense should flow.
We put a law school test together on this,
Yeah, but the jury instruction suggests that you don't have the privilege of self-defense in a reckless endangerment shooting.
I think if he's in self-defense as it relates to Mr. Rosenbaum,
generally,
according
I guess strictly speaking, that must be true because if it's reckless, strictly speaking, it's not intentional. So you can't be, you can't have a reckless self-defense. So I guess that must strictly speaking be correct.
Create an unreasonable risk to another.
Although that's confusing as shit.
Let's give a situation where
happy
out on the street and somebody confronts me and there's a family of 4 little children right behind him and the other person, the other actor puts me in, I'm in fear of death from the assault by this individual. So I whip out a gun and I open fire, and I include in the zone. The danger zone is not only the actor with whom I have a perfect self-defense, privilege of self-defense, but also the 4 children who are behind him.
No, this is a bad read on this.
I think this is how I reconciled that reading in my mind was that when the jury decides about the charges involving the 4 children, the jury is to consider.
Hello, Antron. Just for anyone that's just coming in, I'm live. They're not, but I'll say hi on their behalf.
Whether I was acting in self-defense with respect to the bad actor,
right? For the
that's consideration in determining whether my conduct was reckless.
Yeah, well, I'm going to be applying stickers,
with respect
like
to
metal
those children,
stickers, so I'm going to have to concentrate. But
and also whether it was showed utter disregard for human life, and the jury might reconcile that by saying, "Well, you should have tried to change positions so that your shot would have the children in the background."
That is an insane read.
I agree. That's an insane read of self-defense.
Tweety, if you look at the label,
say that if the bad actor in your situation, if you were acting in self-defense, the instruction says that you did not then create an unreasonable risk to another. It's what it says.
I don't even understand. That doesn't make sense.
Then.
Well, why did they? I'm sorry. Go ahead.
No, so I guess what I'm saying is I don't think if it's self-defense on the bad actor in your scenario, then by that fact, according to 820, the instruction says your conduct did not create an unreasonable risk to another. So if we're talking about the children behind that bad actor, the statute says, or the instruction says, then if it's self-defense, it did not create an unreasonable risk. And then period.
Right.
So
Correct.
Why does it say up above that the, in the second sentence, the fact that the law may allow the defendant to use force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful.
I agree. That's what I said.
What you're telling me is that the fact that the law may allow the defendant, the fact that the law may allow Schrader to use force in self-defense as to the bad actor does not necessarily mean that recklessly endangering the safety of the children was lawful. Why isn't you're telling?
It does
me
necessarily mean, as I, yeah, that's what he's saying. It does necessarily mean that.
The children. Only if, according to 820, only if the conduct against the bad actor was self-defense.
Yeah, right.
That's the part I've read to the court. If the defendant was acting in lawful self-defense, his or her conduct did not create an unreasonable risk to another.
Yeah, of
Correct.
course it can.
Period.
Right. He's right.
Are you freaking kidding me?
This is like pretty basic self-defense theory too, which is confusing me. When the judge finally gets stopped talking, we'll talk about this more because it's weird.
Yeah. Well, we can briefly address what they're trying to reconcile is this conflicting jury instruction that says you cannot have self-defense in a reckless endangerment charge. You don't have the privilege of it, which I think if the charge is standing alone, that makes sense.
Right.
Because if they're recklessly endangered, you're not acting in self-defense, because if you're acting in self-defense, your actions aren't reckless.
Yes, right.
In the scenario where you are acting in self-defense, firing a bullet at someone who's an aggressor, the people around them could in theory be endangered, and the self-defense should flow into that reckless endangerment, because again, you're not recklessly endangering person B because you're lawfully shooting person A.
Right.
That doesn't make a lot of sense if you're justified in shooting one person.
I'm a little bit surprised he didn't actually use the phrase "intent follows the bullet" as part of his argument, because this is intent follows the bullet.
Right.
I have murderous intent with respect to person A. I shoot at person A. I actually hit person B. Person B dies. I'm guilty of murder. Self-intent follows the bullet.
Right.
But it works the other way around. I have a valid self-defense claim.
Instructions committee. And on page, well, I don't know if you've got the pages there, but well, I haven't, but near the end it says
It's 4:45 in the morning.
Yeah. So self-defense works the same way. I have self-defense with
for
respect
example,
to person
assume
A.
that the defendant is charged with causing reckless injury to the victim and raises the defense that he was acting in self-defense against someone else and thereby injured the victim. Criminal recklessness requires that the defendant's conduct created, quote, an unreasonable and substantial risk of death or great bodily harm, unquote. In considering whether the risk was unreasonable, the jury should consider the evidence that the defendant was acting in self-defense. So that's what I'm thinking is that what they mean is there is not what you're arguing, I think, becomes a perfect self-defense as to injury to others.
Right.
During
Correct.
the exercise of perfect self-defense. I
Correct.
don't think that's the law.
I think it is.
Maybe it was what we once thought, but I don't think it's the law now. And that the jury, when they approach the McGinnis case, looks at whether
The law changed somewhere along the way.
and
Just so the
if-
chat
even
knows,
if exercising
jury is not in the courtroom
perfect
right now.
self-defense with respect to Mr. Rosenbaum, that he doesn't have a self-defense as to Mr. McGinnis's endangerment, But instead, the jury is told you consider, because, and I'm interrupting myself, because one of the things we tell the jury, and you've referred to it several times right here in our discussions in the last couple of weeks, one of the things the jury considers is what the defendant was doing, why he was doing it, how dangerous was the conduct. When they weigh those things with respect to the account involving Mr. McGinnis, they consider, if they decide that it was perfect defense, self-defense as to Mr. Rosenbaum, then they consider that in deciding what the defendant was doing, why he was doing it, how dangerous was the conduct, and then they make their determination whether the fact that Mr. Rittenhouse was,
Nate the lawyer has it right.
if they find that he was acting in self-defense, they can weigh that in deciding whether or not he recklessly endangered the safety of Mr. McGinnis. That's how I read it.
It's a confusing jury instruction. To
It's
say
a very
you-
confusing jury instruction.
You don't get
Now,
self-defense,
but
but
I am
if you
going
get
to-
if you
I'm
did
gonna
self-defense,
try
to-
then the
Yeah,
jury
yeah, yeah.
considers
Put around
self-defense.
those
Yeah.
fifth and seventh counts because we don't have an instruction for number 7 and
I'm also going to pick apart the judge's
Yeah,
hypothetical when I have a chance.
number 6 is. I've had lots of statutory issues come up over the years, and this is the naughtiest.
Is it though?
Okay. Other than that, any problem with the instructions?
Nothing, nothing else from me.
Istari, we'll
State?
try and
No.
clear it up in a second.
Okay. Let's get the jury down.
Okay, you want to
Okay.
quickly?
Go ahead.
No, I was going to say you want to hit that hypo.
Yeah, so I wanted to complete my previous thought since I kept getting interrupted by the judge.
Yeah, I guess.
If you have self-defense against person A
At the end
and you
of
fire person A and hit
last
person
night,
B, it's still self-defense because intent follows the bullet. So intent follows the bullet works both ways. So now let's pick apart the judge's hypothetical.
and whatnot.
In the judge's hypothetical, the way he described.
No, I'm not playing Candy Crush off to the side. I was stupid enough to let something fly away. And yes, I am paying attention, Stephanie. I'm just looking for a very, very tiny piece of something that's missing that I'm going to be very, very frustrated if it's actually disappeared.
Is there is a person who is in fact posing an imminent threat of death or grievous bodily harm to me, right? But also there are 4 children behind him, or family that has 4 children, or whatever, right? So that's the premise. And he says, okay, so I have a right of self-defense against this guy.
Hey,
I have a perfect right of self-defense against this guy.
each other,
Fine,
and I think
but I might also simultaneously be reckless to the 4 children.
slightly
Then he goes on, why? Well, maybe I should have moved
Mr.
and
Smith
fought
has
and shot from a different position.
that,
But wait a second.
at a previous employment where
I have an imminent threat of death or grievous bodily harm. Where do I get the time to move to a different position from?
prior
The entire premise of I have an ongoing or imminent threat, but also I should move to a different position. Where's the time?
Any question or observation?
Yeah,
It's-
it's a weird one. What just happened was the audio video guy
would have any
last
impact on her.
night or this
ability to
morning
serve.
passed by a
I don't-
juror. So
You could ask
Binger
if
is
you could ask
informing the
me
court
to
of this.
ask her if you want me to, but I'll probably tell you no. Well, might as well be honest. It doesn't sound like anything, unless you have question about the accuracy of the report to me. I think it's a non-issue.
What, they just happen to walk by each other on the street or something?
No, when he was coming in to set up the
Ready to go
camera and audio
But-
equipment
Okay, anything else? And
uh,
I did get a note,
in the courtroom.
you know, from whom?
I
this
guess it
came?
must have been yesterday, last night.
Well, I don't know which
And what
one.
did they do? Say good morning or something like that, and we're having a fight over it?
Did you see them put a turn number on there?
I think the
Yeah,
risk
yeah.
is
And
that
then I like what Batman says too. Yeah, maybe I should have moved. Also because, well, we were establishing it from the judge's hypothetical. Like in this hypothetical where I'm on the street, it doesn't make sense. It makes even less sense for Kyle Rittenhouse because, as you point out, he was on the street. It's like, oh, I should have fired from a different position as I was, on my back.
There's another subtle aspect of what happened. The judge read the comment, and it's probably from the same statute, but the comment was over a reckless injury.
Thank you, Robert.
Not reckless endangerment. So in his hypothetical that encompassed the comment from the jury instructions guide, it's talking about recklessly injuring one of the children, which would change the calculus from, well, he shot and put one bullet in the aggressor and the children were endangered because a bullet came their way, versus he shot and struck one of the children. So let's say hypothetically, you use your self-defense claim by firing an automatic burst, right? Burst fire from an automatic weapon, and you fire off 6 or 7 rounds.
Suppress the sound while I hold it down, or does it click on and off?
What? We're confused about microphones now?
And then if I put, and now I'm live again, right? Okay, I've got the nice hand signals here from the respectful hand signals from the Court TV crowd.
I got some hand signals. No, that's a bit unfair. That's a bit unfair.
So that,
but I do love what Nate was saying earlier, where he's screaming into the void in caps. Go back to read it, or see if I can find it where I can quote him. But he says, from several points ago, he says, "Perfect self-defense cannot be reckless. That's a legal impossibility. If it was reckless, it's not perfect," and all caps, self-defense because he was reckless. Yes, Nate, we're with you, and I'm enjoying watching you scream into the void as you try to reconcile the word perfect with the word reckless, and like me, have basically your brain stops working because it's a mutual conflict. It's one of those things where you tell the robot, "I am lying. I must be believed, and I am lying." The robot blows up because it can't deal with a logical paradox. Yeah, perfect and reckless have a problem in the same sentence. You are correct, sir. Perfect recklessness. Yes, exactly. That's where we're at. Perfect recklessness, or reckless perfection, or something.
Yeah, that's the interesting thing is Kyle's claim is one of relatively perfect self-defense. No bystanders were struck. The closest that we have is McInnes suggesting he was briefly afraid that he thought he had been hit by a bullet. And we don't know if that was like a piece of concrete or something hitting his leg, or if it was just psychosomatic reaction to hearing gunshots at close proximity. Who knows? He thought he had been struck, but he was not struck in any way. He was not injured. So I'm not sure how we get to the judge's hypothetical.
Okay, well, I guess too, but
it is a very concerning or confusing jury instruction to say you don't get self-defense, but if you did self-defense, then the jury can consider it. I think it's covering the idea that you're like, someone in the chat says, or good logic in the chat says, you can't self-defense with a nuclear missile, right? So, okay, yeah. So if you have a howitzer or something and you self-defense someone and it blows through them and into the next county, I guess you're recklessly endangering the people behind the target.
I haven't really considered the self-defense implications of the perfect self-defense, but with a howitzer. So yeah, I haven't. You might have a point there somewhere, but let's, I don't know. I don't know how perfect self-defense works with a howitzer.
I have no idea. This is the issue, and this is why arguing over these jury instructions is really important and getting clarity to the jury, because we're confused by this. We're lawyers. The judge is confused by this. He's not only a lawyer, but a judge.
The fact the judge is confused, or the fact that the judge seems to implicitly acknowledge the wording is difficult to parse, because he just called it like the naughtiest legal issue he's had, and he's going to give this to a jury.
Yeah.
With these instructions.
It bothers me that Binger is by far the tallest Gaige Chad in the room, because he's such an effete idiot. He's like a foot taller than everybody else in that frame.
Comments about self-defense in a tank. I feel like self-defense in a tank doesn't apply unless the other person coming towards you has another tank. Because I feel like that having effectively a suit of armor around you that would ordinarily be impenetrable to, small arms fire or whatever. I don't know how big a bullet has to be to penetrate a tank. But I would think that if the person's coming towards you with a knife, it's probably excessive force. But that's my opinion.
Okay.
Oh,
Make a copy of both sides and then pick it back up, please. All right.
when are we going to bring this
Long
jury in,
enough for-
Judge?
Soon, please.
That to happen.
The jury's sitting back there like, what the hell's going on, right? We showed up like an hour and a half ago or something, probably. What time did they have to show up? Was it
You know
9
what?
or 8:30?
You
Who?
can give it to her when she
The
comes.
jury.
All right.
I have no idea. They should be at. They should be here.
Who are we
since
calling
9.
now?
He's calling the jury form or the bailiff or whatever to bring the jury in. I think,
Hello,
Would you come down, please?
you got it.
or the
Thank
jury
you.
foreman.
We need the door open. I don't know if somebody's standing over there or not.
Would you come down? I don't know if that means bring the jury with you. Okay.
Well, actually, I read the commentary, and the instruction guide says if the judge says, "Would you come down?" The jury is free to interpret that reasonably as singular or plural. They're not privileged to interpret it as plural, but under the circumstances, they can read it as plural.
Are you serious? Is this an instruction?
No, I'm making fun of the last instruction.
I was just confused for a second. Is this a real thing? Are you? Yeah.
If someone comes at you with a knife and then you jump in a tank and fire. I think once you've removed yourself from the
Here
imminent
we go.
danger,
Let
because a
me-
knife's not going to pierce a tank.
Let
So
me
I
hit a
no longer
couple,
think that self-defense applies in
super
that
chats here.
circumstance, honestly.
Padria says, just put it in rice and the magical Asians will come and fix it. Oh my God. He's talking about your tech issues. Silent Vash 27 says, wonder if we will have more crying jury members. Very possible, but we probably won't hear the jury ever again until they're rendering a verdict. Mean Sarton says, I've had cases where the alternate jurors aren't known until the end of the case. Maybe that's how he'll do it. Could be. Peter Bemis says, they said WOU is alternate and WOU is alternate will be determined post-closing argument. Oh, who is alternate will be determined post-closing
One to a chair,
argument.
please.
So they're going to bring in all
Always trying to
20.
sit on someone's
8
lap.
of them will be alternate, but they won't know. It'll be mystery round. So that's weird.
Now we say alternate, but unless I misunderstood, all the alternates will be dismissed once the jury goes back. So there are no alternates if someone has to be removed during deliberations, if I understood correctly.
Yeah, the alternates will be sitting in the jury room
Oh,
or
okay.
sitting in the courtroom, and then once the closing arguments are done, they'll inform the alternates who they are, I guess.
Each side.
And then apparently go home, which seems odd. It seems odd that you wouldn't keep some in reserve in case you need to substitute out a juror. It happens.
Gen X Medic says self-defense with a howitzer would depend on if it's high explosive rounds or a canister shot. Europa Chronicles says FFS Schrader has been chewing on the illegal gun issue for several weeks. If he still doesn't know if it applies, he needs to dismiss it. Well, he said that they
you can be
filed the
seated.
brief
Good morning,
for
everyone.
reconsideration, but he didn't see
and,
it for whatever reason. So
Scooter.
that's why he hasn't
then we
ruled
have
on
to
it
swear
yet.
the jury. All right.
Silent Vash says prosecution forgot to remove the hanger from his coat.
There you go.
I'm
Whoever
sitting
chat said
so
that.
weird.
Great minds think alike, people.
President-elect Austin M says dismissing the possession charge mid-trial kneecaps the prosecution. What do you think? So one of the arguments from the prosecution was how do we do this with the curfew charge, since it's a 6-person jury, since it's a civil charge is the issue.
Yeah, I don't I don't know the law obviously well enough, but
Is,
I think they have
why
to sever it.
why wouldn't a 12-person jury be sufficient for a 6-person
I
thing?
think year after next.
Don't
Seems
know, I
odd.
think defense should have said,
then the
I agree, Your
sheriff's
Honor. We should
original
sever this
equipment,
charge and it should be
some
tried
furniture.
separately. Just get the
Can you,
curfew
move
issue
that,
out of the case entirely.
Which is the most comfortable location?
Yeah, maybe they missed a trick on that one.
Would it be comfortable down there? Right there in front of the officer there?
Seraph Creed says,
Well,
judge
let's move the
arguing
chair.
Kyle placed the
Yeah,
kids,
well,
then
that might-
shot.
I wonder what these, like,
Everything
papers
from there,
behind
that's
them
my
are.
only concern. Okay, yeah.
Behind the
'Cause
judge?
the bottom one, yeah, the bottom one looks like it might be a book, but some of those top ones look like they might be in some sort of plastic wrap.
All right, great.
Either plastic wrap or,
I'll talk more about the building later.
yeah.
And
So I'm curious what that might be.
When there's a break, we're going to.
Maybe it's forms of some kind that haven't been opened yet.
Yeah.
Could be. Did I hear something about a sandwich? Gosh, I'm hungry. Means Arton says he's scared to change the jury instruction. Not the first judge to be reluctant to mess with approved instructions. Yeah, well,
Yeah.
those are issues that can be overturned on appeal. If you,
You know,
if you get
fair
it wrong.
enough. You know, jury instructions, particularly at this point, are kind of tried and true. They've gone through vetting processes through many appeals previous. So judges are, I think, rightfully
Good morning,
reluctant to mess
everyone,
with them.
and I'm glad I told you not to come in until 9:45. I did tell you that, didn't I?
No.
All right, no, we
Wow,
were
he
doing
just made a joke about the jury. He's
And,
like, he's just to the jury. I'm glad I told you not to come till 9:45. I did tell you that.
that happens periodically throughout the trial.
And the juries think themselves, please kill me.
nothing
Well, that is a Milwaukee
effective.
Brewers
Usually
Kleenex
ends up
box
saving
behind him.
some time, some of your valuable time, and so we hope we. Oh, I see how it's laid out. Okay.
This woman is the clerk,
We're-
or she's the
we'll
judge's
have much
assistant.
more of that today. Would you? We're going to swear you now. Your
Yeah.
oath to reach a fair and just verdict. So if you would please,
Can I ask
Mrs.
all
Lehman.
the jurors to raise their hand, please, take the second oath?
Stephanie, what am I making? I'm making what's going to be the piece de resistance of my gunpla collection, which is the extreme metal grade track freedom, which you're not going to be able to see because of the blur effect on my camera. But actually, maybe I can just hold it up there. There.
And please
It'll
silence
look pretty
those
sweet when I'm
phones
done.
if you would.
The jury's allowed to bring phones into the room.
What?
I'm sorry, what?
An audible signal. And before the trial begins,
The jury's allowed to bring phones in.
I hope will help you better.
Is that what's going on?
As jurors and
That can't be
conduct
accurate.
Do they get to take that into the deliberation room? Holy shit, dude!
to decide the case solely as the evidence develops, presented at the trial, and the law is given
My
to you
brain
in
is
my instructions.
Not working after that.
Anything that you see.
No, because that implies a whole host of problems.
Do not let any personal feelings about race, religion, national origin, sex, age, or politics affect your consideration of the evidence. Do not begin your deliberations and discussion of
just
the
saying
case until
generally
all
the
of the evidence
courtroom.
has been presented
But I don't
and
think
I have
so.
instructed you regarding our law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. There are times when I need to discuss legal matters with the attorneys that do not necessarily concern you, or in some cases, it's something needs to be discussed outside your presence, and you'll be excused at that time. Usually, if it's going to be short, I'll just put you into the conference room back here, which is it might be a little bit tight, but I think you'll be okay. And otherwise, we may take a break, and you'll be up in your jury room. When you're in the jury room, you need to stay there. You can't be wandering the hallways. You can't be coming and going, except when you have permission from the bailiffs. And you do have, if you have permission from the bailiffs, you may go to the break room across the hall here where they've got some vending machines.
Put the vending
also
machines in the
outside
jury
if
room,
you
man.
want to get a little
That'd be
fresh
good.
air. Or smoke if that's
Pop the top of that Coca-Cola. See if it tells you
Bailiffs will
guilty or not
escort
guilty.
you. So you need to go as a group, and they know the procedure, and then go back directly to the jury room and remain in the jury room until you're dismissed for the day. Do not research any information that you personally think might be helpful to you in understanding the issues which are presented. Do not investigate this case on your own or visit the scene. Do not read any newspaper reports or listen to any news reports on radio or television about the trial.
Or on your
Do
phone in
not
the
consult
court.
dictionaries, computers, websites, or other
Is it okay if I live tweet this?
for additional
Live tweet my
information.
thoughts as it
Do
goes
not
in real
seek
time. That'd be
information
helpful for my
regarding the public
mental
record
recollection
of
later.
anyone involved
Go
in
for
this
it.
case. Any
No,
information
I meant the jury.
outside the courtroom would be misleading, inaccurate, or incomplete.
No.
Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experiences as jurors while you are serving on the jury. Do not use a computer, cell phone, or other electronic device with communication capabilities to share any information about the case. For example, do not communicate by blog, email, text message, Twitter, or any other way on or off the computer. Do not permit anyone to communicate with you, and if anyone does so, despite your telling them not to, you should report that to me. It will be tempting when you go home in the evening to discuss this with members of your household, but you must not do so. This case must be
Staged
decided by
suicide
you
mirror.
jurors
Okay.
based on the evidence presented in the courtroom.
Starring that. Thank you.
People who are not serving on the jury have not heard the evidence, and it is improper for them to
Well.
influence your deliberations and decision in this case.
We're going to hear the
The
evidence.
trial
though.
has been completed. You are free to communicate with anyone in any manner. These rules are intended to ensure that you remain impartial throughout the trial. If any of you has reason to believe that another juror has violated these rules, you should report that to me. You are to decide this case solely
Don't be no snitch.
on the evidence offered and received at this trial. Evidence is defined first as the sworn testimony of witnesses, both on direct and cross-examination, regardless of the party who calls the witness. Second, any exhibits which are received, whether or
Cheers,
not
chat.
they accompany you
1,000
to the
likes.
jury room. Third, any facts which the lawyers have agreed or stipulated, or which I direct you to find. Attorneys for each side have the right and the duty to
Yes,
object
Nick
to
Mailer,
what
I
they
am.
feel are improper questions asked of witnesses, and to the receipt of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact that an objection is made.
I'm looking at his pencil
allowing,
holder now. What is this like
Testimony
red
or other evidence to be received
devil
over
thing he's
objection.
got on a
I am
pen or
not
something?
indicating any opinion about the value of that evidence.
No idea.
You jurors are the sole judges of the believability of the witnesses and of the weight of the evidence. You are not required to take notes during the giving of evidence in this case, but you are welcome to do so if you wish. If you do decide to take notes, please take care that it does not distract you from carefully listening to and observing the witnesses. You may use your notes during your deliberations to refresh your recollections. Otherwise, you should keep them confidential. The bailiffs will supply you with the materials. You may
Another
rely-
judge
rely
lets you take
upon-
notes. That's cool.
Excuse me. After the trial, your notes
Yeah,
will
in
be
a
does seem to
collected.
be a
case
bit
like
of a
this, you
trend.
gotta
Yeah.
take notes.
You will not have a copy of the written transcript of the trial testimony
I
available
wouldn't.
for use during your
But they do.
deliberations. You should therefore pay careful attention to all of the testimony because you must rely primarily upon your memory
I'm
of the evidence
curious
and the
just
testimony introduced
on
in the
on
trial.
a policy level why they
Your
don't
duty
provide a
is to
transcript.
scrutinize the way the
to the
testimony
jury.
of the witnesses.
I mean, wouldn't that be
and
helpful?
determine the effect of the evidence as a
Yeah.
whole.
Yeah, but that'd be too.
You are the sole judges of the credibility, that is the believability of the witnesses.
It's like, why go off our recollection when we can just literally read the words on the page?
In determining the credibility of each witness,
I don't
and the
know.
weight
Maybe
you
they
give
don't
the
want to taint the
testimony of each, you
impression
should
with an
consider these
objective
factors,
cold read later.
whether the witness has
Maybe.
interest or is disinterested in the outcome of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clarity or lack of clarity of the witness's recollections, the opportunity which the witness had to observe and to know the matters and things about which testimony is given, the reasonableness of the testimony, the witness's apparent intelligence, bias or prejudice.
Bad now at 10, Jason.
Prejudice, if any, is shown, possible motives to falsify, and all other facts and circumstances during the trial, which tend either to support or to discredit the witness's testimony, and then give the testimony of each witness the weight you believe it is entitled to receive. There is no magical
I
way
give it
for
the
you to
weight
evaluate
of
the
that
testimony.
prosecutor.
Instead, you should use your common sense and your experiences in life. In your everyday lives, you determine for yourselves the reliability of statements which are made to you by others, and you should do the same thing here. The first count of the information in this case charges that on
Okay.
the
On to the count. Look at this stack of papers the judge is sifting.
25th of August of last year at the city of Kenosha in this county, the defendant recklessly caused the death of Joseph D. Rosenbaum under circumstances which show utter disregard for human life.
That's going to be a hard
First-degree
one.
reckless homicide, as defined in the criminal code, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of this crime, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements of this crime were present. First, that the defendant caused the death of another. Cause means that the defendant's act was a substantial factor in producing the death.
Substantial factor,
Second,
back
that
to
the
like the
defendant
Floyd
caused the
discussion,
death
right?
by criminally reckless conduct. Criminally reckless conduct means that the conduct created a risk of death or great bodily harm, which was unreasonable and substantial, and that he was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. The circumstances of the defendant.
Third element, buddy.
You lose your place on the page.
The third element is that the third circumstances of the defendant's conduct show utter disregard for human life. In determining whether the defendant's
not literally marking it
utter
when he reads
disregard
it.
for human
I
life,
mean, that could work.
consider these factors: what the defendant was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious was the danger, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The second and third counts of the information, respectively, charge that at the same time and place, the defendant recklessly endangered the safety of Richard McGinnis under circumstances which show utter disregard for human life. And the third count
20,
charges an
Harrison.
identical crime
Yeah, and
involving
apparently they did that at the
unknown
end of the
male,
at the end of the previous day.
and to each of these charges as
How
well.
is he still unknown at this point,
Guilty.
right?
Reckless endangerment of the first degree as charged in these
That's-
counts is committed by
That's
one who
like just
recklessly
conceptually a little
endangers
bit
the
weird. It's like
safety
we
of
can't even
another
identify
being
who the purported
circumstances which show
person who was
utter
acted against
disregard
is for
life.
sure.
Before you may find the defendant
Criminal
guilty
violation
of
against John
the first
Doe.
degree as to either of these counts. The state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, that the defendant endangered the safety of another human being. Second, that he endangered the safety of another by criminally reckless conduct. Again, criminally reckless conduct means that the conduct created a risk of death or great bodily harm to another person, and that the risk of death or great bodily harm was unreasonable and substantial, and that the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm.
That's a weird one because
And great bodily harm means injury which creates a substantial
not
risk of
privileged
death,
to self-defense
which
there, but that
causes
guy just kicked him in the
permanent
face.
serious permanent disfigurement, or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily injury. And the third element is that the circumstances of the defendant's conduct showed utter disregard for human life. Again, in determining whether the circumstances of the conduct show utter disregard for human life, you should consider what he was doing, why he was engaged in that conduct, the danger of the conduct, how obvious was the danger, whether the conduct showed any regard for life, and all other
As to the jury.
circumstances
He's talking directly to the jury.
relating to the conduct. The fourth count of the information charges that at the same time and place, the defendant intentionally caused the death of Anthony M. Huber with intent to kill him. First-degree reckless homicide, as defined in the criminal code, is committed by one who causes the death of another human being with intent to kill that person or another. Before the defendant may be found guilty of intentional homicide of the first degree, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant caused the death of another, and cause means that the defendant's act was a substantial factor in producing the death. And second, that the defendant acted with intent to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute.
That's one thing that I will just comment on there quickly is a lot of people have some sort of misconception as to what premeditation can consist of. Premeditation doesn't need to be minutes. It can be seconds. It can literally be a single cold calculated decision. It's basically the difference between a reaction and a positive action is whether or not it's premeditated. And it can cause all sorts of issues, really, when you're trying to get down to the nitty-gritty as to whether someone trans poop. Okay, Tweety. It can cause all sorts of issues, especially really in self-defense cases as well. So it's going to be interesting to see how they handle that.
There need not have been any appreciable time between the formation of the intent and the act. The intent to kill may have been formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act.
Terms displayed and delivered, Mandy. It's on the
You
bottom
cannot look
banner.
into a person's mind to determine intent, which must be found if it is to be found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case which bear upon intent. Intent should not be Intent should not be confused with motive. While proof of motive is necessary to a conviction, while proof of intent is necessary to conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The fifth count of the information charges at the same time and place at the city of Kenosha in this county. The defendant attempted to cause the death of Gaige Grosskreutz with intent to kill that person. This is a charge of attempted intentional homicide of the first degree. The crime of attempted intentional homicide of the first degree, as defined in the criminal code, is committed by one who, with the intent to commit first degree intentional homicide, does acts towards the commission of that crime which demonstrate unequivocally under all of the circumstances that he had formed the intent and would have committed that crime except for the intervention of some other person or some other extraneous factor. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements of this crime were present. First, that the defendant intended to kill another human being. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another. Second, that the defendant did acts towards the commission of the crime of intentional homicide of the first degree, which demonstrate unequivocally, under all of the circumstances, that he intended to kill and would have killed another, except for the intervention of another person or some other extraneous factor. Unequivocally means that
he missed.
Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from the defendant's acts under the circumstances. Another person means anyone other than the defendant and may include the intended victim. An extraneous factor is something outside the knowledge of the defendant or outside of his control. While the law requires that the defendant have acted with the intent to kill, it does not require that the intent have existed for any particular length of time before the act is committed. The act need not have been considered or reflected upon for a week, a
He's
day, an
holding that
hour,
up
or
because he was
even
trying
for-
to. He's trying to keep his own channel clear of like the stuff that might get him
There
or
need
his
not
kids in
have been
trouble. I
any
think.
appreciable time between the
Schrader's
formation
gonna
of the
Wait
be
intent
COVID.
and
Doc,
three weeks to get on this
Get
channel.
a get a
intent
cough
to-
drop or
They
something,
have been
man.
formed at any time before the act, including the instant before the act, and must have continued to exist at the time of the act. Again, you cannot look into a person's mind to determine intent, which must be found if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case, which bear upon intent. Intent should not be confused with motive. While proof of intent is necessary to conviction, proof of motive is not.
Intent
Motive refers
versus
to
motive will trip some lawyers
Reason
up,
for
man.
doing something, and while motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of the defendant in order to obtain a conviction.
That's all right. But honestly, guys, if anyone
Evidence
wants
of
to
motive
donate
does
towards
not
the
by
trip in
itself
August
establish
to
guilt.
Matsuri, that'd be
You should
great.
give it the weight you believe it deserves under all of the circumstances.
Don't put yourselves out, though. Obviously.
The sixth count
I like
charges
what
that
Nate
at
the
the
lawyer
same
said
time and
about
place, the
Gaige
defendant
Grosskreutz. He's a
was a
unisex
person
now.
under the age of 18 years
No more biceps for him.
and was armed with a dangerous weapon. The seventh count charges that
I didn't think he was going to read that.
at the same time and place, the defendant intentionally failed to comply with an order issued by an agent of the state or of a local government unit, which was engaged in emergency management activities under Chapter 323 of the statutes.
Oh, it was a freaking curse.
And the
If
defendant
anyone
has
was gonna-
also pleaded not guilty with respect to each of those charges. I'm going to give you a more complete instruction about those offenses which are alleged at the close of the trial. Basically, the sixth count deals with the circumstances under which it is lawful for a person who is under the age of 18 to have a firearm in his possession. And the seventh count deals with special circumstances in which emergency management edicts are issued and the requirements which are imposed for obedience to those edicts.
The denialist says step 1, buy a howitzer. 2, name it perfect
The first
self-defense.
five
3,
counts of
fire in
information
random
allege not
directions.
only that the
4,
defendant committed the crimes
profit?
which are charged in those counts, but also that he did so while using a dangerous weapon. If you find the defendant guilty on any of those counts, then you must answer the following question. Did the defendant commit the crime while using a dangerous weapon? Dangerous weapon means any firearm, whether loaded or unloaded. A firearm is a weapon which acts by the force of gunpowder. Before you can answer the question yes, if you are called
So,
upon to ask it, answer.
Air-based guns
Then
are
you
not
must be
firearms, I
satisfied
guess.
beyond a
So,
reasonable
yeah.
doubt that the defendant committed the crime while using a
or
dangerous
rail
weapon.
guns.
Self-defense is an issue in this case, and the law of self-defense allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force that the defendant and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. The defendant may intentionally use force which is intended or likely to cause death or great bodily harm, only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though it is mistaken. In determining whether the defendant's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances existing at the time of the alleged offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts, and not from the viewpoint of the jury now. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant did not act lawfully in self-defense. That is with respect to counts 1, 3, 4, and 5. So those are the charges of reckless endangerment, reckless homicide, and intentional homicide, and intentional attempted intentional homicide. A separate instruction applies to, I'm sorry, I misstated that. The
Oh,
reckless, the instruction I just gave you on self-defense applies to the first count of reckless homicide involving Joseph Rosenbaum, the third count involving the unknown male, the fourth count involving Anthony Huber, which is a charge of intentional homicide, and the fifth count, which is attempt to commit intentional homicide involving Gaige Grosskreutz. There is a different rule applicable to the charge involving Richard McGinnis, the second count. And that is that there may be evidence in the case that the defendant was acting in self-defense as to Joseph Rosenbaum. The fact that the law may allow the defendant to have used force in self-defense as to Joseph Rosenbaum does not necessarily mean that recklessly endangering the safety of Richard McGinnis was lawful. You must consider the law of self-defense in determining whether the defendant's conduct as to Richard McGinnis was criminally reckless conduct which showed utter disregard for human life. But the defendant does not enjoy the privilege of self-defense as to Richard McGinnis, because Richard McGinnis was not any way
such a confusing jury instruction. Terribly.
The law of
terribly
self-defense
conceived.
allows the defendant to threaten or intentionally use force against another only if the defendant believed there was an actual or imminent unlawful interference with his own person, and that he believed that the amount of force he used or threatened to use was necessary to prevent or terminate the interference, and that his beliefs were reasonable. A defendant may intentionally use force which is likely intended or likely to kill or cause great bodily harm only if the defendant reasonably believed that the force used was necessary to prevent imminent death or great bodily harm to himself. So that self-defense would be applicable to the defendant with respect to Mr. Rosenbaum, if you find that it's sustained by the evidence. But that doesn't follow through with respect to Mr. McGinnis, who was in the area of the gunfire.
Doesn't automatically follow
And
through. Come on. Oh my God.
So you have to analyze that separately and determine, well, I'll get further into it. Keep in mind that a belief may be reasonable even though mistaken in determining whether the defendant's beliefs were reasonable. The standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position
And the irony
under
is
the
this is when they should be
circumstances
really
then
paying
existing.
attention. But
The reasonableness
Bruce
of the defendant's
thanks to
beliefs
confusing
must be
shit,
determined from the
and
standpoint of the
being
defendant
very
at the
monotonous
time of
about
his
it.
acts and not from the viewpoint of the jury now.
like,
You should consider the
this is the equivalent of the in-flight safety briefing that the stewards give when you get on the plane. Everyone that's in the situation, anyone that's been in the situation has heard it before. But if it's the first time you're hearing it, you're really supposed to be paying attention. And Bruce is not doing a good job of this, to be perfectly honest. So, yeah, couldn't do it. I'd nod off how he's talking to. Now I believe they need to hire strippers to read jury instructions. Yeah, I know. I caught myself. I said stewards.
the evidence
Oh, wait,
relating to self-defense, along with all of the other evidence in the case, in deciding whether the defendant's conduct created an unreasonable risk of death or great bodily harm as to Richard McGinnis. If the defendant was acting lawfully in self-defense with respect to Mr. Rosenbaum, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in the case that the risk was unreasonable. You should consider the evidence relating to self-defense as to Mr. Rosenbaum in deciding whether the circumstances of the defendant's conduct with regard to Mr. McGinnis showed utter disregard for human life.
Guarantee no juror has
followed
it.
Prove beyond a reasonable doubt that the defendant.
I'm not sure I'm following it.
In self-defense, And you must be satisfied beyond a reasonable doubt from all of
Oh
the
yeah,
evidence
it's
in
too
this
offensive
case.
now to be calling
I
them
know I'm not.
The
stewardesses.
circumstances of the defendant's conduct showed utter disregard for human life. In reaching your verdict, examine the evidence with the utmost care and caution.
Everybody blaming
Act
the
with
judge for
judgment,
this.
reason,
Chill out a
prudence.
minute.
The
Like,
defendant is
these
not
are
required
the
to
jury
prove his
instructions from
innocence.
Wisconsin.
The law
The
presumes every
instruction
person
itself
charged
is
with the
bad.
commission of a crime to be innocent, and this presumption requires a finding of not guilty, unless in your deliberations you find that it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you may return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the innocence of the defendant, then you must do so and find him not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for
No
which a
fucking
reason can be
shit.
given, arising from a fair and rational consideration of the evidence or want of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life.
Oh,
A reasonable doubt is not a doubt
I'm
which is
sure
based
that's a
upon mere guess
well-held
or
opinion.
speculation.
By
A
France.
doubt which arises merely
That's
from
the point.
sympathy
I've never actually
or
seen
from
it, so that's
fear to
why
return
I'm
a
doing
verdict
this.
of guilt is not a
Curious to see
reasonable
exactly
doubt.
what the evidence was.
A reasonable doubt is not a doubt, such as may be used to escape the responsibility of a decision. Examine the evidence and search for the truth, giving
It's
the
one of the
defendant
better definitions of reasonable doubt I've heard.
every
So
reasonable doubt. We're going to hear the opening statements of the lawyers now.
Thank God.
And we follow the procedure where the state speaks first. You know, sometimes you see these actress judges on TV, and they just destroy my enjoyment of the program when they tell the lawyers we're going to have the opening argument now. And I think, well, the only argument you're going to have is with me, because there's no such thing as an opening argument. It's opening statement.
this is technically correct.
Argument is for the end, and that's when they're going to make their pleas to you to return.
An
verdicts
opening
in
statement's
accordance with
mildly
their beliefs.
argumentative.
At this
Persuasive,
point, they're
maybe
going
we
to
should
briefly
say.
acquaint you with what they think the evidence is going to show, give you an overview, alert you to the things they especially want you to watch for in the evidence. And they can be very useful to you for those purposes. And they're brief. And then we can write into the evidence right after that. Mr. Binger, I think, is going to address you first on behalf of the state. And then Mr. Richards will
Can
have
I ask you a question?
to make an opening statement now, or
So-
first he is entitled.
So, given that jury instruction with respect to count 2 for this reckless endangerment,
And
so you and I both know that we have to
with
apply
that,
the law as it's been
again,
given to
don't know
us,
what you have-
regardless of what we think about the law personally. So,
Because this is,
given the law as it was just described to us in count 2, and given the evidence we currently understand,
Binger, you may-
guilty or not guilty, because I don't know anymore.
Good morning, ladies and gentlemen.
Depends on the juror's feelings, apparently.
I was asking
The
you, what do
evidence
you
in this
think?
case will show
I think
You-
not.
I mean-
August 25th,
Okay.
2020,
I want to hear this guy. I
here
want to
in
hear
our
this dummy.
community of
Fair enough.
Kenosha. The defendant, Kyle Rittenhouse, who was 17 years old at the time, had armed himself with an AR-15 style semi-automatic rifle loaded with 30
Oh, yeah.
rounds in the magazine.
Magazine clip.
And using that rifle, he shot and killed Joseph Rosenbaum, an unarmed
That's
man.
Binger.
The shot that killed Mr. Rosenbaum was a shot to the back. This occurred after the defendant chased down Mr. Rosenbaum and confronted him while wielding that AR-15.
Did it?
The evidence will
Chased
show that the
down and
defendant
confronted
fled
him.
the scene
How did he chase him
of the
down?
dead body of Joseph Rosenbaum,
Rosenbaum
without
chased
stopping to
Rittenhouse
offer
down.
any aid whatsoever.
Okay, hang on.
And
We're,
as-
we're already into some bullshit. Okay, this is what we saw, and we got to remember, for those of you that sat through the Anderson trial with me, Gravely is this guy's boss. I'm not surprised in the slightest that he's lying through his teeth is part of the opening statements, because they can pretty much say whatever they like. There's no consequences. There's very little that you would object to in both opening or closing arguments. It's generally considered very bad form to do so, and I'm not even slightly surprised, to be perfectly honest. This is already. What is your and perhaps Australia's opinion on Russians, Putin, and West Taiwan's poo forming an alliance? I think we're headed into a fairly large military conflict by the end of the decade. Would be my personal opinion, but we can talk about doom and gloom sooner or later. I'm not happy with it. I'm really not. But straight out lie by Fluffer Boy. Yeah. Look, he was retreating. Even I've seen the footage because Nick showed it on the stream yesterday as to exactly what happened when he took those shots. He didn't chase anybody down. It's only bad if the state does it. If it's only bad if the defense does it, the state keeps doing it. Yep. There was some chasing going on, just not Kyle. Mm-hmm. Bing's behavior is disgusting and gross. Yes. And again, people, as I said yesterday, this is what we get as a result of elected DAs. As I said, here in Australia, for the most part, DAs it's a job. You can be hired, you can be fired. There's still accountability for it, but there's no political bias behind it. Like, there's no need for that. There's no point in aiming for convictions and that sort of thing for that reason in order to maintain your position. And I do think that has a significant impact on things. Also, thank you to the 45 of you watching over on Rumble with the 14 likes. I appreciate that. And guys, I'm just going to take this opportunity, the 214 of you watching, if you haven't already liked the video, please do. And maybe just double check if you already are subbed, if you wouldn't mind checking, because people are getting unsubbed again. So, is Australia an American ally or mostly neutral? No, we're what are we? We've got AUKUS, which is the Australia, UK, and US treaty. We're part of NATO. We're pretty close ties, which is why it's a little bit scary that I don't think that, you guys have a military base here. Actually, there's a silo in the middle of the Northern Territory, I believe, from memory. And we're part of Five Eyes. This is true. But I am worried that you guys aren't going to be able to come to our aid when West Taiwan actually makes a move, which I'm a little bit terrified about. But anyway, Aussies are definitely allies. Have a military base in Australia? There's a couple, actually. And I know part of... I think there's guys stationed at certain military installations, I do believe. Don't quote me on that, but I'm fairly confident.
As he's running, word spreads from the crowd on the street that there is an active shooter running through the area. And the citizens there attempt to stop him. They approach the defendant. One person hits him in the back of the head. One person takes a swing at him with a skateboard. That individual is Anthony Huber.
He hit him with a skateboard.
Eventually, the defendant loses his balance and falls to the ground. An individual who is the subject of count number 2, the unknown individual, runs in at that point and attempts to kick the defendant in the face.
No, count number 3. You got this wrong. This
unknown individual is unarmed. The defendant, in response, points his AR-15 directly at this individual as this individual is literally flying over his body and discharges that gun twice. Luckily, that individual was not hit. But clearly, if he had been hit, the wound would have been severe and perhaps even fatal.
Flying over his body. He's
Someone's been watching the
Immediately after that, Anthony Huber,
defense will get to say all this,
who is holding a skateboard, comes in and reaches for the defendant's gun. He grabs hold of the gun and tries to pull it away from the defendant.
Well, thanks.
The defendant is wearing his AR-15 strapped to his body. There is a nylon strap around his entire body, and the gun is slung from that. So it is essentially attached to him. Mr. Huber's efforts are unsuccessful because of that strap. And in that struggle, the gun winds up pointed directly at Mr. Huber's chest. The defendant pulls the trigger one time and discharges a round into Mr. Huber's chest, killing him instantly. A final individual by the name of Gaige Grosskreutz has followed this chase on foot and has approached the defendant at this time. Mr. Grosskreutz is holding his cell phone that he'd been using to record the night's events for a live stream on Facebook in one hand, and a Glock semi-automatic pistol in the other hand. He runs up to the defendant. The defendant turns towards him with the AR-15. Mr. Grosskreutz raises his hand. The defendant then turns his rifle over, begins to examine it for a second. Mr. Grosskreutz takes this opportunity, and you will see in the
Was
photo
it for even a second?
that he blades his body with his left hand, reaching towards the defendant. His right arm is pulled back. This is the one with the gun in his hand.
Well,
And as he's reaching for the defendant turns the
maybe, Max.
AR-15 and
I'm
discharges
gonna discuss
the
that with
eighth
the
and
bosses.
final round into Mr. Grosskreitz's right arm. The arm
just
with the
made
gun.
2 self-defense cases right
Mr.
there.
Grosskreutz runs off, screaming for a medic. The
I
defendant
I don't mind it though, because he's admitting to bad facts, so he's taking the
that
sting
night,
out, which is
he
good
killed
strategy.
2 unarmed people, shot at a third at very close range, and wounded Mr. Grosskreutz in the arm, who was armed with a gun.
And is now
It is the
disarmed.
state's position that this evidence demonstrates the criminal charges against the defendant is intentional homicide of Anthony Huber and his reckless conduct towards the other defendants. Now, what I've just given you is the snapshot, but there's a wider context here. As we all discussed yesterday, this occurs during the context of the events following the shooting of Jacob Blake, which occurred on Sunday night, August 23rd, 2020. And we all know that within a short period of time after that, the community erupted in protests, looting, rioting, arson, and violence. Sunday night and Monday night were 2 of the roughest nights that our community has ever seen. We are well aware of the damage that the uptown area along 22nd Avenue suffered. The probation and parole office on 60th Street, the furniture business there,
Yeah, I got no idea how
Car
to get to
Source,
scale
one
like
of their
that.
locations on Sheridan, and other properties around town that were damaged.
I love it.
Fortunately, in the entire sequence of events, this was all property damage. And one of the things we all agreed on yesterday is life is more important than property.
Fair.
Up until Tuesday night,
Not always.
despite all of the things that the community had experienced, no one had been killed.
If I got a Lamborghini and someone's pouring
But
a
what
can of
happened
gasoline on it,
as
you
the
can better believe
time
I'm
went
gonna
on
eat it.
was that the people of Kenosha, who felt a sense of outrage, began to protest. But like moths to a flame, tourists from outside of our community were drawn to chaos.
Oh, they're going
Here
to
in
pull this
Kenosha.
one, huh?
I like it.
People from outside of Kenosha came in and contributed to that chaos. And it caused many of our citizens to fear for their safety, fear for their homes and their families, fear for their businesses, and take steps to protect themselves, whether it is to arm themselves, board up their windows, move, or take time away from the community. All of those reactions were entirely understandable and reasonable. And no one here is going to tell you otherwise. As long as those are what you're left doing, there's no issue. But out of the hundreds of people that came to Kenosha during that week, the hundreds of people that were out on the streets that week, the evidence will show that the only person who killed anyone was the defendant, Kyle Rittenhouse. The evidence will show that hundreds of people were out on the street experiencing chaos and violence, and the only person who killed anyone was the defendant, Kyle Rittenhouse. We will show you videos of some of the events that night, of police.
Are you going to show video of the shop owner getting beaten to death for putting out fires? I highly doubt that.
Tear gas, rubber bullets. And yet, the only person who killed anyone was the defendant. There are fireworks going off, which is a loud noise, sounds like gunfire. There are guns being discharged, the sound of gunfire throughout our community that night. Hundreds of people are there experiencing this. And yet the only one who kills anyone is the defendant. We will show you video of hostile confrontation between literally hundreds of people on one side of the issue and on the other side of the issue. People getting up in each other's faces. And yet the only person who killed anyone.
Love it. I love the repetition.
He's making
Hundreds
a good
of people
opening statement.
No, I think this
nights.
opening is
Experience the night of August 25th.
wonderful.
Experience that chaos. Hundreds of people. And yet the only one who killed anyone is the defendant, Kyle Rittenhouse. Recently, I heard someone sort of tongue-in-cheek joke that jury service is bringing in folks from our community and paying them $8 a day to help solve a murder. We're not asking you to solve a mystery in this case. In most homicide cases, the elements that I need to prove might be a little challenging, but here, there's no doubt, there will be no dispute in this record that the defendant had that gun that night, shot 8 bullets, 4 of them hit Joseph Rosenbaum, 2 of them at an unknown individual, 1 into Anthony Huber's chest, and 1 into Gaige Grosskreitz's arm.
Love it.
That will not be in dispute. The central issue in this case is going to be self-defense. And the judge has given you an instruction, which I want to highlight here, because there are some factors that I'd like you to keep in mind when you hear the evidence in this case.
Don't touch my stuff, I won't end you.
The defendant used deadly force. There is a privilege under our laws to use deadly force, but it's a very limited privilege. That privilege, according to the law, indicates that the defendant can only use deadly force if he reasonably believed that the force was necessary to prevent imminent death.
Mm-hmm.
He is making Kyle's argument for him. He's just explained that Kyle has to be in imminent, like, it's subjective to Kyle as to whether or not he feels that he's in imminent danger. Bravo, Binger. Bravo.
Or great bodily harm to himself. In determining whether or not those beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in the defendant's position under the circumstances that existed at the time of the offense. The reasonableness of the defendant's beliefs must be determined from the standpoint of the defendant at the time of his acts and not with the benefit of hindsight.
You don't say.
You are essentially the people of ordinary intelligence and prudence who will apply that standard of reasonableness to the defendant's behavior and make a determination as to whether or not his use of deadly force was reasonable. Was it reasonable for the defendant to believe that the force was necessary to prevent imminent death or great bodily harm to himself? So let's talk about the context of that evening. And I'm going to try and go in a little bit of chronological order to set things up for you so you understand the evidence as it comes into this trial. The first witness you're going to hear from in this trial is a man by the name of Dominic Black. Dominic Black was, at the time of this incident, dating Mackenzie Rittenhouse, who is the defendant's sister. And through Mackenzie, Dominic Black got to know the defendant. And they spent a lot of time together in the months leading up to August 25th, 2020. In fact, on May 1st of 2020, Dominic Black bought the AR-15 for the defendant. That occurred up in Ladysmith, Wisconsin. Dominic Black used money that was given to him by the defendant to go to an Ace Hardware up in Ladysmith and buy the gun in Dominic Black's name. Now you might ask, why was it necessary for Dominic Black to do that? Why couldn't the defendant do that? Because the defendant was 17. And Dominic Black and the defendant knew that because the defendant is 17, he cannot purchase a gun. He cannot legally own a gun.
That's not true.
And
No,
so
but
this
the
was in
owning
fact
part,
a
that's
straw
the end.
purchase on behalf of Dominic Black, on behalf of the defendant. After the gun is purchased in Ladysmith, Dominic Black and the defendant spent a little time up there at Dominic Black's family's hunting property. And they fire both that AR-15 and one that Dominic Black already had. And the two of them are practicing using their AR-15s at a shooting range that they have on that property. And Mr. Black will tell you some more about that. Then they agreed that that gun would not go home with the defendant.
Even here, you can
to
fire
his
a
home in
weapon on private
Antioch,
property without a
Illinois.
license.
It would stay here in Kenosha at the residence of Dominic Black's stepfather in a
That's not legal
gun
advice.
case. And in fact,
Seems
after
safe.
the two of them returned from Ladysmith in early May of 2020, the gun stayed at that residence here in Kenosha until the day of August 25th, 2020.
Cathurga says, listening to this POS
On
prosecutor's
the
sophistry
night
is
leading up to
pissing
August
me off.
25th, that Monday night, the defendant stayed over at Mr. Black's residence here in Kenosha. And the two of them decided on that next day, Tuesday, August 25th, that they would do something about what was going on in Kenosha. So at one point earlier in the day, they come down here. They work on cleaning up some graffiti on some buildings here downtown. Then they decide they want to come back later that night and protect the local business called Car Source, which is located at 59th and Sheridan. Now, as I talked to you a little bit about yesterday, Car Source actually has three
Nice.
locations very close in this downtown area. One of them was on the east side of Sheridan Road at 58th and Sheridan. Either on Sunday or Monday night, I think it was on Monday night, August 24th, that entire property was pretty much destroyed. There were multiple cars in the parking lot that were set fire and completely burned out. The building itself was damaged as well. Right across the street from there is another Car
magically
Source
happened.
location that also sold used cars. And some of those cars had been damaged on the night of Monday, August.
No, I like it though because
So,
he's getting in
on Tuesday,
front
when the defendant and Mr. Black are
of
out,
bad facts.
they encounter one of the owners of Car Source. And they talk to him about protecting their 59th Street location that night. And there's some discussion about that. In the afternoon, Mr. Black and the defendant go out to Jelinski's on Highway 31, Green Bay Road. And they acquire straps so that they can sling those guns around themselves when they come back to the downtown area that night. And
Don't wanna carry a gun
eventually
all
later
day.
that evening, they return. They meet up with some other folks that are interested in protecting Car Source. Originally, they start out at 63rd Street Car Source, which is the third and final Car Source location. But then they agree, we're going to go to the 59th Street, 59th and Sheridan location and protect that location to make sure no one damages the cars, no one damages the property. And I want to be clear, there's nothing wrong with that. Protecting that property is entirely lawful, totally understandable. And it's something that many people here in Kenosha did. And there's a group of people, including the defendant and Dominic Black, that take up positions at 59th Street. Some of them, like the defendant, are on the ground in the parking lot, where as people are walking by in the street, they're having interactions with
Can I
these
make a
people.
joke about roof Koreans?
Dominic Black will testify.
Sure.
He took up a position on the roof. He did that because he didn't want to be on the ground, close to where other folks were, close to where potential
Oh, they're gonna
issues might
suggest
arise.
it.
He wanted
Well,
to
Kyle
stay a little
should
bit
have
removed
chosen
from
to be
all
up on
that.
the roof.
Didn't want to
What,
get
fired-
directly involved. in
Fired
it.
down into the crowd. I guess that would be good.
Oh yeah, sure.
You will
that's in
hear
no
and-
way gonna look-
See videos of sequence of events going on around Kenosha that night. The evening begins with large-scale protests, large-scale, no other way to put it, rioting that's
Yeah,
occurring
because
for
he knows
him.
that Bing
right
is talking
outside
out his
these
ass.
windows,
And like I
right in
said,
front of the courthouse here at Civic Center.
the opening
Park.
statements are purely for the jury to
There
try and
is
color
a
them as much as
crowd of
possible.
police that
There's
are
no evidence.
lined
There's
up to
no.
protect this building, to protect the public safety building, which is right next door. And there
You
are
may
a
not like
large
what he's
number of
saying, but
protesters
he's
that
doing
are
a very good
agitating.
job.
They are
in
screaming
opening
at the
here.
police. They are throwing projectiles. Police are shooting rubber bullets, tear gas, etc. It is a very volatile situation at Civic Center Park. Now, that's at 56th and Sheridan, about 3 blocks north of the Car Source where the defendant was. But as the evening goes on, the police decide to move the line of protesters south on Sheridan. And eventually, they pass the Car Source at 59th and Sheridan. The police establish a line at 60th and Sheridan, 1 block south. Now, as that process is going on, many of these protesters pass by the defendant and the people that he's with at 59th Street. Words are exchanged. There is confrontation. There is a little bit of hostility. No one is hurt. No one fires a gun. No one is injured. But clearly there's antagonism. It is clear that this is a crowd that is not on the same side as the defendant, that does not see him as an ally, does not see him and his group as someone that they identify with. And as I said, there is a hostile exchange there for a while. In fact, at one point, members of the crowd pull one of the dumpsters from the property out into the street and attempt to start it on fire. And some of the other folks that are there with the defendant go out and put the fire out and have some very harsh interactions with those people in the street. I believe the evidence will show that it is this process that demonstrated for the defendant that this is a crowd that is not a safe crowd to be in. This is a crowd that does not view him as an ally. This is a crowd that if he ventures out into it, there could be problems.
That seems a little defense friendly.
Now,
unless he's going to convert
once the police pass by and the protesters are pushed down south of 60th, I believe the evidence will show that the car source
Zach's
that the defendant
DA
is
was
stationed
involved.
at is
This
no
guy
longer in
is
danger.
an employee.
There's no one there who's attempting to damage the property. There's no one there who's going to do anything to harm anyone there. The situation has moved on. Does the defendant stay there? Does he decide that he's done what he set out to do and it's time to go home? No. The evidence will show that the defendant, another individual in the group by the name of Ryan Balch, who you will hear from, decide to venture out into the crowd. They cross the police line.
Chrissy, he's not here. But yes, we did actually watch the Zeminski getting. We did actually watch Zeminski getting pulled over on the channel. About 2 weeks ago, I think. This is being a junior. He had to suffer through being a senior. Have I mentioned how glad you're going back over this? I think we all forgot just how bad Binger and Lunchbox are. Fucking Binger. Thank you for the super chat, Flux.
60th and Sheridan. And they walk amongst this group of hostile protesters. At some point, they both wind up at a gas
to not
station
shoot anybody.
on the southeast corner of 60th and Sheridan called Ultimate Gas. And you'll see some video of the scene there. It is a scene, again, of groups of people that are clashing with one another verbally. There's some shoving going on. And in the midst of this is Joseph Rosenbaum. And you will hear some testimony about Mr. Rosenbaum and his activities that night. Mr. Rosenbaum had been discharged from the hospital that very day and had come back to his home of Kenosha, had met up with his girlfriend, Carrie Ann Swart.
I think
he couldn't stay with her, so he left her
defining it
and
as
came downtown and got caught up in the midst of these protests.
Got caught up.
You will see him on videos. You will see photographs of him as he's walking around. He is carrying a plastic bag. Part of that plastic bag is clear and see-through. It has a string, white string, drawstring to it. It is the type of bag, I believe the evidence will show, that you get at the hospital when you're asked to put all of your personal possessions in a bag. Your shoes, your watch, your phone, your jewelry, etc. That's the type of bag it is. And I believe the evidence will show that he was carrying it around most of that evening.
Yeah.
And at various points.
Oh, actually,
the evidence will show that Mr. Rosenbaum is agitating.
No,
he is getting in people's faces.
Sorry.
He is using obscenities. He is essentially daring people to respond. 46. In fact, at Ultimate Gas, I believe the evidence will show that he actually gets right up in the face of armed people who are similarly armed as the defendant, who have similar AR-15 type rifles on. And he is literally confronting them in their faces.
Mm-hmm.
None of those folks shoot him. They push him away. He's 5'3", by the way, 150 pounds. They push him away.
He just made the manlet argument.
No one appears to take him as a serious danger. The defendant is at the Ultimate Gas station during part of this. So is Ryan Balch. I believe Mr. Balch will testify that there was an understanding that when we cross south of 60th, we stay together. We
He
try
can't
not
be
to
in fear
intervene
if
in
no one was
anything.
taking him seriously.
But if we
and
get
therefore they weren't
separated,
a threat to him.
head back to 59th Street, where our original group is. Mr. Balch does. The defendant attempts to. He comes up to the police line. They won't let him pass. He says, I work at that business, and points to 59th Street. And again, they won't let him directly through the line. Now, I believe the evidence will show that he could have easily gone a block in either direction if he really wanted to go back, but he turns away from the police line, returns to the ultimate gas station. And a few minutes later, we see him on the video.
Hang on. Did he just make the argument that it would have been better for him to ignore a direct instruction from a police officer to walk around and go to the business instead of abiding by what he was instructed to do and going somewhere else to protect other property? Bingy, you fucking wanker. Other court streams from Australia? There are, mostly for the federal court stuff, but they're boring as shit because they're usually company v company, and it's usually over nothing. The most interesting one in the last 6 months has literally been a McDonald's versus Burger King, or our version of Burger King, over which patty was the best, which patty was the most moist. And the thing that really irritated me about that one was that the scientific testing that they did involved driving around to like 12 different stores, buying burgers, and then leaving them sitting on the car seat for like 8 hours before they got tested, because they all had to be purchased in the one day. But it didn't occur to anybody that the fact that they'd been sitting in like the hot sun on a car seat for 8 hours would affect the testing. So that's why I cover American trials, because the Australian trials are just boring as hell and batshit crazy. So, but anyway.
Man by the name of Corey Elijah, who will testify very shortly here in this trial. Mr. Corey Elijah was one of these people out on the streets who was Facebook live streaming the events of that night. And he catches the defendant passing right in front of him with a fire extinguisher. The gun still slung around his body, strapped to his body.
Who cares? He was
and Corey
carrying
Elijah will testify. This caught his attention. What
fire extinguisher?
Where's he going with this fire extinguisher? And so Corey Elijah decides to follow with his video, recording the entire way. And we will show you that video. You will see that as Corey Elijah leaves the ultimate gas station at 60th and Sheridan and heads south, he passes by the defendant, who by this point is walking, holding a fire extinguisher in his hand, all by himself. Corey Elijah, I don't think, registers that that's the person I originally saw, and he keeps on passing him. And as he continues, he passes by Joseph Rosenbaum, who at this point has taken his shirt off. He's got shorts on, and he's taken his shirt and kind of wrapped it around his head. And Mr. Rosenbaum is still carrying that plastic hospital bag and walking down Sheridan towards the 63rd Street car source.
Yeah,
the
sure.
defendant is behind him at some distance. As they get down to the 6200 into the 6300 block of Sheridan Road, that block on the west side of Sheridan has a house.
This is true. If anyone's watching in
right
a
at the corner of
just throw a wave in the chat so I can
and
say
then
hi.
On the south end of that block, the south half, is the car source lot. You will hear testimony from someone from the FBI who was up in a plane that night taking video, and we will show you the video. It is an infrared video, which means it picks up heat. This is at nighttime, so regular cameras, especially from an airplane, aren't going to be able to see everything. So the infrared helps us to see in the dark. The video picks up Mr. Rosenbaum. It is quite clear to see him because he is a white blob. Infrared picks up heat. He doesn't have his shirt on. So the cloth of a shirt would help conceal some of that heat, but when you don't have your shirt on, that heat radiates, and the infrared picks it up more clearly. So he's very easy to see in the video as a white dot. You see him running towards the 63rd car source. And behind him, running in the same direction, following him, is the defendant. As they get to the 63rd Street car source, there are some cars on the north side of that lot. Mr. Rosenbaum peels off behind those cars, and the defendant stops on the other side of those cars and turns towards Mr. Rosenbaum. Now, obviously, in an infrared video from a plane overhead, we don't know exactly what was going on at that very moment. We don't know what words were said. But what's clear is
that was a racist slur. That was a racist slur. That was a racist slur.
Started. It caused Mr. Rosenbaum to come around the cars and start running after the defendant. The defendant drops the fire extinguisher right there. and runs, carrying his AR-15. At some point during that foot pursuit, the defendant turns around, points the gun at Mr. Rosenbaum, who puts his hands up in the air. Now remember, he has got no shirt on. He's got his hands up in the air, almost like, what are you going to do? The defendant stops, pointing at Mr. Rosenbaum, continues to run. And right around this time, there is a gunshot from someone else, who we have identified by the name of Joshua Zeminski. This is an individual who's walking on the sidewalk, probably 30 feet away from where the defendant and Mr. Rosenbaum are running.
Oh, this will be interesting.
Mr. Zeminski, for reasons only he can explain, decided to take his handgun and fire it one time in the air. As I said, this is in a different direction and many feet away from where the defendant was. Mr. Rosenbaum continues to pursue the defendant, and we will have Detective Martin Howard testify that he's timed the gap between Mr. Zeminski's shot and the eventual gunshots is about 2.5 or 2.6 seconds. Mr. Rosenbaum closes on the defendant. The defendant turns and fires 4 shots at Mr. Rosenbaum. You will hear the testimony from the Milwaukee County Medical Examiner, Dr. Douglas Kelly, that Mr. Rosenbaum suffered 5 wounds total from 4 bullets. Dr. Kelly will testify that the first 2 wounds that were inflicted upon Mr. Rosenbaum were to his lower extremities. We're not sure which order they were in, but one was to his right pelvis, fracturing his pelvis, and one was to his left lower thigh. Dr. Kelly will testify that these wounds caused Mr. Rosenbaum to start falling face forward. And you will see video of his body where it is found. He lands on his face down on the ground. As he is falling, the defendant fires 2 more shots. One of them hits the defendant in the back, or I'm sorry, Mr. Rosenbaum in the back. And that is the shot that kills Mr. Rosenbaum, according to Dr. Kelly. You will hear testimony from someone by the name of Richie McGinnis. Richie McGinnis is a reporter who came to Kenosha to cover the events of that night. And at some point, shortly before these shootings, he encounters the defendant at 59th Street and interviews him. He talks to the defendant and then follows the defendant down Sheridan Road and is right behind the defendant as these shootings are occurring. In fact, he is in the car source lot. He is behind Mr. Rosenbaum when Mr. Rosenbaum is shot. And Mr. McGinnis will testify that one of those rounds came close to him, which is the basis for the count that we've alleged that Mr. McGinnis was recklessly harmed or placed in danger by the defendant. Mr. McGinnis will testify that when he saw Joseph Rosenbaum shot and fall to the ground, he immediately ran up and attempted to treat Mr. Rosenbaum. He took off his shirt. He used it to try and stem some bleeding. He rolled Mr. Rosenbaum over onto his back, and he's attempting to administer first aid. Many other people respond at that very moment to that location and attempt to help Mr. Rosenbaum. They eventually lift him up. They carry him across the street to Frederick South, formerly known as Kenosha Memorial Hospital.
If there are people out there that don't understand what the word smunt is, it's something that, whilst it did exist prior, I've coined it to mean stupid MF, see you next Tuesday. It's a way of getting around some of the YouTube's censorship. So you will hear me call people smunts occasionally.
KMH, which happens to be right across the street. These folks load him into a hospital SUV that's there in the back of it, and it races off towards the emergency room to try and save Mr. Rosenbaum's life. That's what Mr. McGinnis does. The defendant, after shooting Mr. Rosenbaum, gets on his phone, calls Dominic Black and says, "I just shot somebody," and starts running away. Now, one of the things that you will see and hear in this case is that the defendant throughout this entire evening held himself out as an EMT, as a medic, that he's carrying a medical bag with him, strapped to his body.
Hey, if the police
and
have
yet,
no duty
in this
to protect
time,
people, why would you?
Mr. Rosenbaum there on the ground,
duty to render
injured, potentially dying, the defendant offers no aid, but instead runs. He runs up Sheridan Road. He encounters another member of their group from 59th Street, who you will hear testify, by the name of Jason Lakowski. Jason Lakowski is similarly armed. He's a former Marine. He had been with the defendant at 59th Street and had come down in response to the gunshots. Mr. Lakowski will testify that he met Mr. Rittenhouse as the defendant was fleeing the scene. And Mr. Rittenhouse said to him, "I didn't shoot anybody, but I need help." And Mr. Lakowski says, "Head up towards the police." So the defendant starts running north on Sheridan. The crowd starts yelling, "That guy, the defendant, just shot somebody," because that's all the knowledge they have at that point. And it's true. So they begin to chase after him. They clearly believe he's an active shooter, and they try and stop him. And I've already described to you the events that follow. Mr. Huber, the unknown individual, and Mr. Grosskreutz. So when we talk in this trial about the nights of August 25th, we need to keep in mind the context of that night. We need to keep in mind the fact that there were hundreds of people on the street that night experiencing the same chaos, the same loud noises, the same gunfire, the same arson, the same tear gas, the same hostile confrontations with people who believe the opposite of them. And yet out of these hundreds of people, only one person killed anyone that night. Only one person shot anyone that night.
Yeah, because only one person out there was doing the right thing. The rest of them were there with their loot.
Of the defendant's actions. I ask you to keep that in mind. Now, in this trial, you are going to hear from a number of witnesses from the state. I've already told you about a few of them. We are going to begin the testimony with Dominic Black, and he will tell you a little bit about the acquisition of those guns. You will hear from Corey Elijah,
Shouldn't Dominic
who was
Black
live
just plead
streaming
the fifth on that?
night. You will hear from Detective Martin Howard, who worked diligently to gather evidence, including many different videos, many different photos of the scene that night. We are going to use that television to show you these things so that you can see them yourself.
By a white cop.
I know many of you alluded to the fact yesterday that you've watched or read things about this. You will get the full story here in the courtroom, and you will see some things that have not been made public yet. We intend to do that by moving the TV as central as we can so that you can see it as up close and as well as possible. And we will show you as much as we can about those nights, the events of that night. You will hear from the FBI individual who was in the plane taking that infrared video that shows the defendant chasing Mr. Rosenbaum and initiating that confrontation.
Fair.
You will hear from other individuals who took video that night. You will hear more about Joseph Rosenbaum from his girlfriend, Carrie Ann Swart. She will tell you about his hospital stay. She will tell you about that bag. She will tell you about what was in that bag. You will hear about Anthony Huber. You will hear that he was a skateboarder, that he lived for skateboarding, that he was at the skate park at Panoia Park all the time, that he actually knew Jacob Blake personally, that he came out that night because he wanted to show support for his friend, Jacob Blake. You will hear what sort of person Anthony Huber was. You will hear from other witnesses who've been affected by that night.
Except that he was a domestic
violence
violencer. You won't hear that one.
Who did a lot of investigative work to assemble all of the evidence against the defendant in this case. And you will hear from Dr. Douglas Kelly, who will testify regarding the cause of death of Anthony Huber, the gunshot wound to the chest. And you will hear that the shot that killed Joseph Rosenbaum was a shot to the back. And based on all of that evidence, I think you will agree with me that the defendant is guilty of all of these charges. Thank you.
Okay.
Go ahead.
Opening statements out of the way.
About a 10-minute break. Please don't talk about the case during the break.
All right. Yeah. So for my money, and I sense the chat will disagree with this, but so be it. I thought the opening was about as good as you would expect. This is top notch. It's not 10 out of 10. It's not like, creating new levels of brilliance but it's at the highest level of like a normal professional. So I'd say this is 9 out of 10 in terms of an opening. Some minor points of criticism for me. It was a little long for my taste. I think some of the points could have been shortened or perhaps omitted. That being said, I did like the overall idea of presenting the full timeline and full story. So I like the concept, but perhaps it could have been shortened a little bit. I liked his pacing. I liked his timing. I liked how he didn't step over some major points. Like when he made like a really emphatic point, he would stop for, 3 or 4 seconds to let the point sit. And so that was really good. I just think overall it was well presented, well argued. His tonality, his pacing, his word choice was overall extremely, extremely good. I found it very persuasive. That doesn't, of course, mean that I'm saying that I think that ultimately Kyle Rittenhouse is guilty. So please don't misunderstand me. But I think he did a exceptional job for a prosecutor. I thought it was very, very good. What do you think, Nick?
I basically fully agree. I mean, as far as the prosecution in this case has a really rough set of facts to make this conviction. They know they do. They have the context of a riot. They have a context of chaos. He knows that he has the context of these guys pursuing Kyle, reaching for guns. I mean, he's not trying to mitigate that. And it's pretty interesting, or he's not trying to ignore that. He's putting it in there. He's trying to mitigate it by getting out ahead of it. The fact that he has to stand there with a straight face and convincingly does so.
Oh yeah, I found him believable. I found him like he to me at least, he seemed like he believed everything he was saying.
Right. The fact that he has to, with a straight face, argue that Joseph Rosenbaum pursued Kyle Rittenhouse. Kyle turned and did not shoot him. Rosenbaum puts his hands up. He's like, oh, okay. And he backs up. And then a couple of seconds later has to admit that. And then some other guy shot into the air. And then that guy, and then Rosenbaum resumed pursuit of Kyle Rittenhouse. Like, he has to deal with that fact. And he does it really, really well at opening. Now, this stuff is going to, of course, keep coming through trial as the timeline is established, and particularly by the testimony of Dr. Black, because he's going to be the guy laying out the video timeline. One of the facts that he seems to be hinging this entire argument on is the predicate act of shooting Joseph Rosenbaum in the back. And I argued yesterday, I think convincingly so, that if whoever wins on Rosenbaum is going to win this case. Rosenbaum,
I think it's very likely.
Yeah, Rosenbaum is the hinge. And so except for the
confusing jury instruction on reckless endangerment, which God knows at this point, but carry on.
Right. But on the main murder charges and the Huber or the Grosskreutz assault charge, if you win on Rosenbaum, you're going to probably end up winning on the other two, because it goes right to his state of mind, what he reasonably believes. The interesting thing is it doesn't matter what Rosenbaum, Huber, or Grosskreutz believe. The reasonableness of their actions are not on trial. He wants to maybe put that reasonableness in there to try and confuse the jury. I assume the defense is going to focus heavily on the fact that it's about what Kyle perceived, not what anybody else perceived.
This is part of this issue is exactly what you were experiencing in the chat yesterday with the confusion from the chat from Kyle Rittenhouse's side. People were confused about this aspect, that we kept saying, oh, Rosenbaum, I mean, some of these people might be valid in self-defense. They might have a valid self-defense claim.
Right.
And some people on our side or Kyle Rittenhouse's side were confused by this. It's like they seem to be under the impression that if these people have a valid self-defense claim, it must necessarily mean Rittenhouse doesn't, which isn't true. They can both.
Yep.
So
No,
people who support Kyle Rittenhouse are confused by this aspect. So sure, why not confuse the jury? Because some of them probably believe that too. If he can demonstrate that these people were reasonable in their actions, he can try to infer that's necessarily true. Rittenhouse isn't reasonable.
Right.
So that would allow the jury to get to a guilty verdict if they have that same issue.
And
smart.
The trick for the defense will be reiterating and explaining and emphasizing on the jury instructions that it's Kyle's state of mind that matters in all of this. that the other people's actions, their perceptions are not relevant to this.
How well do you think that's going? We couldn't convince our own chat, yesterday, Nick. How well do you think that's going to go?
We'll see. I don't know. Maybe Richards is a really good lawyer. We'll have to see what. Or do you? I'm curious to see if Richards or Sharifsi is going to take the opening statement.
I'll obviously rate it for itself. The only part. Okay, so I want to say a couple other things. I thought it was very good tactically for the prosecutor to admit to bad facts.
Yep.
It's called drawing the sting, is a phrase you often hear in law. When you have bad facts, it's very helpful to you to get them out in front because the other side's going to bring them up. So you basically have two choices. Do I let the other side bring it up, or do I try to bring it up and try to create the initial impression that those facts, those are bad facts, but they don't really matter?
For the record, taking the sting out is almost always the way that I personally go, because there's always the opportunity for you to dull it, to mitigate it, to, as bad as it sounds, twist the facts if necessary. Hey, I'm a lawyer. I still have to do the job. It's very much a case of you want to be seen as the open, honest, and transparent one. Hey, yeah, there's this fact that goes really badly against my client, but because of this, and this is why you should ignore it. And that's almost always the most appropriate way to go through it. Unless there's defuse the bomb yourself. Unless there's something extraordinarily poignant as to why you would not do that. And I've never been in that situation. I've never been in a situation where it's been better to try and bury something as opposed to bringing it out ourselves and getting in front of it. So it just helps with the client's integrity, your own integrity, and how you look in front of people. So
I'm so confident in my case, I can admit to the bad facts and I still win. So it's generally true, and I think true here, that he is incredibly smart for making the defense's case for them, because many things he said will be things the defense will say. And that's kind of the point.
Yep.
He's trying to preempt that by I already said the same thing. I went first and it must be guilty. So, it's not like it's the first time you've heard this, not a surprise. So I thought that was very, very good. So, for people who don't understand why they're doing that, there's a very strong tactical consideration. And I think it was the right call. The only part of the argument that I thought overall was weak was the self-defense argument, because he correctly states the law of imminent danger to himself and others. Now, he tries to answer that by saying no one else shot anyone else that night. Therefore, Rittenhouse no one else, despite all the arson and rioting and blah, 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 no one else apparently feared for their life. Therefore, it must be true. Rittenhouse didn't fear for his life.
Oh, it hurts.
I didn't really feel like he didn't really feel like he satisfactorily closed the self-defense. He mentioned it, but I didn't really feel like he fully converted it to the end. It's a bit of a weak argument for my point. He's trying to argue from implication that because everyone else didn't shoot anyone else, and because everyone else was in roughly the same position, that Rittenhouse in his specific situation is not reasonable.
Okay,
and it's a little weak, but I don't know he could have done any better. So I'm still sticking with 9 out of 10.
Yeah, look, the burying evidence ethically is always an issue, frankly. Two state witnesses proved Kyle's innocence. Yeah. So, Caitlin Shute, been looking forward to this for weeks. So excited. Sorry I'm late, been at work, catching up now. No worries. Thank you for being here. Guys, remember, like, subscribe, double check that you are still subscribed, and hit the bell so that you actually get the notifications when we go live to this stuff.
Yeah, no, again, it doesn't mean that that they're going to win the case. It doesn't mean that it's the most convincing thing ever. It just means he did the job that he should do. And as a defense attorney, you would not want that guy. Don't want that guy giving opening arguments. You want pretty much any other prosecutor.
Fat ass would be good.
Yeah, because that guy seems just inherently unlikable. Right? Like, just from his posture and overall demeanor, he seems he's less charismatic, he's less likable, and he seems offensive and affrontive even. But no, Binger did a very good job. And you have to give credit where it's due because it's a consideration that the jury is going to take in. Now we'll see how the defense does. And
see if they can meet the challenge.
Hopefully they're going to make some very compelling arguments. I mean, he talked a lot about shooting in the back, which was a tactical choice. The context of that shooting in the back is what the defense has to show. And what Dr. Black's testimony, why it's so important.
I will,
the space between the shots that Kyle fires, it's bam, bam, bam. That's it.
Yeah.
Bam, bam, bam. No,
Close enough.
Bam, bam, bam. It's so fast. It's like a quarter second or less between each shot. So Rosenbaum is falling forward, and the shot that hits him in the back comes in at a downward angle. I mean, it's not like Kyle Rosenbaum was turning around to flee and he shoots him.
Fair enough. But, you know, then, of course, you can properly say he was shot in the back. Now, why that's true, I'm not going to necessarily mention right now, but it is technically true.
And
here's why from a ballistic standpoint.
He kind of does.
He kind of did.
Very. I mean, he was falling, so I mean that's why it went in his back. But he was shot in the back, and we don't.
Yeah,
I mean, that's a coward's shot right there. Is shooting a man in the back.
I think you know the chat is going to is calling him a liar and all the rest of it. And again, the chat's going to disagree with it. But I, for my money, didn't see anything he said was a lie. Everything he said, to my money, was a. Go ahead.
No, there was something early on. I commented on it. He lied about something. I don't remember what it was. It was very early in the argument, though.
Okay, yeah. Well, maybe with the one exception, if we ever get back to it, we can discuss that specific thing. But everything he said is a colorable interpretation of the facts. So, I thought it was about as good as can be done.
And
you would do well to study this as an advocate.
Absolutely. And to be clear to the chat, in case some people are confused, you typically don't object during opening arguments. It's very bad form.
It's very bad. And same thing for closing arguments. Objection is like,
unless the act is extremely egregious. Like
that's what I was saying before.
They make a highly prejudicial statement that has no foundation, will not be shown, or was specifically excluded in a prior motion. That's the only time you're going to get to object during opening arguments. The defense's objections, so to speak, will come when they lay out their narrative next. And so I just want, because I know some people are like, why isn't the defense doing something? That's why, because if you did, objecting during opening arguments can be a very negative thing from the judge and from the jury.
You know, the chat is suggesting that calling it a straw purchase might be a lie. In terms of
Leon's law,
in terms of like its more legal sense, probably, but in terms of a more colloquial sense, it's that might be something that is a little bit touching the line. But
the lie was him saying Kyle could not own the gun, which is not true.
That I didn't know. That it's like he came. I'm not sure about that one. So that might have been he misspoke or maybe something, but it's like that one does seem to be a bit of a problem. But I'm not gonna harangue the man for one sentence.
No.
In an otherwise brilliant opening, because
I am. He was doing at different times. He did outright lies. Now, for anyone that's wondering why those specifically weren't objected to, it's better to let him have enough rope to hang himself, basically, and then use the defense's opening arguments to poke as many holes as they like in whatever he said. And I'm really hoping and looking forward to that, frankly. So we're about 2.5 hours in, so we've got another hour and a half to go, guys.
I'm pretty sure the defense is going to make some mistakes somewhere. It's probably not going to be perfect. So,
we'll see. Maybe it will be. The judge will just go, "Oh my goodness, that was so
colorful
good."
Interpretation is accurate.
No, I'm just kidding.
Sure.
Let me read a couple of these chats. Stephen Cooper says, first night they cleaned graffiti. Second night he cleaned the neighborhood. Billy Witch Doctor 99 says, thanks for covering this, Nick and Uncivil. Hey, my pleasure. I assume it's your pleasure too. Maybe not though. Dennis Heaton for the donations.
Skip forward a bit.
Off the jiggling at a guy in the back as he was falling to the ground.
Yeah.
That is completely incorrect. And I don't know how to say it other than that's just wrong. Tommy TK says, Nick, he's extraction technique. It's why it's good. It's good for Binger to have put it in there. That's why he's mentioning these things. He wants to get the jury outside of the mind of Kyle Rittenhouse and into the mind of other people. But the state of mind of Kyle Rittenhouse is what matters. If Kyle Rittenhouse shoots Joseph Rosenbaum in cold blood, then with intent to murder, right, rather than intent to defend, then it changes Kyle Rittenhouse's state of mind for everybody else. Now he's not defending himself from harm. He's defending himself from being a murderer by murdering more. He's continuing his string of illegal activity, and he would know that. That would be part of the issue there. But if Kyle's defending himself from Joseph Rosenbaum, then he subjectively is carrying that fear into his going towards the police. And by the way, that was a really brilliant moment by Binger, if I must say so. He mentions an absolutely irrelevant fib that Rittenhouse allegedly says to the other guy. I don't know if he actually says this, but apparently the guy's going to testify that Kyle Rittenhouse says, I didn't shoot anybody. I just need help. And the guy says, run to the police. Right.
That was, the prosecutor said the opposite of that.
No,
the prosecutor said, I just shot somebody is what the prosecutor said.
No, that's what he calls his friend and says, I just shot somebody.
Right.
And then he encounters the former Marine guy who he was with at the car source. He encounters that guy and says, allegedly, I didn't shoot anybody, but I just need help. And so he says, yeah, head to the police, is what he said. Kyle said. Now, maybe he mistook that. Maybe
Yes,
I misheard it, but I'm 99% sure that's what he said.
Actually, that
well, if that's what a witness is going to testify to, then so be it. I mean, if that's what he's going to say, then okay, the prosecutor can rely on that.
But the brilliant part of that to me is he mitigates the fact that he's telling the jury that Kyle Rittenhouse is headed towards the police with a lie that Kyle Rittenhouse told about just shooting someone. It's because
so it goes to his credibility, which he told a lie to this Marine, so it questions maybe everything. So fair, reasonable.
Yeah, and we'll see if that if that bears out with the testimony. I'm not sure. It's possible Binger misspoke too, but I don't know. Let's see. So it says you're going to mention the manlet argument the prosecutor is making for Rosenbaum.
There is a point to be made, because when you're looking at self-defense, the relative threat profile of the people is relevant. So if you have a 5'3", 130-pound person, the amount of force that would be required is different than 6'10", 400 pounds or whatever.
He said 5'3", 150, which is actually pretty big for that height. 150 is and Rosenbaum is not like, he's beefy, he's burly, his broad shoulders, so yeah, it's an interesting question, but it was just funny the way it's like, oh no, everybody shorter than 5'3" just realized they're no longer threatening.
Short kings, right?
Yeah, short kings rise up. Oh, but except you can't.
Ooh,
that was rude.
Apparently, did take a couple steps like 2 or 3 months ago. So, yeah.
Let's see. President-elect Austin M says dismissing the possession charge mid-trial kneecaps prosecutor. I would agree. Oh wait, I read that one too. Not applicable says, could you imagine having to baby a 30-plus-year-old judge or 30-plus-year judge on how self-defense works? I'm glad people get paid to do this, so I don't have to. Freaking crazy. Look, arguing over jury instructions and arguing over the law happens with a lot of judges in a lot of instances. No, judge, this is what this means. Yes, judge, this is well established here, here, and here. It's just how it goes. President-elect Austin M says, arguing the endangerment might be good. It forces the state to call McInnes saying he was in danger. If not, it may collapse the whole prosecution. McInnes is the state's witness, which I think is a misstep by the state. Personally, I think that was a bad play. I think bringing the charge against McInnes and making him the state's witness is a bad play because McInnes is typically favorable to Kyle. And the other interesting thing about that, that I hope the defense puts together at some point, is the fact that Kyle fired 4 bullets, hits Rosenbaum 5 times because 1 bullet leaves Rosenbaum and re-enters at a different point in his body. Again, he's falling forward. So you can imagine it going through like a shoulder or an arm, and then into a thigh or something like that. I don't know. They don't know the order of the shots. But
there was a point in chat that I missed earlier in the analysis that I wanted to mention, if you don't mind. It is true in self-defense law that if you're like purposefully inducing someone to act in a violent way towards you, it can nullify the self-defense case. So I saw that in a case where there was a guy who shot someone outside a convenience store, I think, as they're going in or out. And on the video, it looked like self-defense. And I said so at the time. But as it developed, apparently this guy was coming like on a routine basis. And the assertion was that he was, through his actions, trying to provoke the action so that he could use self-defense. So that was one of the things the prosecutor is trying to get to, that Kyle was that he was in this hostile crowd. He knew it was hostile. He knew it was hostile to them. Therefore, he was trying to provoke an attack against him. Therefore, he loses his self-defense claim. So that's a colorable argument.
I think it's pretty thin to say that someone was present, therefore they were provoking.
Yeah, I wasn't. Yeah, colorable and thin. Yeah, it's just worthy of note. I try to give, in the chat, I just try to look from both sides of this analysis and just like, well, this is what the prosecutor. What's the best possible case? What's the best possible case for the prosecutor given what they just said? It's like, okay, here's how to make that work.
You have to understand there is a complete moron in the chat who has been running this theory for the past 6 months, desperate for attention. And he doesn't get that provocation tends to involve an overt act. Carrying a gun is not provocation. Being present in the crowd is not provocation. There has to be something more. The closest Binger can get to this is this alleged FLIR video that literally no one has seen outside of the 2 parties, apparently. This FBI FLIR video that shows, even though there's no audio and no resolution.
I'm curious what this could possibly show, because I'm just trying to imagine it in my head.
There is going to
be able to show something.
There is video of Kyle following Joseph Rosenbaum, incidentally, not specifically, towards the place where the shooting would take place. There's also, on that video, Joseph Rosenbaum meets up with the guy who had actually fired the first shot into the air. Joseph Rosenbaum meets up with him and is walking with him. So the prosecutor said, we have no idea why this guy fired the shot. Was he being called as a witness? I'm really curious if that guy is a witness, and we'll get to ask why he fired a shot into the air randomly that night. But there is video of Joseph Rosenbaum just before the incident meeting up with that guy and his significant other as they're walking to the same place. Kyle is about 20 or 30 yards behind them. They're not running. Kyle does not appear to be in any sort of pursuit. I don't know if that's what the FLIR video is covering specifically, but that is on non-FLIR video. I've watched it myself, so I know that's true. So I'm curious if that's the issue. If that's the issue, it will not show Rosenbaum. It'll show him jog up to the other people. It does not show Kyle running in any way that I've seen. So it'll be. I'm really curious to see that FLIR video. He's got a big hurdle that since there's no audio, it's going to be really hard for him to show that Kyle was definitely provoking Rosenbaum and not the other way around. There's a significant amount of doubt there, but without seeing the video, we don't know.
Right.
So that'll be interesting. Rick Nikita says, where's the whistle pig at? Hopefully you didn't drop another $400 bottle of whiskey. As I told you in chat, I drank all of that on stream. It was delicious. Thank you very much. Peter Bemis says, so Kyle's going to prison for 12 years for not shooting someone because of a bad read from the judge, McInnes was
like a
behind
minute
Rosenbaum.
left.
Oh, wait, I wanted to
Maybe.
get back to this point. Kyle fired 4 shots. All of them went into Rosenbaum. The interesting thing is the shot that apparently recklessly endangered McInnes would have necessarily come out of Rosenbaum, right?
Yeah.
So it's a weird thing to say that someone could be recklessly endangered when the bullet traveled through the intended target into someone else or near someone else. Like, it's not like he indiscriminately fired, missed 5 shots and hit 1, you know, and the 5 shots errantly went off into the crowd. You know, he shot the target. The bullet just traversed through the target.
It's yeah,
Okay,
but
so
the
there's no transfer
question,
malice. Yeah, that makes sense.
I guess the question would have to be at the moment you pulled the trigger, whether it was reckless, because you don't know. You may not, probably can't determine where the bullet's necessarily going to go because people might move and such and so forth. So
Yeah, but if you follow that argument, then every time you pull the trigger on a gun, it's potentially going to be reckless because, I mean, for a really stupid example, imagine you're out hunting and you take a shot at a deer. And, you know, I don't know much about guns, so forgive me if this sounds even more ridiculous than I'm intending it to. But if you take a shot at a deer, it goes over or through the top of the deer or whatever it pierces at. Point is, if it goes through and hits a guy that's sitting there in camo that's looking to take another shot at something else, have you just committed murder? I don't see any transferred malice there. You have to have the guilty intention, which is basically, you know, you can fire recklessly into a crowd with the intention of hitting somebody. But in this instance, it's, yeah, no. But, okay. Interesting.
is it
We also don't
reckless even
know-
though you hit what you're aiming at? That's a tough squeeze.
We also don't even know if it was if the bullet traveled in a straight line. I mean, AR-15 bullets tumble.
This is very true.
And if it's the one that hit
Your
the
Honor, before
pelvis,
we,
there's no way to
proceed to the defense opening. It's my understanding that counsel is going to be showing videos to the jury.
Okay.
These aren't evidence yet. I don't know what's going to be shown. And I think it's unusual procedure. I've often considered using exhibits in my opening statement, and I think it's generally.
How has this issue not already been resolved?
Yet, so we can't be showing them to the jury unless they're in evidence, and we don't have any of this in evidence yet. So I would object to that.
He does need to tell you what he intends to show. I got to turn things on here. He does need to tell you what he proposes to show, and me too. But the rule does not preclude their use during opening statement at all.
Just because you didn't know you could do it doesn't mean that's illegal.
The first slide is a jury instruction, part of self-defense. The second slide is a picture of Joseph Rosenbaum wearing the maroon shirt for identification purposes. The third is a video at the Ultimate Gas of Mr. Rosenbaum
Looks
having
like Rich
to be
got a haircut for
restrained.
this.
Okay.
Fourth is a still
I don't know that I'd
photograph
agree with that, but I'm sure you got a
of
basis for it.
Mr.
So.
Rosenbaum walking down the street after arming himself.
Hey,
with
Tom
a
Gillis, how you
chain.
doing?
The fifth is a picture of Joseph Rosenbaum.
Just to clarify, I was talking about a completely ridiculous situation where it would have been impossible to know that the individual was there. I mean, obviously, you're going to know who and where and what is being shot at. I'm specifically talking about if someone... Okay, so say someone miraculously materialized after you'd fired. In that absolute split second, would it still? But that's what I'm saying. It was a completely ridiculous scenario. But thank you. I appreciate your comment and your
Rosenbaum
super chat.
taken from the video at the Ultimate Gas Station of him and Mr. Zeminski.
This should be done at the judge's
The
bench, in my
sixth
opinion.
photograph.
Well, the jury's not
Once
there,
again,
so
a
Oh,
picture
jury's not in yet. Okay.
taken by Nathan DeBrune of Joshua Zeminski and Joseph Rosenbaum starting a fire at the trailer. And in that one, Mr. Rosenbaum is wearing a blue mask. Number 7 is a picture from
Yeah,
the
no, Carl, I
Ultimate
knew that
gas
much.
station, taken from a video of somebody who's commonly been referred to in this as Yellow Pants Man, Kelly and Joshua Zeminski, showing Joshua Zeminski armed with the weapon that was the first weapon fired at car source number 3. Number 8 is a picture for identification of Richie McGinnis. Number 8 is a picture of how Richie McGinnis was dressed that evening so he can be identified in the videos. Number 9 is Gaige Grosskreutz and his backpack, taken from a video that has been agreed to be introduced into evidence. Number 10 is a still photograph of Gaige Grosskreutz running down Sheridan Road towards my client, arming himself. You can see him pulling the gun out of his back waistband. Number 11 is a still photograph of Anthony Huber holding his skateboard.
Was a roll.
And then number 12 is a picture of Anthony Huber holding his skateboard, so you can see the whole skateboard, but dressed the same way as it is in number 11. Number 13 is Anthony Huber holding Mr. Rosenbaum back at the confrontation at Ultimate. Number 14 is the photograph of Jump Kick Man, the non-complaining witness, kicking my client in the head. 15 are 2 close-up photographs taken from that of the shoes of Jump Kick Man. 16 is a photograph.
What are those?
Of 11:40 p.m. when Kyle Rittenhouse is going out with Mr. Balch, and he's confronted by Yellow Pants Man and 3 other armed individuals that evening.
Yellow Pants
And those
Man?
photographs are blown up in 17, showing one individual with a noose, the other individual with rocks in each hand.
Hang on, wait,
and
what?
the other one.
You just gloss over that. Someone was walking around downtown with a noose? You don't think maybe that plays into a few different things? Like, holy shit. Yeah, okay.
A picture of the individual in the blue shirt armed. 18 is a video where Mr. Rittenhouse tried to return to the 59th Street car source and was stopped by law enforcement and the Bearcats. Number 19 is a still photograph taken from Mr. Rittenhouse at Ultimate as he's leaving with the fire extinguisher, his medical pack, and his gun, heading towards car source 3. 20 is the video, what's called the infrared video, with Kelly Zeminski, Joshua Zeminski, Rosenbaum, my client, and Richie McGinnis circled and identified. 11:48 is a still photograph of Mr. Zeminski's arm in the air, firing the first weapon.
I tell you what, with
the first shot.
To introduce this opening
22 is those individuals, that same photograph from the video, same video, a photo just a couple of seconds later with 2 circles, one identifying Mr. Rosenbaum in yellow and another one showing Mr. Zeminski with his arm raised firing. 23 is a video taken from, and I always forget this gentleman's name, Lucas Zanin, from 63rd Street, right west of Sheridan, which forms the south edge of car source. And that's what Kyle was running to. There's approximately 100 people there bashing all the car windows, in there with pipes, bats, things like that, jumping on the cars. And you hear the first shot, which is Zeminski's, and people kind of stop a little bit. And then you see Kyle, you hear the next shot, and all those people
You
start
see
taking
Kyle?
off from
Oh
car
my God.
source.
Is that what
24 is the
happens?
video where Kyle begins leaving car source 3 after the shooting. And on that video, you hear.
How long is this
somebody
opening going to be?
who's
I
been
mean, he's not
identified
opening
as
now. I'm just wondering when he actually gets to the opening. How
yelling,
long is that actually going to be?
kill him,
Sound
things
like
like that.
30
You
minutes
shot
at
him.
least.
25 is Gaige Grosskreutz' video where he runs up to Kyle. It's about 7 seconds. Runs up to him as he's running down Sheridan. At that point, Mr. Grosskreutz is unarmed. He asked Kyle what he did. Kyle said, "I'm going to turn myself into the police. I had to." Photograph 26 is from PG on the screen. Photograph of an unidentified individual in a white sleeveless, or what's kind of as a wife beater shirt, hitting Mr. Rittenhouse in the head, knocking his cap off. And then right after that, you see the next photograph from that video of circled Mr. Huber picking up after a skateboard, which he had used to strike my client in the head. The next photograph is a still photograph of an individual running up to Kyle as he's on the ground. There are several individuals in that photograph. One of those individuals being Jump Kick Man, approaching from Kyle's right.
Jump kick.
And the next photograph is him
term.
kicking Kyle in the head. 30 is the picture of the close-up of that and the shoes. 31 is a photograph of Mr. Huber striking Kyle Rittenhouse in the head with his skateboard held by the trucks in his right hand.
Oh, what?
The trucks of the skateboard.
Do I look like I skateboard?
They're called trucks.
Okay, the wheels.
Do I look like I
wheels?
The wheels. Yeah.
Wheels with his right hand while he's grabbing Kyle's gun, his
Whether or not
bare
you look
hand,
like your skateboard's sort of
touching
irrelevant,
Kyle's
right?
gun with his left hand. The next photograph is
It's not really up to the
depicting
defense or the prosecution to know
Man
what you do or
getting
don't
up
know.
from the ground. Mr. Huber with his hand once again
No,
on the gun going forward.
I already am liking
and still
Richard's
having a
strategy
skateboard.
here.
33
Because
is
Kyle's
close
case
up of
is
that
highly
photo.
visual. And so he's going to make it
34
visual from the start.
Is you can see the strap
We'll
on
see how he
Mr.
pulls it
Rittenhouse's gun being pulled
But-
taut. Mr.
I'm not
Gross
sold on it yet. We'll
running
see
in
how it actually
frame
manifests.
from the right of the frame. Next is Gaige Grosskreutz standing in front of Kyle Rittenhouse with his hands up. Kyle does not shoot. Next, Gaige Grosskreutz lunges forward with his right hand pointing directly, and that is when the shot is fired. And then there's a picture of Kyle Rittenhouse on the ground, individuals approaching him, one with a pipe, one with his hands up. He backs them off, does not fire. 11:51, him video trying to turn himself into the Kenosha Police Department and turned away. And the final is a photograph from the Antioch Police Department surveillance cam at 1:20 a.m. of Mr. Rittenhouse and his mother turning himself into the Antioch Police Department.
This is the most Wisconsin accent that has ever Wisconsin.
Witnesses, we've got the whole trial there. I thought the opening statement was supposed to be a summary of the evidence.
Yeah, this
the
is
evidence itself. This is I think we're up to 41 videos and photos that are going to be seemingly introduced through the testimony of Attorney Mark Richards. This is a highly unusual procedure, Judge. We will, both sides will have the opportunity to call witnesses to talk about these things. We will have an opportunity in closing arguments to characterize these things, but to give the jury what the defense considers, and I'm not conceding that these things are all the evidence, or even that a lot of these things are relevant, but for the opening statement to essentially be the entire defense case and all the evidence, showing it to them is highly unusual. I took the approach in my opening statement, and I guess I was not pushing the envelope as far as I should have, but it's always been my approach that I will describe what I believe the evidence is going to be, but I'm not the witness. I'm not giving them the evidence. That's what the testimony is for. We've had a stipulation as to the authenticity of a lot of the things that counsel has talked about. That does not mean that they're admissible into evidence. It does not mean we're conceding relevance to those things. And I anticipate that there will be some arguments as to the relevance of a lot of these things. We've already had some arguments about some of these things.
I think that
So, you stressed to the jury that the opening statements would be brief. It took 5 minutes for him to list all of those things, let alone what it's going to take to actually show them and play them for the jury. So I think as a general policy, Your Honor, and I understand it's not necessarily the law, but witnesses should be presenting evidence, not the attorneys in their opening statement. So I object to this procedure. I think it's
interesting.
It's overly long. It's duplicative of what the evidence is going to be. There'll be an opportunity through witnesses to present all of that. I think counsel should be describing what he thinks the evidence is going to show. That's appropriate. But showing them all the evidence.
This objection, you think
this
he's
way,
going to ask for
why do
another
we even need
recess to
witnesses?
reframe
At this
his
point, let's just
opening?
I'll get up and I'll play all the videos I want to play. I'll play all the videos they want to play, and then we'll just be done without any testimony. That's not the way this trial should work. So I don't think this is a proper procedure, Your Honor, and I do object to it.
Okay. Well, first of all, are you going to be able to authenticate each and every one of these?
All of these come from exhibits that have been agreed or stipulated to their authenticity.
And they're all going to be relevant?
They all are relevant. They've all been.
It sounded like what I've already heard about, by and large. The standard is not what you did or what you can do. The standard is what the law allows. And I can remember studying this 50 years ago that this was an acceptable
Schroeder should have taken the
with
innocent case
judicial
back then.
permission to make an opening statement. We see it more in civil cases than in criminal. It's not customary in criminal cases, but I've seen it done by your office.
Damn.
Ooh, by your office is a nice little burn.
In terms of the numbers. But on the other hand, there's a large number of crimes being charged and separate acts that are being asserted with respect to both the acts that the state alleges were unlawful and the defendant's claim of self-defense. So given that they do appear all to be relevant and they've been agreed as authentic, then I don't see any reason that I should interfere with his right to make an opening statement. Mr. Finger makes a good point in reinforcing my comment that this is supposed to be brief and informative. So
I
keep
don't
it.
think I'll be any longer than him, Your Honor.
10 minutes?
No, then
All
he
right.
was.
No?
Yes,
He said him. Any longer than him.
Filed,
Okay.
not
I was about
objected
to say.
to by the defense, is that there be no reference to any pending or prior criminal cases or convictions with regard to Joseph Rosenbaum.
Oh, bug off.
Fair enough.
The parties are aware, the jury is not, that there was at the time of his death a pending criminal case between Joseph Rosenbaum and his girlfriend, Carrie Ann Swart. And there was a bond condition that prohibited Mr. Rosenbaum from having contact.
Yeah.
The purpose of my motion in limine, which, as I said earlier, was not objected to by the defense, was we're not going to talk about that. Now, I made a reference in my opening statement to the fact that
What are you thinking about this bird American flag
Miss Swart
pin?
that night and was basically was not allowed to stay with her or was not able to stay with her that night, so he left her residence. And I purposely worded it that way, Your Honor, because there are many reasons why someone may not be able to stay at someone's residence. It could be because of a bond condition. It could be for a myriad of other reasons. It's my understanding from an off-the-record discussion with counsel that he intends to go into this. He believes I've opened the door to it. I wanted a pretrial ruling from the court on this issue. We got one. And I'm now raising it because if it's going to be mentioned in the opening statement, I think this is the time to address this issue rather than in the middle of an opening statement.
You can anticipate the objection.
Again, I do not believe that my statement opened the door to it. And frankly, my statement is not evidence. So I don't know that it can really open the door anyway. But by and large, I was very careful in the way I worded that. And I don't think it opened the door. I don't think, regardless, this is a relevant issue for this trial. Mr. Rosenbaum's conduct with regard to Ms. Swart has nothing to do with what was going on the street that night. So it is completely irrelevant. And I would ask that the court reaffirm its prior ruling on my motion in limine.
Why couldn't he stay with her?
Ways. He can't go and say he was at the house and he couldn't stay there.
Given that there'll be four of them on screen, I think
why can't we tell the jury why? Because there was a no contact order. It's not appropriate. He thinks he didn't open the door, but he danced through the door. And he also talked about the hospital, got out of the hospital. He was in a mental hospital. And he's going to put her on the witness stand and we're not going to get to ask that? That's insane.
It's a tough call.
Hospital, Your Honor. I believe it was actually St. Luke's in Racine, which is a medical facility. It is not a mental institution. This wasn't Mendota or Winnebago or something along those lines. And frankly, I'm not even 100% certain why he chose to check himself in. But again, whether or not Mr. Rosenbaum needed a new kidney or needed medications for mental illness or was going in to have his blood pressure checked has nothing to do with the events of this night. And frankly, it's just a backdoor way of attacking his character and suggesting to this jury
that's the ultimate problem.
Because
it is. That's the ultimate issue.
Is
it character
some
issue?
sort of mental illness.
Yeah.
That had something to do with his behavior that night. I'd love to hear an expert on that, I guess, if they want to try and present that, and we can go down that line and we can talk about whether mental illness contributed to his behavior. What was his diagnosis? What medications were he on? We could open that door and go all the way through it, but that's a mini trial on an irrelevant issue. And if it's going to come in, there's a way to get it in through an other acts motion, which was never filed by the defense. And I certainly have not opened the door when I talk about the word hospital. This could be COVID treatment. It could be a kidney transfer. It could be anything. It does not open the door. And again, I was very careful in the way I worded that, Your Honor. You know, if I start talking about his medications, or I start talking about,
a bag
you know,
of his belongings
seeing a
from a
psychiatrist or
hospital
something like that. That's
you
different.
brought up.
Hospital is a
I think the prosecution might have the better end of this one.
nebulous
Might
term
be.
that could mean
I just think
a
it's
myriad of
interesting.
things.
You know, help me out here. I thought when I read the pre-trial motions, and I know there were a series of them on which there was agreement, so I probably may not have the best recall of those because I didn't have to put too much thought into it. But I thought that the references or the statements which were attributed to Mr. Rosenbaum were, "I just got out of jail today." You're telling me that there was also a discussion about hospital? No, or
there's no video or statements or audio of Mr. Rosenbaum talking about the hospital. The only relevance it has, Your Honor.
Well, wait a minute. I mean,
You brought the bag up,
Sure.
dude.
is there testimonial? Are we going to hear testimony that he made statements that he had just gotten out of jail that day?
There's going to be statements to that effect.
Okay.
My
And in
understanding.
fact, your statement on your opening statement was, and I will tell you this. I'm going to ask you to try to reconstruct from your, if necessary, I'll have the reporter read it. But I don't recall the exact statement. I do know that I thought at the time, I'm surprised he's going into this because it may trigger a response. So what exactly did you tell the jury?
What I said, Your Honor, is that Mr. Rosenbaum had gotten out of the hospital that day
Right.
and was carrying around a plastic bag,
Right.
which is the kind of bag that hospitals give you to carry around your personal belongings. The only relevance that has to this case
Well, I
is
don't know.
that's
I
the
just
bag.
wanted to get
Sure.
the statement.
And I
Now,
was doing that because
okay.
the bag comes in. And
Okay.
that's the only
I understand.
relevance.
Okay, now, and you also made a statement about his being with the person by whom he was allegedly bound not to have contact.
That's true.
And do we know the exact scope of that order?
I believe it was a straight, typical,
Don't
no
tell me
contract.
typical. No.
We can look it up, Your Honor.
Yeah. Well,
better.
what did you say about it? What did you say about it?
What I said is that he had seen her after he got out of the hospital,
Right.
that he couldn't stay with her. And so then he left and essentially came downtown.
That's
and
right.
Ms. Swart
That's what
will
he said.
testify.
Why
And
did
she
you
will
say that
talk.
he couldn't stay with her?
I'm sorry?
Why did you say that he couldn't stay with her?
I said that because it explains why he left and came downtown. He's got a hospital bag, Your Honor. It's a little unusual, I think, for someone to be released from a hospital, have a bag of their personal belongings, go to their girlfriend's place, and then continue to walk around with it.
It's unusual. Maybe
a
the
little
jury
unusual.
wants to know
We
about
know what was really going on.
And by the way, how do we know that he had been there and had left? Is she going to testify?
Yes.
Okay.
Yeah. And so she's going to talk about seeing him. She's going to talk about that bag, and she's going to say she saw what was in that bag. And this comes into play, Your Honor, because this is the bag that was.
But you're not going to be able to ask her, do you know why he left your house?
Cocktail, or it's got chemicals.
As a cross-examination question?
Burying himself on this.
It had toothpaste, mouthwash, a water bottle in it. That's the narrow.
Had a water bottle in it? Water bottles are dangerous weapons.
The relevance is not something I want to talk about now. I want to talk about what you said and why he thinks it is worthy of response.
He's misrepresenting the facts of the case to the jury by saying hospital when it was a mental hospital. Mr. Binger knows full well
Why isn't that a hospital?
he had gotten out for a suicide attempt.
So?
And
It's a hospital.
and let the jury know what type of hospital it was. Why he was acting the way he was. He was not acting appropriately. That's part of the defense. And, and then he goes and says, can't stay there. Why can't he stay there? Because there's a court order that says he can't. He wasn't supposed to go there in the first part.
True.
If he was on trial for violating his bond, then we'd have that trial. But he hasn't been tried or convicted of that.
Brought it up though, Binger.
He went there.
Your Honor, and by the way, we have the bond.
This is a tough call.
No contact, including the residence, electronic or third party, with Carrie Ann Swart and the Park Ridge Inn, which she stays there. And they had been staying there together until that criminal case started. So, you know, if we wanted to charge Mr. Rosenbaum with violating his bond, what good would it do? He's deceased. But yes, that is true. But again, it doesn't make him a criminal on this evening. It doesn't make his behavior.
He literally does if he violated the no contact order.
I don't think, as far as your opening statement, you need to respond to his statement about the hospital. I'll have to separately decide at a later point as to whether he had been hospitalized and for what. I don't know if that's admissible or not. I suspect that it is not, but I'll keep an open mind. As far as his not being there or not supposed to be there, again, I'm not sure that I want to hear about that in your opening statement. Again, I'll hear you later as to why do you think
that's going to come up on cross, though.
Yeah, you would think it would be a proper question for cross for the girlfriend.
And he's trying to say,
and here we see Bruce kicking it down the
being at home. He couldn't stay there.
The can down the track.
Well, the jury should know why he couldn't stay there.
Sort it out.
Well, I don't know. If he can't stay there, he can't stay there. She could have kicked him out because she didn't like his having a hospital bag. I don't know.
But that's not what happened.
I'm not sure it's necessarily relevant. He was where he, like the defendant, was not supposed to be, allegedly, and we'll let it play out.
This is really a close call.
Things in your opening
because
statement. Anything
this
else?
is all character evidence
Okay.
that's not normally admissible.
Yeah.
Thought
But as
Binger
I said,
may-
I thought the prosecutor had the better end, so I think the judge's decision is correct.
Would you come down, please?
Thought for a minute Judge might let it in the way he was like, well, it's like, ooh.
Yeah.
I think that stuff's open to
That it doesn't come
later
in
on.
now makes sense, but how you're going to keep that out of cross with the girlfriend on the stand seems, yeah.
Yeah, there's
like
no way.
You can ask her, did he come to your house? And it's like, do you know why? Or it's like, did he leave? Do you know why? And it's hard to imagine that the restraining order doesn't come into a cross-examination question.
She's going to testify to what's in the bag. Where
Do you know why he was in the hospital?
Yeah, where'd he get the bag?
If she knows, she's just a girlfriend, so privilege isn't an issue. If she knows independently, privilege isn't an issue for medical privacy. So isn't that a proper question for cross-examination?
Yeah,
but it is a character. So it makes sense to exclude it now. I'm not 100% sure on the issue of when she's on the stand is where the more interesting fight is going to happen.
The reason it makes sense to exclude it now is because they could decide to not call her.
That too.
That's the big one. Or they could decide to avoid the line of questioning entirely and have her testify to something else. I think part of the prosecution's issue is that they here's the crazy thing. I think he may have opened the door on Huber in his opening argument, now that I think about it. He loved skateboarding. He just loved to skateboard. He knew Jacob Blake. He was there to show support. Now do you get to impeach his character? Did you raise character as to why he was at this protest in the first place? Like, he's just helping out a friend. He just loves to skateboard. Now do you get to start saying, well, you know, this guy who loves to skateboard and just helping a friend has a criminal history and is engaged in further criminal acts? I don't know.
I did love his ruling on the video, though. He's like, well, you've agreed it's authentic and it's relevant. So basically, I'm making that determination now. So he can bring it in. Like, the law allows it. Why should I stop him?
All
right.
Dealing with what do we got?
The big problem with prosecution's case, the big hurdle, I should say, is the prosecution has to manage not raising the character of these people because their histories are problematic for the jury. Okay.
Good morning still for the next 10 minutes. This is my opportunity to tell you and show you what I believe the evidence will show. You've heard the state's opening statement, and now I will give mine. We have two very different outlooks on the events of August 25th of 2020. Kyle Rittenhouse was present in Kenosha, Wisconsin on the evening of August 24th. He stayed at his friend's residence, Dominic Black. He saw on the live streams and things like that the events of the 24th. He saw a car source, number one, as I refer to it, the one that's on the east side of Sheridan Road, burn, all of the automobiles burned, destroyed. He saw the looting going on. He saw the other businesses burnt down. And the next morning, he went down to downtown Kenosha to look at the damage. He stopped and he helped clean up at the old Ruther High School. I think it's called something else now, but when I was around here, it was called Ruther, and before that, Bradford. And he saw that. He met one of the owners from Car Source, and they talked, and they decided that they would offer their services, him and Dominic Black and Nick Smith, to help protect the property of Car Source. Ladies and gentlemen, the evidence will show, in spite of what the media and public statements and things like that have been, the evidence will show that Kyle Rittenhouse had strong ties to Kenosha. His father lived in Kenosha. His mother lived in Antioch, Illinois. Kyle worked here in Kenosha County at the Recplex in Pleasant Prairie as a lifeguard. He went downtown to clean up the graffiti. Him and Nick left there, and they decided to come back that evening and help Car Source Lot 2, which is at 59th and Sheridan, and initially Car Source 3 at 60th and Sheridan. And when they were doing that, they met other individuals who had come to town at the urging of websites and things like that, and then just a general, I would say, distaste for the destruction. And those guys from the West Bend area, Ryan Balch, Lakowski, Joanne Fiedler, agreed that they would all help protect the Car Source lots. And initially, they went to the lot.
Please stop starting your sentences
early in the evening. And what will end up
he does it
being,
immediately.
You will see the events of that night unfold in video and still photographs. But ultimately, what this case will come down to, it isn't a whodunit, when did it happen, or anything like that. It is, was Kyle Rittenhouse's actions privileged under the law of self-defense? That is, that the defendant believed that there was an actual or imminent unlawful interference with his person. The defendant believed that the amount of force which he used or threatened to use.
What happened to the other guy we saw yesterday? He's still at the council table. He was better.
The interference, and that his belief was reasonable. You as jurors will end up looking at it from the standpoint of a 17-year-old under the circumstances as they existed on August 25th of 2020. And Mr. Binger makes a big thing out of Kyle Rittenhouse was the only person who shot somebody that evening. True. Mr. Rittenhouse was the only person who was chased by Joseph Rosenbaum that evening. This is Joseph Rosenbaum. And what's important in this photograph,
as unbearable as this
one,
guy sounds, you got to remember he sounds like a
identify him
Wisconsin.
throughout the course of trial.
And these people
Notice
all
the
live in
belt,
Wisconsin.
The baggy, lengthy jeans. And there will be a fair amount of testimony, I'm sure, regarding the maroon shirt. He's obviously currently wearing it. Mr. Rosenbaum was at a location, and Mr. Rosenbaum had, along with other individuals, started a dumpster on fire. And when somebody put that dumpster that was very close to a gas station out, Mr. Rosenbaum became enraged.
I wish we could see the video. Was that Colin Kaepernick in the video?
Does it sound on?
I just saw a giant afro.
That's just a brief snippet of that.
They got the shoot me
interaction.
N-words in there.
And he was upset, and he's yelling that he wants to be shot. And you'll see individuals in the full video, which you'll see in the course of the trial.
I'm going to start making a note every time he starts
holding him back, trying
You don't have enough
to
paper.
stop him from getting at an individual who is dressed with a baseball cap, an AR rifle, and long pants. Excuse me, short pants. Who looks very much like Kyle Rittenhouse. Here's Mr. Rosenbaum during the evening. Him and his friend or associate, Joshua Zeminski, had just come from starting a trailer on fire. He arms himself with a chain and goes up and down Sheridan.
Better get the little one ready. So I'll be back in a minute.
Carrying this rather heavy chain used to tie down equipment.
There's 4 minutes left to be at
Next
10
is a
minutes.
still photograph taken from the ultimate gas station where he was shouting, "Shoot me, nigger, shoot me, nigger," at a Black Lives rally. Who is that behind
Dropped
him?
it.
Joshua Zeminski. The evidence will show
Demonetization.
that Mr. Zeminski, also named as Alec Blaine, and Mr. Rosenbaum are together.
He dropped the
throughout
hard
the
R.
Joshua Zeminski plays a central role in this scenario on August 25th. One, creating chaos and havoc with Mr. Rosenbaum. And two, more importantly, when we finally get to car source number 3, Mr. Zeminski is the individual who fires the first shot that evening behind Kyle Rittenhouse as he's being chased by Mr. Rosenbaum. Here's a picture with 2 circles. Mr. Rosenbaum and Mr. Zeminski starting the trailer on fire on Sheridan Road along with the dumpster. You see the photograph, the second one circled. Testimony will show that that is in fact Mr. Rosenbaum wearing a blue mask, not his shirt over his head, and carrying a bag, which I'm sure there will be much testimony about. Other individuals.
Sorry, he's salty as hell.
Once again, Mr. Zeminski. In the photograph taken at the ultimate, this is a still from one of the videos you'll get to see, is Mr. Zeminski armed with the weapon that he ultimately fires at the car source 3. The individual with the red hair is Kelly Zeminski. She has a backpack and there's a circle on her hand with a big, heavy flashlight. As you can see, there was no need that evening for a flashlight other than it being a weapon. Count 2 is an individual by the name of Richard McGinnis. He was a
There's no need for a
reporter
flashlight at night.
covering the riots in Kenosha. He had covered the
Well, it's called
riots
arson.
in Portland, Minneapolis. And he will tell you what he's called to the witness stand by either the state or myself, that he was dressed like this that night. the black t-shirt with the white back, the helmet on his head. And he had interviewed Kyle Rittenhouse and talked to him. And Mr. Balch and Rittenhouse were going to go out and see if anybody needed medical attention that evening. And Richie McGinnis was going to follow along. He will testify that he goes out with them, and eventually they have an interaction with the individual who we refer to as Yellow Pants Man. This is Gaige Grosskreutz, the individual who is the victim, or excuse me, the complaining witness in count 5. I apologize. And in that photograph, you see that he's wearing a backpack and he has his cell phone in his hand, as he does throughout the evening, filming. Photograph 10, excuse me, the next photograph, is the evidence will show Gaige Grosskreutz running down Sheridan Road, and you see his hand going into the back of his waistband, pulling out a firearm to arm himself. The evidence will show, through testimony of an individual by the name of Nathan DeBrune, that yellow dot right up there is where Kyle Rittenhouse
You mentioned the word
is.
victim, which I
They
missed,
chased him
but
down
apparently.
Sheridan Road. Mr. Grosskreutz is not in any danger. Kyle Rittenhouse has already told him that he's going to turn himself into the police, yet he arms and continues with the mob to attack. This is a picture of Anthony Huber, the individual who attacks my client as he's laying on the ground after being kicked in the head by Jump Kick Man with his skateboard. He's hit him with the skateboard as he was running down Sheridan Road, and then as he's laying prone on the ground, he comes in for another hit on his head and then grabs Kyle Rittenhouse's firearm to try and take it away from him.
I think Jump Kick Man is one of the most
Next
brilliant
photograph
things the
is a
defense has
picture
done so far.
To look at the whole skateboard, the size of that skateboard, the trucks of that skateboard. Ladies and gentlemen, I would love to be able to hold up that skateboard in front of you as evidence today, because then you could see it. You could see the weight and the heft of what a skateboard is. And what that skateboard would do is somebody takes it in their hand and swings down on somebody's shoulder, head, and neck, trying to separate the head from the body, as Mr. Huber did.
He's trying to decapitate?
Here, Your Honor, this is straying beyond a characterization of the evidence, and it's Mr. Richard's interpretation. It's an argument.
You'll see the
What a
photographs.
fucking dick.
You'll see the videos, and ultimately, you'll.
Why doesn't he have the skateboard? He said, "I'd love to show it to you." Why don't they have it?
Trying to do. Skateboard doesn't exist because Ms. Giddings, his girlfriend, in spite of repeated requests by Detective Howard, refused to produce it. That's what the evidence will show.
Warrants, my
Mr.
friend?
Huber at the Ultimate Gas holding back Mr.
Yeah, that objection was
Rosenbaum,
overruled, but
who is ultimately
objecting it all was
the
bullshit to
individual
me.
who lit the fuse that night. Man I refer to as Jump Kick Man or the non-complaining witness. Kyle is laying on the ground after being knocked to the ground by an individual hitting the head with a rock, Anthony Huber hitting him with the skateboard, and Jump Kick Man comes in, kicks him square in the face with his black boot. Close-ups of that. And as he's kicking him in the face, Kyle fires 2 shots at that individual. He's not hit. He gets up and he runs away into the night, never to be seen again, never coming forward to identify himself as a victim, complaining witness, or otherwise to law enforcement. We looked for him, the evidence will show. The state looked for him, the evidence will show. Those are the big players in this case. But ultimately, what you'll end up having to decide, looking at all the circumstances of that evening, are the events that occurred over really a brief 15-minute period, but more importantly, 3 minutes. The police spread or push people south to approximately 60th. That's something we can agree. There's no line set up to stop Kyle or anybody else going in a southerly direction down Sheridan Road. There's no statement that if you go in that direction, you can't come back if you have business in that direction. Kyle,
bring it to the podium.
An individual by the name of Ryan Balch, followed by Richard McGinnis.
Well, maybe you can't.
Go down there, Sheridan Road. And at 11:40, they have a conversation yelling medic. And you'll see the videotape of this event. Kyle's got his medical bag, his gun, and he comes upon these three individuals. And the individual in the yellow pants accuses Kyle Rittenhouse of pointing a laser sight from a gun at him. Kyle shrugs it off, does not want confrontation with these individuals, does not point his firearm at them, and he leaves. Why does he leave? Because he doesn't want trouble. These are the three individuals who are with yellow pants. One individual is carrying a noose. I don't know what that's for. The other individual, the testimony will be from Kyle Rittenhouse and Richie McGinnis.
Wait, Kyle's going to testify?
And then the blue-shirted individual was carrying a 9mm firearm.
Is that what he said?
Richard McGinnis will tell you about the marauding nature of these individuals. He was so intimidated by them after Kyle walked away that he had to give up 2 White Claws to him to settle him down and some cigarettes so that he would be
What the fuck are we talking about?
Kyle, from there, realizes he's been separated from Mr.
Calm down,
Balch.
have some White Claws.
He goes over to the Ultimate gas station looking for Mr. Balch and is unable to find him. What happens next is he attempts to get back to Car Source at 59th and Sheridan Road.
We're 4 minutes
Kyle
from
on the
20
right
minutes.
coming into the frame.
But Bingers is about 15 minutes, I think.
It was a very different experience living those two speeches.
I work in that business. I am at that business.
They don't let him pass. He goes back to the Ultimate gas station, and a few minutes later, at approximately 11:45, he receives a phone call from Dominic Black. Dominic Black informs him, the evidence will show, that they're breaking windows and starting fires down at Car Source 3. Go and stop them. He asks an individual for a fire extinguisher and asks the individual to go down to Car Source 3 with him. The individual gives him the fire extinguisher, but does not go with him. And Kyle heads down to Car Source 3.
So
he doesn't know
to go. That's
that Mr. Rosenbaum is down there. He's been asked to go down there by Nick Smith. He heads down Sheridan from 60th, walking to Sheridan and 63rd, where the Car Source is. That's a picture of him from a video leaving the Car Source at 11:46 p.m. approximately. He has his firearm, and he has, as you can see in his other hand, a fire extinguisher to put out the picture, the fires and that are being started down there. This is an aerial photograph that the state had referred to in its opening. And it's actually started to roll, and you'll see circles in here. There's Kelly Zeminski in the green lettering, and that's a thermal image, excuse me. I don't think I can start it. It starts very slowly.
This is the problem with tech.
You can see People are labeled Richard McGinnis, Richie McGinnis, and they head down.
Oh, this is the thermal imaging from the FBI.
Which we can't see, which is lame.
You see Mr. Rosenbaum come around. I'm hiding in the cars, beginning to chase my client. You'll see the flash of the firearm from Mr. Zabitsky.
Oh, thank God.
Oh, thank
You'll see
you.
the flashes of his first shots.
Not focused at all.
I'm not responsible for cutting this video. I don't know how it got the way it did chopped up. That's the FBI up in the plane that took this video. But it's very telling.
The
because
FBI
you'll see
delivered
this
an edited
100
video?
times. I'm not going to go through it again for you in opening. But you'll see it that the individuals are heading down Sheridan Road, and you'll see this.
They should have just objected to this video.
It's now over here. Go
Sure they did.
right in this location. You'll see Kyle come into this area and pause where Mr. and Mrs. Zeminski are. And you'll see in this car is a fire that started. See
Move your head.
Move, Binger.
Kyle runs in this direction, trying to get away from Mr.
Well, I'll look at this one instead.
Ladies and gentlemen, Kyle Rittenhouse is under no obligation whatsoever to retreat from Mr. Rosenbaum. He does. He runs away from him because he doesn't want a confrontation. He doesn't.
I can't
want
see
trouble,
shit in this still.
which makes no sense.
Good, because the jury
What
can't
state
either.
says about him hunting.
If that's
or
their big
chasing
evidence, that's
him down.
actually probably great.
He's trying to get away from the individual. You'll hear testimony, not just from Kyle Rittenhouse, but Balch, Mr. Balch, about Joseph Rosenbaum.
I want to take a bet on the probability the
Kyle?
cameraman shows the jury at some point.
And to Ryan Balch in each other's presence. If I get either of you two alone, I'm going to kill you. Flat out threats to murder. When Mr. Rosenbaum is shot in the car source lot 3, there's been a gunshot behind Kyle. He turns to address Mr. Rosenbaum of his firearm. Mr. Rosenbaum is not deterred. He continues to run. You'll see that on numerous videos, closing the distance. Mr. Rosenbaum could have stopped at any time. Mr. Rosenbaum is wearing that maroon shirt on his face as a mask, covering up his identity because he wants to steal my client's firearm and use it against him to carry out the threat he had made earlier. That isn't just the word of Kyle Rittenhouse made up after the fact. You'll hear the testimony of Richie McGinnis, who was close that evening. He was following behind them. You'll see him on the video. He'll testify to you in court. He did not feel in danger. He was doing.
No, it's fine. I heard it. Don't stress
He will
about it.
testify that Joseph Rosenbaum.
I'll take my phone with me and listen.
As he put it, one of the scariest screams
I
I
have to do
ever
that.
heard, yelling, "Fuck you," and dove for Kyle Rittenhouse's gun. Kyle Rittenhouse fires. He fires 4 shots at Joseph Rosenbaum. The state wishes to slow everything down into a microsecond. Those 4
Weird
shots,
phrasing.
the evidence will show, took 0.76 of a second, 76 hundredths of a second from first shot to last shot. Those shots will be those measurements will be put forth by Dr. John Black, who's a certified video examiner. He breaks every frame down. He knows how much each frame takes.
Mm-hmm.
He counts the frames, and he comes up with that time.
Yeah, I'll bet, Rabbit.
I think that was a
That's
little
photograph
unnecessary. Just could have stopped at
11:48.
0.76 seconds.
That's car source 3.
I don't know. I think it added a little something extra.
Individual right here with his hand in the air. The evidence will show that's Mr. Zeminski. This is Mr. Rosenbaum in full stride running after Kyle Rittenhouse. This is a still from a video. And you'll see a lot of videos leading up to this. You'll see a video, I believe it's from Corey Elijah, where he's confronted by Mr. Rosenbaum. And he doesn't want a confrontation. He goes, you'll hear it on the video. The video is not showing that confrontation, but you hear Kyle's voice.
Constipation comment?
Friendly. He thinks because he's giving medical attention and helping people out, that people don't have an animosity against him. He's wrong, but that's the belief in his head, and Mr. Rosenbaum chases after him. And I believe
sounds like Kyle's going to be testifying directly to his state of mind. I don't know if I agree with that.
He went down there because Nick Smith asked him to. Why didn't he keep running? One, you don't have to run. But two, I'll show you a video from 63rd looking back onto the car source lot.
Oh, okay.
Taken
People actually cared.
by an individual who will testify and his daughter. Next
How do you
photograph.
make showing the video boring?
Again.
That's what I want to know.
Zeminski with the arm up, Rosenbaum in full stride chasing and an arrow
Everything can
pointing
be-
to Kyle. This is the video from 63rd and Sheridan Road.
Oh shit. They shooting. You shoot. Oh my god. I am.
You'll see that whole video during the trial.
What does that video
pointless.
show?
Individuals
What does that video
trying to
show?
reverse the
Video
rioters,
shows nothing.
destroying all of those vehicles. As Kyle was running from Mr.
I feel
Rosenbaum,
like that might have been a bad choice.
he did
honestly.
not want to run
Maybe we
into
weren't
those
paying attention to
rioters
them
who
bashing
was
windows or something.
destroying all of that property that did not belong.
Should have highlighted
But
that
even if
before
people in the
showing
crowd
video.
And the
were,
first gunshot, the evidence will show Mr. Zeminski. You hear 4 shots in quick succession. The evidence will show that is Kyle firing at Mr. Rosenbaum as he's trying to take Kyle's weapon from him to use against him. You hear 3 more shots in quick succession. I don't think the government will have any dispute. I don't think the evidence will dispute. Those 3 shots are from another person who's in the car source lot firing for some reason. He was never identified, never arrested.
That was interesting how he phrased that.
This will
It
show
wasn't the
Kyle
prosecution,
running
then it was the
back
government
to the scene of the shooting.
positioning
will
them as
show,
anti-Second
I
Amendment.
think
morals,
the evidence will show
which I think is
why
hilarious.
Kyle Rittenhouse didn't stay and render aid for Mr. Rosenbaum. Not that he's under any obligation to do that, but sometimes discretion is the better part of valor.
He fucking shot him! Get him there! He fucking shot him! He fucking shot him! He fucking shot him! Take 3 shots.
how is that helpful to the defense?
That dude shot him.
Showing why he's,
That nigga just shot that dude.
why he's running.
Cranium that
Okay.
Cranium that dude. He
Individuals
just shot
were
him.
yelling, he just shot him, shoot him, and you can see one of them with a gun, Mr. and Mrs. Zeminski. He begins running down Sheridan Road. He's not taking his gun. He's not threatening anyone as he's running down Sheridan Road. He's running in a southerly, excuse me, I always get my directions confused, a northerly direction from 63rd towards 60th. What is at 60th? The evidence will show that is where law enforcement is. And that's where somebody would run to be protected from a mob that wants to kill him. The evidence will show this next video taken from Gaige Grosskreutz.
I think we're coming up on
He
40
runs
minutes
up
here.
to Kyle. At this point, he is unarmed. Kyle does not point a firearm at him, does not do anything to dissuade him from approaching him. You'll hear on the video the exchange, and you'll see it.
Hey, what are you doing? You shot somebody? Who shot? Who shot? Hey, stop him!
You see him running the gun at the ground away from Mr. Grosskreutz. Mr. Grosskreutz came up on Kyle, got very close. Did Kyle point a firearm at him? Did Kyle shoot at him? No. All he wanted to do was get to the police. But the mob is closing in, of which Mr. Grosskreutz is a member. First individual runs up behind Kyle and hits him in the head with his hand or a hand with a rock in it. This yellow circle shows Kyle being knocked a bit askew. More importantly, his hat being knocked off. He's run all this distance. His hat stayed on his head. The government doesn't want anyone to think that he's being attacked or hit. This still photograph shows that his hat is being knocked off. That's the first blow to Mr. Rittenhouse. He continues to run. The testimony will show that these individuals are running up on him. What's important in this photograph, the evidence will show, is on the left, the testimony will be Mr. Huber is picking up his skateboard. Why is his skateboard on the ground? Because he has taken his skateboard and swung it at Kyle Rittenhouse's head for the first time, hitting him in the head. And you can see in the blue circle, Kyle Rittenhouse beginning to fall down. The two red marks are one, the individual who struck him first, and Jump Kick Man closing in. Kyle goes to the ground. This is a still photo from a video you'll see. What's important here, the evidence will show, it's an individual. Kyle's on the ground within 2 feet. Kyle points the firearm at him, does not fire. The individual backs up. He's no longer a threat. Kyle does not discharge his firearm. Next picture. The unidentified complaining witness, Jump Kick Man, kicking Kyle in the face. Behind Jump Kick Man is
who jump
Huber.
Kicks with their hands in their
Now he's
crotch
picked
like
up
that.
his
It's very
skateboard.
weird.
This is a photograph from a different angle, a different individual. And you see him running in Kyle's direction. There's the boot right before contact. Those are the boots that struck Kyle Rittenhouse in the face. Here is the photograph. Mr. Huber's bare hand on the skateboard, holding the trucks, bringing it into contact with the back of Kyle Rittenhouse's
Don't
head.
call them trucks.
Jump Kick Man still has not even gotten completely on the ground. And where is Mr. Huber's hand? And it's important here, ladies and gentlemen, it's a bare hand grabbing his gun. The state will produce evidence, I believe, that there's no DNA on the gun. He must not have touched it. Ladies and gentlemen, there's video photographic evidence of him touching the gun. Next, bare hand
What the
pulling
point?
the
It's his
gun
gun.
towards
Isn't there
him.
going to be DNA evidence on
Oh,
it?
Jump
damn,
Kick
that's
Man
a good
getting up
angle.
to run away. You see a close up, the bare hand on the gun. Kyle Rittenhouse flat on his back in the most vulnerable position one can be in. There, the strap is pulled tight.
That's about as
Mr.
self-defensey
Huber's
as you
trying to
can
pull
get,
the
in all
gun away
honesty.
from Kyle Rittenhouse as he's laying flat on his back. Kyle's afraid he's going to be disarmed and shot with his own weapon. The evidence will show he fires one shot, striking Mr. Huber. In this photograph, just entering from the right, the evidence will show is Gaige Grosskreutz. One hand, a phone, one hand, a firearm. Here's Gaige Grosskreutz with his hands up. Kyle Rittenhouse does not fire. Look at the distance between them. Huber's skateboard has not even hit the ground yet. That's how fast all these things occur. Mr. Grosskreutz does not stay in that position or back up. He moves in on Kyle, getting closer, pointing the gun almost directly.
Oh, sorry. What I was specifying is that the guy that's hitting him with the fucking skateboard, if he's reached back and is trying to handle his gun, if the prosecution are arguing that because there's no DNA on that gun, he can't have picked it up, that to me is a little bit suspect anyway, because if it's his own gun and it's in his back pocket, shouldn't there be DNA on it anyway from him having put it there in the first place? Like, the fact that there's no DNA is more of a surprise to me than anything else. Vaporize the arm, Mr. No Bicep. So, red misters his bicep. Oh, gross. All right, this will be interesting.
At his head. As the state said, he's like this, but look at where the gun is going. The gun is in the circle.
Oh, he was grabbing
it
at Kyle's
hasn't got
gun.
directly to
I
pointing
thought
at
that was
Kyle's
something that he
head,
was trying to pull
but
one
it's
out of his
going
back
there.
pocket.
Kyle fires
It's that.
once,
My
hitting
bad.
him. Another individual approaches after Gaige Grosskreutz has been shot, puts his hands up. Kyle Rittenhouse does nothing. In that in event number 2, the whole event from first shot with Mr. Grosskreutz, jump kick man coming in and getting the 2 shots, to the time Gaige Grosskreutz is shot in the arm is about 5 seconds. You'll have exact times of those shots, how fast it occurs. And after the shooting that evening, Mr. Grosskreutz was interviewed.
Oh.
He told law enforcement his story of that evening.
Is he going to say what he said?
One interesting detail he forgot to mention was that he was armed when he got shot. He told the police that he had lost his gun as he was running down Sheridan Avenue. He didn't know that there were people out there like him videotaping and photographing everything. He had a gun in his hand, and that's why he shot. His statement says that the reason he went into the fray was because he had to stop Anthony Huber from beating Kyle with the skateboard. At 11:51,
really?
Kyle has gotten up. There are individuals around
Why is that defense?
in that area who've come at him. He's pointed his firearm, backed them off, and he continues in a northerly direction down Sheridan Road to 60th.
He just shot them. Hey, dude right here just shot them. Dude right here just shot all of them down there. That dude just shot them over there. That dude right here. Yeah.
Sorry, guys, just interrupted by Lady Overlawd, who was working it today. Been quite lovely heading off to work.
You see Kyle with his hands up approach the police car to turn himself in. The evidence will show that the police told him to get away from the car and go home. The police say that they pepper sprayed Kyle. Kyle didn't get hit with the pepper spray. He's not disputing that they might have shot pepper spray at him. That's why he backed up so quickly. He finally makes his way to car source 2 back at 59th, meets up with Dominic Black,
Finger's
the
gotta be
individual who sent
seething
him
at how
down to
long
car
this
source
is right
3,
now.
tells him about what had happened. Dominic Black, I believe.
It's ridiculous that he went to the police for help and they pepper sprayed him.
He saw him. He was white as a ghost, sweating like a pig, and he was explaining what happened, saying he had to do it. It was self-defense. They talk about going home. to Antioch. Dominic Black takes him home. They leave about 10 to 12. And at 1:20, Kyle Rittenhouse and his mother are walking into the Antioch Police Department, turning themselves in to the police, which is what he wanted to do here in Kenosha. But the way Kenosha was that night, with the police department surrounded by fence and things like that, he couldn't. He turned himself into law enforcement. He said from that day what he did.
Apparently.
He's made no bones about that. He acted in self-defense, ladies and gentlemen. The evidence will show that his actions on August 25th of 2020 were reasonable under the circumstances as they existed that night, being attacked by Mr. Rosenbaum. The evidence will show, and the law is clear, he didn't endanger those other individuals. The government can refer to him all they wish as an active shooter. The only person he had shot was Joseph Rosenbaum, who had made threats to kill, had made numerous statements about ripping people's hearts out. He wasn't afraid to go back to jail. And Nathan DeBroom will testify to some of the actions of Mr. Rosenbaum that night. And he'll testify, and it was one of the more telling statements, I thought, in a statement.
He just got the back to
If there was
jail in
trouble that night, Joseph Rosenbaum was there. And that's ultimately who visited himself upon Kyle Rittenhouse. The evidence will show he thought probably that he could get that gun from Kyle Rittenhouse. He was wrong. Kyle Rittenhouse protected himself, protected his firearm so it couldn't be taken, used against him or other people from Mr. Rosenbaum who'd made threats to kill. And the other individuals who didn't see that shooting attacked him in the street like an animal. Ladies and gentlemen, that's what the evidence will show. Thank you.
Woo! 40 minutes.
Thank you, Mr.
Good prediction,
Richards.
man.
Let's break for lunch, folks. I'm going to take a vote now, and I don't want to influence by phrasing it one way or another. Are you comfortable with the temperature here? I'm going to ask how many think it's too warm, just right, or too cool. So, how many think it is too warm in here? How many think it is just right in here? 2, 4, 6. How many think it's cold in here? All right. Well, the majority is going to roll, unfortunately. but okay. Thank you. We have this blower up here, which on occasion I used to, and it's gotten progressively worse over the years in terms of its enormity and intensity, but it controls the entire building. So I can't shut it. I can't ask them to shut it down because it has control over the water, the air throughout the entire building. And it's tied into what they did at the ceiling here in 1965 or so. All right. With that,
So
please
hot
don't talk about the case during the break. And is it unrealistic to set a tentative start time of about 1:15? But if you folks
45
want
minutes.
more,
That's a short lunch.
that's okay. Just let me know if you want more time, and then we'll use this as a trial for the future. If you decide you wanted to go less time too, we could do that. But right now we'll aim for 1:15. And any questions? Okay, thank you very much.
Okay, peeps. So we're almost exactly at the 4-hour mark. I've got just enough time to listen to what Nick and Kurt have to say just before they go into the break. So I'll start again tomorrow. If you're more interested in actually hearing the going into the first witnesses and that sort of thing, then I'll be starting from the roughly 4-hour mark at... We'll aim for 12:30. But keep an eye out. So if you are going to disappear as of now, just please remember to like and subscribe, hit the bell, and hopefully, we'll see you here tomorrow. As I said, I'm going to listen to some of what Dick and Kurt have to say. But otherwise, guys, I'll see you later. Okay.
Okay. So since I went first last time, why don't you go first this time?
Way too long. Way too long. It took him almost 20 minutes to get to the meat of his opening statement. What he should do is he should go back and reconsider and edit out that first 20 minutes, because his last 20 minutes was pretty good.
No promises,
because of some of the photos and the video and his statements. I think this is the risk with using tech in making these opening statements. It becomes a crutch, and you can use it way too long, way too much. You can include stuff that isn't really useful. One of the videos is supposed to show us that these people are breaking windows. You can't tell it. And he says afterwards, oh, that's what it showed. These are breaking windows. It's like, well, but I didn't see that when I watched the video. You told me after that's what I was supposed to see. That stuff was a mess. So the 41 exhibits or pictures, they weren't exhibits yet. The 41 pictures and videos, too much. But some of his stuff about Rosenbaum was great. So his stuff about Huber and Gaige Grosskreutz statement that he was there to stop Huber from hurting Kyle Rittenhouse, fantastic. Be very interesting to see how that pans out as it's introduced. He managed to get the Rosenbaum not wanting to go back to jail, or being okay with going back to jail, getting in there. Like, he got that in, which will be an interesting perhaps segue into getting ultimately the reasons that Rosenbaum would have been at jail or at the mental hospital into the case in general. So the thing I said on Twitter was this: the prosecution had a better opening statement. I don't know how you could watch those two and say that the prosecution didn't. He just did a better job. It was more concise. It was easier to follow. But the defense has a better case, and they laid that case out really well in this opening statement, even if it took forever to do. So we'll see how that goes. But I think on opening statement judgment alone, prosecution's was better by far. What did you think?
Yeah, so I'll just preface this by saying because there was some speculation in the chat about
how early am I waking up?
The case. I'm fairly familiar with the case. I've covered it on my channel, and I've been on the view that Kyle Rittenhouse has a valid self-defense claim. I've said it many times that I think it's a valid self-defense claim. So I have to, but what I have to do when I'm analyzing this is I have to put myself in the position of the jury, because the jury is supposed to look at the evidence only from what's in court. So to the extent they know anything, they're supposed to disregard that and not only look at what's being presented before them. So I have to put myself in that position when I'm analyzing this. For me, I thought this opening was like a 3 out of 10, possibly 2 out of 10, where the prosecution was 9. There were just a multitude of problems that I wrote down. The biggest overall problem, there are two big overall problems. One was the run-on sentences. There's just sentences that went on forever, and beginning new sentences with "and." The other big problem was he had no storytelling. He had no narrative architecture. This is what the prosecution did so well. They had a story, and they went through the story in a time sequence and with plot points and things that showed a direction and a narrative architecture. For me, the defense lawyer was presenting information, but there was no coherent or cohesive theme that was driving what he was saying. And also, unlike the prosecution statement felt like it was planned and rehearsed, and it didn't come off as rehearsed. What I mean by that is it seemed like something he had worked on and really gotten the wording down and gotten the timing down. It seemed like he could do it basically from memory. He had that statement down. The defense seemed like they were making it up on the fly. I don't know if that's true or not, but that's just the way it came off, or that he's just making things up. It didn't seem planned out. There was also this point
because of the
from
US
a technical
zone,
aspect of
so
law,
I'm not infringing
where
on my
the
work
chat has
hours.
pointed out that he used the word victim. Apparently
Yeah.
more than
I
once.
appreciate it when
So this is
people appreciate
this
them
is
doing
what shifted from a 3 out of 10 opening to a 2 out of 10 opening, because I didn't catch it anytime he said it. So I'll take the chat's word for it. But if he used the word victim in relation to these people, then the state has the argument of reopening that door. And so if they're now able to refer to these people as victims going forward, he sabotaged what was a major win for him. As a comment I made earlier, it's like, how do you make the videos and photographs of the thing boring? Because that was just, it was boring. It was, and he did get better at the end. I'll give him credit for that. He got better at the end, finished okay. But the first 30 minutes really were not good. So that's what I think. If you had to base it right now, you'd say that Kyle's going down in flames, which is not my preferred conclusion, but that's where I think, yeah, I thought it was pretty bad.
I disagree with the assessment that basing it on the opening statements would say Kyle's going down in flames. I think that the prosecution delivered a better opening statement, but I don't think it was a case-winning opening statement versus the defense's opening statement, personally. I think the defense, again, had a bloated opening statement, way too much extraneous stuff.
As long as shit. I forgot to mention that too. Oh God. Yeah, it was long as hell.
Getting to the worst part for me was getting to it. That's what took so long. It's like, just get to the opening statement, please. Can we get to where your thing is? But he had too much of a lead up. But he did have some really good stuff in there, and some of those photos are fantastic. Photos from angles that I hadn't seen before, which is nice. I've watched a lot of the video, but they grabbed some really good still frames of the hand on the gun. They've got I don't think his showing of Grosskreutz advancing was a very good still frame.
Yeah,
that's weird because he's like, look at how he's closer. It's like, well, you picked a completely different angled image, so I don't know that that's super helpful, but yeah, and pointing out that Gaige lied about having his firearm is an interesting sort of addition there as well. So it's and I think that's kind of important because Gaige is going to be the one testifying, right? Like, the other two are dead, as the prosecution is very happy to say. They're dead, so they won't be testifying. Gaige will, and he's already brought up credibility issues with Gaige, and I think he's on the road. Although I think it's mostly Binger's fault to bring in Rosenbaum's criminal history. And someone pointed out to me, this is something I missed in the prosecution's opening statement, which I wish I would have caught it. The prosecution said that Huber was a good guy, which is quintessential character statement that can open you up to introducing.
If he said that, yeah, that would be, yeah.
And see, that's the hard thing. The stream is being wonky.
We can go back to full screen because there's nothing to watch for a while.
Yeah. I'm actually going to switch to, whoops, wrecked. No, I'm actually going to switch to the court TV feed.
Okay.
Instead, I've heard the court TV has better.
And I'm not, please understand, when I'm giving assessment, I'm basing it off of what has been said in court up to this point, because that's what the jury has to do. Where are we right now? So am I saying that Kyle is toast? When I said that, did I mean based on everything that will be admitted? No, I thought I was fairly clear, but I'll say it again. I was basing it based on what we know up to this point, because the jury at least is supposed to conceptually block everything out of their mind except what's been offered in court. So all the jury knows is the opening statements up to this point. So based on that, how would you rate it? And I was like, well, based on that, Kyle's toast, which was my assessment, although Nick disagrees. He thought it was stronger, which is a valid disagreement of opinion.
No, I didn't think the opening statement was stronger. I just think the case overall is stronger.
Yeah. So I wasn't speaking to the case overall. I was speaking to what we know so far.
Right.
So yeah, when the witnesses testify, and maybe if this guy's going to be doing the case principally, maybe he's a lot better at questioning than he is at opening statements. I mean, different lawyers have different strengths. So as the evidence gets revealed and as the witnesses testify, the case hopefully for Rittenhouse will be a lot stronger, because I continue to think, based on all the knowledge we have, that Rittenhouse is not guilty. So hopefully that will become manifest throughout the trial. and hopefully someone else closes. Would be my thought. But the opening alone is not working. Not working great.
So it turns out the state's opening video on Court TV is 34 minutes 22 seconds. So if that's the case,
how long did they say?
I clocked it at 40 minutes, almost to the minute on the defenses. So 34 minutes to 40 minutes is I didn't realize the states was that long. It
didn't feel that long if it was that long. It felt shorter.
Yeah. So I'm checking the two ends of the video here. And yeah, it's the entire 34 minutes for the state. So the defenses was only 6 minutes longer. It felt a lot longer to me. Of course, that was my I guess I'll have to see when they release the actual time-stamped video.
I think that's got more to do with the actual
Court TV doesn't actually have a live stream
than anything
right
else
now.
As to why it felt
we'll
a lot.
Have to
certainly did to me as well.
Wait and see. Someone on Twitter mentioned that they have better view of the exhibits. And after opening statements, I guess the state's going to start the case in chief, right?
Negative towards the defense counsel. I mean, he's doing exactly what I'm doing, based solely on the information that is provided at the moment. I would say if there was nothing else provided, if there was no other commentary, if there was no evidence presented or anything like that, I do think right at this very moment in this trial that it would have been an issue for Kyle. I really do. I do think there was a heck of a lot more that they could have done. I mean, Natalie, if you're listening, I'm not like complaining about your colleague or anything. I'm just saying that based on my own opinion, I think that the opening could have been stronger. But, you know, them's the breaks. So.
Presumably. That'd be the next logical thing to do. Call your first witness.
Yeah, we'll hear.
No, so here's the thing, Mads. Here's the thing. From the juror's perspective, they don't know that any of it is bullshit. We have extrinsic evidence. We know that what he said is crap. But to the jury who don't otherwise know or should not know, he had the better delivery.
Our first witness and see how that goes.
Hey, Nate.
And people might disagree on the assessment, and perhaps the jury disagrees. I mean, we don't know what's in their head. I was just trying to give my best assessment of where we're sitting.
We're giving our opinions, and
maybe a little bit overcompensating because I'm so pro Kyle that maybe I'm a little bit overcompensating in trying to go the other way to be as fair. But yeah.
Yeah, the other thing, the thing that I brought up in the middle, which I do think is important, in places.
Oh, and Kyle's going to testify. Apparently, we should talk about the Fisher thought.
Yeah, we got to talk about that. One thing to remember: if there's a place with various stereotypical accents, like the movie Fargo, for example, or just Mark Richards talking, it may be annoying or grating to hear a thick Wisconsin accent. To me, who's in Minnesota, thick Minnesota accents are different, but also grating. But I'm from Texas. You're not up in Wisconsin or Minnesota. So it may be annoying to us, but to the people that are sitting there in the jury box, most of them, if they don't talk like that, you know, their dad does, their uncle does, their brother does, their mechanic, their priest, whatever. These people are used to these kinds of accents. So he's got that it's like a weird mix of Chicago and Wisconsin thrown together. And so it's an annoying thing, and he sounds really weird, and he draws out his words, and he starts every sentence with "and." But I think those affectations are probably pretty normal for the people who are sitting in the jury box.
Maybe that's fair. Maybe they will respond to that more based on their local, dialects and patterns. That's a fair point. But we have to go with the biggest reveal, which is apparently Kyle's going to testify now. Apparently, this is the thing.
Oh, I hope not. I mean, it can be done, but I think it's too risky. I don't see why you would. The only thing I could see that as to the idea of why you would have Kyle testify is to get his state of mind on the record from him. But that opens him up to credibility issues. It potentially opens the door to the other acts evidence that they've already successfully had excluded, rightfully so. But if Kyle makes any sort of statement into like, well, I've never really been in a fight before, or, you know, I was scared because I'm not used to fighting, then the defense gets to bring in that video of him clocking that chick in the face, right? Like that.
Yeah.
That's a lot of risk. I don't know. I don't think I would do it. It's so far in what I've seen in this case, there's no reason to get Kyle's state of mind evidence from Kyle because the prosecution doesn't have any good evidence about his state of mind.
The problem also is with this particular prosecutor, because the standard reason that lawyers counsel again is because the prosecutor can usually do something to make you look guilty. And I have more confidence in this prosecutor than your standard prosecutor being able to do that, because he just seems more with his game to my mind. So the idea that he can extract statements from Kyle that will seem damning that he can use in his closing doesn't seem that far-fetched to me. So, and as you point out, there are other things that Kyle could say that he could open doors to things that would allow things that otherwise are not admissible to become admissible.
Right.
So
now,
if he has a real prospect of saying something.
It's important to note that Richards very likely, as he did several times during his opening statement, could have misspoken, and that he doesn't intend to have Kyle Rittenhouse, because he mentioned it in the context of another person testifying as well. He might have just said, as my client, as this person will testify, as a mistake. So we're going to the conclusion that Kyle will testify based on what he said here. He may be misspoke or misstated. I hope Kyle does not testify. I don't think it's necessary for him to do so in this case. There's plenty of statements from the deceased. There's statements from Gaige Grosskreutz that support Kyle's state of mind, and I think that's important.
Yeah. I know continually that I'm getting a lot of criticism from the chat, so I'm not sure if I'm not explaining myself correctly, or
no, it's just
I
a
am
charged
myself
topic,
correctly and they hate me.
It's a charged topic, so you know people want Kyle to win.
I want Kyle to win.
Yes,
I want Kyle to win.
But it's the same thing someone else was pointing out.
I consider myself, and the chat's going to disagree with this rapidly, I'm sure, but I consider myself right wing. I consider myself very pro gun, and I'm just looking at this, and I've always to this point been like, I want Kyle to win because it seems clean to me, based on what we knew. And then I'm trying to say, okay, let me put all that aside and try to put myself in the position of a juror who's supposed to be only considering the things that they hear in court. And what do we know thus far from that frame of reference? Now, it might be true, as you've pointed out, that his mannerisms and speaking style will be more amenable to a jury based on what they're used to. I can only speak to what I can only speak to how I would react. But then again, I'm not being called from that community. So maybe there's something there that I'm not factoring into the consideration, but you know,
yeah,
neither's Nick. So we're doing our best.
This is the thing. And it's why getting things like, why it was good for Richards to get the, you know, he wasn't afraid to go back to jail statement in. It's why the prosecution hits on shooting him in the back, right? Because no matter, the prosecution has put the narrative in front of the jury that Kyle shot Rosenbaum in the back.
Yeah.
Now, the defense has an uphill fight to counteract that narrative, and they may be able to do so. But the jury is never going to be able to push from their mind that the first thing that they heard about Joseph Rosenbaum being shot was that he was killed from a gunshot to his back. And the jury's also not going to be able to push from their mind the fact that they heard Rosenbaum say something about going to jail. It may not come up. It may come back up. There may be argument about it. There may be an objection about it later. But in the same sense, you and I cannot take out of our minds everything that we've seen about this case up to this point. So you make a really good point about that, and that we're trying to do this, and we have to actively try and mitigate what we've seen, whereas the jury doesn't have the same level of issue. Now, they have some level of issue. We also have to mitigate the fact that we know the law and have seen, we've read statutes about it. We know common law self-defense. We've read cases about self-defense, and we're trying to take that out of our minds as we do it. So we may overcorrect or overcompensate on some of these things. Or we may give too much faith to the jury too. It's 12 people that we've never met. So that's what makes juries so interesting. And the one last thing I want to say to anybody who's really dooming out about anything so far today or at any other point in the trial, is this: it takes one juror for Kyle to win. It takes 12 jurors for the state to win. And that is a really big thing. If the defense is able to identify a couple jurors who seem to be following along with what they're saying and who seem to be with that, that's all they need to do. They need to feed them all of the red meat, and everybody else gets a salad. Who cares? That's how it goes.
Yeah. Some of the actual videos and photographs that were used in the opening argument, obviously, when there will be admitted as evidence and will be very persuasive ultimately. It's just the presentation framing. It's like what I said from my notes that I took. It's like, how do you make video and photographs of this boring? That I wrote that down with 3 question marks. So the videos and photographs speak for themselves, but the way they were presented, I was like, what now? Huh? Which I think was readily apparent. People saw me half falling asleep, which,
Well, it felt really long. And I had to refocus. I mean, I have some level of ADD. I don't know how much, but I had to refocus several times to try and follow, because, oh boy, it was long statement. It was jumbled. It felt disorganized. And that presentation factors into how much attention people were paying. I do think that he got a lot of the garbage out first, and that his ending was stronger. I just wish he could have made that a little more concise. And I think he should have gotten rid of some of the videos and some of the photos to pick up the speed on that. But we'll have to see. I mean, we won't actually ever see the result of how this particular thing played in the mind of the jury, which is an artifact of how this all works. But we'll have to see as the case keeps going. Did you need a break?
It might very well get better. One will hope, because the videos and footage, as Nate has said, as I've said, as Nick has said, that all seems to show self-defense to my mind.
Yeah.
So one can only hope that the evidence will be presented, when it's actually presented formally, in a way that's going to stick with the jury. And please, for the love of God, get someone else to close.
Maybe Sharif C will do the closing. He seemed a lot
better yesterday. I was like, where was that guy? He seemed pretty odd.
He's got a very good speaking style. He makes good arguments. But who knows what the overall strategy is. Oh, and for everybody out there saying Barnes would have done a better opening statement or whatever, Barnes is never going to give an opening statement in this case. He may not have been ever even appearing before the court, no matter what the circumstances are. So those kind of statements aren't really helpful. And someone asked who hired Richards. Well, Kyle did. Kyle's the client. He's an adult, and he's the one who presumably has control over who his counsel is. So that's one important thing to note on all of this, is that the team that is there because Kyle wants them. Kyle has had the opportunity to change teams. In fact, he did change from John Pierce to Mark Richards and Mr. Sharifsi, and he seems to have confidence in what they're doing. Kyle has resources out there to maybe change that, although I know there's some competing narrative on that, but I can't verify any of it at this time. And so it's whatever you may think about Barnes being on or off the team, and there's some legit controversy and questions about it, that would not change who's giving opening statements and how that statement went. So those types of things are important to remember, People think just because one person is an attorney on the case, that means that they would be doing all these aspects. Kyle has at least 3 attorneys if Barnes is still his civil attorney in some respect, and he may have several more. So that's not how things play out.
And as the chat pointed out, the prosecution objected during the opening, which is a dick move and tends to annoy the jury.
Yeah,
because the opening and closing is the purpose of it is to frame the argument, right? So the opening is here's what you will hear. Here's all the stuff, and to put it into a frame so that everything can be understood. Because the facts by themselves, you have to put them into a frame. The prosecution put them into their frame. I thought it was a very good frame.
By the end of this, he won't be surprised about any.
You put them into a frame. Here's what we'll show. At the ending is here's what was shown. It's dick move to object, and when you do that, it can make the jury hate you a little bit because you're interrupting them listening to, what's happening. So it's ill-advised.
Yeah, especially when the defense did not object to the prosecution's opening, despite, if we're being nitpicky and technical, there were some aspects of the prosecution's case that the defense could have objected to. Would they be successful? Probably not, but they would be grounded in making the objection. It wouldn't be a sanctionable thing to do so. And they did not do that. When you combine that in, and the jury doesn't know this, but we do, which makes it extra dick move, with the fact that he raised substantially the same objection prior to the actual opening statements, and it was resolved and ruled on by the judge. The fact that he would go on and say, Your Honor, I didn't think we were going to make out our whole case again in his objection during things no.
The prosecution's objections at the very start were manifestly true. It's like, I didn't think we were going to argue the entire case, which we just did basically.
Yeah. And you were overruled, or you were, I guess, overruled on your initial objection. Now you had to be overruled again in front of the jury. And that, to me, that made it extra dickish. The jury doesn't get to consider that because they don't know about those initial arguments, but we do, and we will never forget. Bingo.
Fair.
Real quick, do we want to address the elephant in the room? The fact that
I thought I had addressed all the elephants in the room, but there are more elephants. Sure.
Richards did drop the hard R N-word a couple times. And I
only heard it the once. Was it more than once?
I think it was like twice in quick succession.
Okay.
I think it's actually, like, I laugh. I think it was actually maybe a smart move to do so. The alternative would be him saying the N-word, but I think it might have been okay for him to do it because it's shocking, jarring, and attention grabbing, and the rest of his thing was not. So very that's my point on that, is that it's drawing extra attention to this thing that is patently offensive, that has just happened on video from one of the deceased. And that's a part of their case, is his general rowdiness and craziness. So I'm going to go with it. I wouldn't have done it. I don't think I would have done it. I think I would have said N-word. I would have played it safe.
I think I'm not paying attention.
I think I tend to agree.
That's a tough call. Well, hey, I have to go to the bathroom. Do you need a break at all? Or are you good to hang out for a bit?
You can go to the bathroom and I can entertain the chat and defend myself more while you're in the bathroom.
Never defend. You're on the show. You don't have to defend.
Yes, but I want the chat to like me.
That's
so
true.
I have to try harder.
That's true. I just realized my headphones are on backwards.
Oh, really?
I'm pretty sure.
Okay.
First lawyer raised the bail, but
backwards headphones. I'll be right back.
Okay. So it'll be just me for a while. I'm on civil law, in case you haven't checked out my channel. We have over 1,000 videos dealing with legal stuff, mostly courts of appeal, U.S. Supreme Court. Oh, incidentally, while I'm thinking about it, I'm just waiting for the transcript to be synced up with the audio. The U.S. Supreme Court just had oral arguments on whole women's health and U.S. versus Texas yesterday. Those are the abortion cases coming out of Texas relation to SB 8. So I've been covering that on my channel a lot. and we will be doing a Supreme Court React where we'll be going over the oral arguments as we do and constructing them. So I'm just waiting. I have the transcript, I have the audio, but OYEZ, Oyez, it's pronounced Oyez in case you wanted to know. OYEZ.org syncs it up. So I'm just waiting for them to sync it up because it makes it a little bit easier than me trying to do it manually. So that'll be really, really exciting. So I'm looking forward to that. And I've covered the cases on my channel in depth. I basically have said that I thought what Texas was trying to do is extremely clever. And the U.S. Supreme Court seems to agree with that on the whole. So it'll be very interesting to see what happens. So all that good stuff. Also, as I'm sure some of you have noticed on my channel, we're trying a new editing format, which may or may not be a good thing. Also, someone was pointing out, it's like the color of law thing. It's like, we may not stick with it, but we try things and see how it works. And then if it doesn't work, we try different things. So also the music from some of the people I paid on Fiverr leaves a lot to be desired, but we press on. So good times. Become even more poignant. So let me just read you all the notes I had for this defense lawyer, just in order with all the issues I had. The run-on sentences. Yeah. Vocal variety, his speech was mostly monotone. 215. And he didn't vary his pitch. He didn't vary the loudness. He didn't vary delivery speed. It seemed to me whereas the prosecution, when he hit a strong point, he stopped. So he changed the pacing or changed things like that. It seemed to my mind the defense lawyer didn't vary his pacing. It was just a consistent throughout. He didn't vary the volume. He didn't vary the emphasis of particular words like the prosecution did. So the vocal variety was lacking. The storytelling aspects I've talked about before. This comes from trial advocacy, by the way, where, to tell a story. I mean, every trial is telling a story. Here's a whole bunch of things. What's the story behind the things? It felt very unrehearsed. It felt very like he was making it up on the fly. He mentioned the word victim, but we've covered that. The narrative is just missing. And and on just a purely technical level, yes, I understand that the things on the skateboard are called trucks. I get it. I understand. But the jury doesn't understand, so it's probably ill-advised to use the word trucks. It's correct in a technical sense. It is not helpful to the wheels or the axles. Just call them the wheels or the axle would have been fine. So that stuff. So I've been successfully vamping for a couple minutes now, but I could go more.
I got to get a bunch of super chats that I want to get to that I've been putting off because the court was talking. The one thing on the trucks aspect, I think you say wheels or axles in opening statement. And then I think when you're presenting evidence about the skateboard itself, you talk about the trucks, you get one out there. You bring an example of one to the court and you say, look at this. This is a hunk of metal that's attached to the skateboard. If you're hitting someone with this, it's adding weight. You might strike them with the metal. I mean, these are real dangerous things. And you bring that in. I agree. I think for opening statements, it should have just been a quick thing. I also do love, this is my favorite part of the opening statement, I've decided, was him saying that Huber was trying to literally decapitate Kyle with his skateboard. That was magnificent.
It was it was
remove his head.
I appreciate that. That's good flavor text.
I liked it. Okay, let me read some of these chats. American Legend says, good afternoon. Kyle is no monster. He doesn't seem to be a monster. And if they, if they start really getting into it and they really probably don't want to in general. They don't want to defend him being a monster because then they open the door to character evidence that would be contrary. And that's just messy in everyone's lives. But if they need to get into it, they'll play the video of him just weeping at the police station after turning himself in and all of that stuff. There's a lot to suggest he's not a monster. Next, we've got I hate this super chat. screen so much.
Is it like doing that thing where you scroll down and it automatically scrolls back up? Because that's my favorite thing.
No, for me, I scroll down and then it jumps all the way down to the bottom, and then I have to get back to it. Tommy TK says, Nick, I have agreed that the whole case hinges on Rosenbaum's death. It will imply if Kyle's an active shooter or defending himself. Can't wait to see. Next, AGK says, according to the prosecution, the Zeminski first shot. Why isn't this a felony murder case against Zeminski instead? Because they don't want to charge. So I guess the idea would be that he had a reckless discharge or a negligent discharge. That would be a felony case in Wisconsin, and then people died as a result of it. I think it's maybe a little attenuated.
The causation is slightly off, but it's a good question though.
Yeah. Well, and the other question is, why isn't Zeminski being charged at all?
All right. Come on, guys. I'm only going to say this once, okay? Both Vices and I have 2 rules. No drama, and don't slag off the guests. Okay? Now, we all know that there's going to be people that come up through this trial that some people don't like. I'm still expecting you to hold your tongue, or I'm turning this car around and we're going back to Disneyland. Okay? I can watch this on my own without you guys. I'm doing this because I enjoy the fact that I get to stream. I enjoy the fact that you guys like watching the streams, all that sort of stuff. Okay? So, there's plenty of other places where you can vent whatever you want to. Okay? But let's try and keep the chat at least civil. So... I don't care who started it, Captain Bipto, okay? I'll fucking end it. Disneyland shouldn't be used as a threat.
And that'll... What do you think about the defense raising these issues with who's being charged and not charged as, in exchange for testimony? Like, presumably... they would be, Nicholas Black, right? Mm-hmm. His friend is maybe not being charged with a straw purchase. Was he not being charged with a straw purchase in exchange for testimony for the state?
That's always a valid question to ask. Were you offered any kind of incentive to testify?
Yeah.
Not being charged would be an incentive. So, yeah. And that always goes to credibility.
Right.
Sure.
And so,
yes, it's a smart thing to bring up.
Yeah, that I think is going to come up on some of these witnesses. Unpleasant Alex, welcome to the channel. Thank you. Zalowarg says, isn't this very irregular? I mean, for the defense to display what can be construed as evidence during the opening statement. Irregular, maybe. I think it's probably getting more and more common as we go. I don't like PowerPoints and tech in opening statements. I don't like that idea at all.
Yeah. Well, I and as a public speaker, I'm just anti PowerPoint altogether. I hate PowerPoint with a passion.
Yeah.
Okay.
Yeah. It's a weird thing because you're always doing this. You're turning away. You're disengaging. You're pointing up there, pointing over there. A lot of, and even when he pulled up the self-defense thing, he then reads it to them. I hate having a PowerPoint slide read to me.
I am counting
with a fiery passion like that. That type of stuff is why I don't like it. But I think it's going to be more and more, as courts continue to catch up on technology,
all I'm saying
it's going to be more and more common as we go forward. Bilbonius Bag of Donuts says, it's a bird, it's a plane. No, it's Jump Kick Man. Mither and Emrys says, were his actions privileged, not was his actions privileged. Richards is killing me with his speaking style here.
That one you give him pass for. Wrong pass.
Yellow Flash 2 says, Kyle was only taking out the garbage. Mither and Emrys says, FFS Richards, the term victim should never be anywhere in your mouth when talking about any of these individuals. I agree. Binger threw a hissy fit about not being able to use the term in pretrial, and you drop it like that. And the funny thing is, it might have been all that fuss over the term as to why it slipped in. That might have been the issue. Yellow Flash 2 says, let's go, Brandon. Free Kyle. Pseudosnark says, does McInnes need to feel victimized? HR behind you. I don't know what HR behind me means, but does McInnes need to feel victimized? Maybe. I mean, it's going to go to the idea is that the state is charging Kyle with recklessly endangering McInnes, and he's going to get on the stand and testify, I didn't feel like I was in any danger. Like that's a...
Hey, didn't they put dab music on the radio? Don't tempt me.
Why are... I'm YouTube keeps telling me that there's a live video and it's not live over and over again.
Nice.
Wait.
That's
so YouTube was screwing up the Nick during this?
The idea is that
Fantastic.
He's going to testify that he didn't ever feel in danger. He was doing his job. That's going to undermine the credibility of that charge in general. And again, that charge is a weird one because if he shot Rosenbaum and the bullet happened to travel through him towards someone else, that's not recklessness, typically speaking. That's not recklessness as most people would think of it. Mithra Nimitz says, how in God's name did you already decide Kyle will testify? Stupid move. And then you are stretching this out. Get to the point. Kyle acted in self-defense. Focus on that. The rest is fluff and filler. Bad opening. Ovid says, can you fire your lawyer halfway through opening arguments? I mean, in theory, yeah, I guess. It wouldn't. I don't know if that's a good idea.
I don't know how that would work, actually.
This guy is a liability. After dropping the N-word, many jurors will be so off-put that Kyle is now kneecapped for the rest of the trial. I don't think that's actually going to be the case, personally, especially if people are right that it's 11 white women. I don't think that's actually going to bother them that much as people think. Not in Wisconsin, guys. You may think white people in the South are racist, but let me introduce you to the North. The Japanese Yakuza 1 says, after a day's work out in the rain, but I was an hour or so late and pride. Welcome back, buddy. Peter Bemis says, honestly, this may seem boring, but a lot of us saw the evidence for this a year ago. But for the jury, the mainstream media has been hiding this. Consider if this is all novel. That's a good point. You know, some of these people have not seen this evidence. We talked about that a little bit earlier. Mithra and Emmer says, took him 30 minutes to get there, but he finally started making some excellent points. Yeah.
Yep.
He's like a Wisconsin tractor. You just got a crank started or whatever. Scipio says, is the jury live or remote? They're live. I think the opening statement is good, but the camera moves between the attorney and the live video at odds with someone's natural attention. If they're sitting live, I think this may work well. Yeah, they're live. They're there. So all they do is they turn and look at the screen as he's talking. Irby says defense had better opening statement when they went, shoot me N-word, shoot me N-word. Also check Discord DMs when you get the chance. I will. Super Iron Bob says, make Uncivil's point in opening even stronger. The jury is coming not unbiased, but coming in misinformed by mass media, and the defense should know this. That's an interesting counterpoint there. I like that. Tall Skinny Geek says, how pro-gun can Uncivil be if he doesn't have a collection of them on the wall behind him? Called out.
Even then, YouTube didn't allow you to have it on.
Out. Where's your giant rack of guns? Just right behind you in the frame.
Did they?
Like Lauren Boebert or whatever.
No, that's okay.
Have you ever seen when she does the congressional hearings and she's got like the 2 ARs crossed and the 9mm sitting? It's awesome. I love that.
Nice touch.
Ray Fernandez says the opening was so long I was able to make breakfast, vote, and install a shower head, and still had time to watch the end part. It's election day. It's election day here in Minnesota.
Yes, I voted early, so I already took care of that. Yeah.
Oh, you serious?
I didn't. I don't know if I'll get to it. Probably not. I'll be here all day. Oh, well. Rayona says, not sure if it has been like this or if it is a glitch on my app, but if you type Kyle's name on the Facebook app search button, it says 196,000 are talking about it, but it won't show anything. Seems like they are blocking it. I must correct you on something. It's not Facebook anymore. Thank you. It's Meta.
That's right. Now, did they actually change the name of Facebook, or is Meta a holding company like Alphabet? I was. I think
Meta's the holding company currently.
Yeah.
It just seems changing the name of Facebook seems like this is way off topic, but seems like a very, very poor decision to me. But I mean, maybe they're getting out ahead of the MySpace death, right? Pseudo Snark says, I don't think they should have opened stipulating Kyle's testimony. He has to testify now, or they lied to the jury. Bad move. No, that's not true. Personally, they didn't actually stipulate to it, but if they're planning on him testifying, I have a lot of questions. I don't think that's a good idea. 2% right says, Dear Mr. Rackets, before I check out and head to bed, I ask if you haven't yet to watch Pauly Shore's Jury Duty on movie night at some point during this trial.
Yeah, you can say what you want about Legal.
I love that movie. It would be great to watch, but I don't think it's on Prime. And then some Russian letters that I can't read says decap doesn't mean axe guillotine only. There's a Lanto occipital dislocation thing as well. Yes, you'd have an internal decapitation. That is correct. That is correct. He said, he didn't say decapitation though. He literally said use a skateboard to remove his head from his shoulders. Hold on.
I doubt they're going to start on time if I'm a betting man.
For the myocarditis after vaccination.
Whoa!
Fuck.
I'm just going to take that off the screen for a second. You think, Nick? How did you wind up on the CDC website? Yeah, I agree. What the fuck is it doing on Court TV? Just hurry up and change this thing so I can put it back.
Now they do it. Thank you, you assholes.
How does Yahoo get into this exactly?
Yahoo is using the Court TV stream apparently.
Okie doke.
I tried to find the Court TV stream and they shut it down.
All right.
They're gonna start a new one. The hell is that? Are they trying to get people? Wouldn't that be a shady move, right? They're trying to get people covering the trial struck.
Because he's talking about, yeah.
Let me just give a countervailing statement. I'm not making any statements about COVID-19 or vaccinations or anything like that. I've never even heard the term myocarditis before. That was entirely Yahoo. Shut Yahoo down, not me. I did nothing wrong. That was Yahoo, and their YouTube channel needs to be shut down, not mine. I didn't do anything. Edward Redbeard says, Miles Mathis says it's all fake. No blood in video of Rosenbaum putting back of unmarked black ambulance. Blood pack on bicep. Arm should have hyperextended. Surname Rittenhouse is Jewish. All to distract from, this is it, the McMichaels trial. Yes. The Kyle Rittenhouse was a false flag event 2 years ago, or in the middle of last year. Solely
distract
purpose.
From Ahmaud
to distract
Arbery?
from Ahmaud Arbery and the McMichaels trial, which they had no way of coordinating those schedules in separate states for incidents that happened completely different times. No. So long story short, let me humbly suggest no. That is
YouTube says it could be mentioned. Okay,
that's funny if it's a joke.
I'd still rather that not happen randomly. But...
No, yeah, sure, sounds good. Wow. Yeah, Rekashu, you're correct. Imagine from the state of the world that put us here, having to worry about a medical video that might take away your income. Yep. It's that ridiculous.
Yep.
It's that crazy out here right now. With this stuff, let's see. Okay.
There we go.
Let's see.
Slowly taking shape.
All right. What else do we have here? I do have I do have the stream ready to go. They've kind of fixed it.
Yeah, but I've got permission from Nick, so I know I'm not getting
I
struck.
underestimate the power to them. What is my prediction in Virginia's election? Are the Reds going to take back the governorship? I have no idea. It looked like it's polling favorably for Republicans in Virginia. You have any opinions on that?
The Virginia race, yeah, it's looking really interesting. I was a resident of Virginia for many, many years until I moved to Texas about a year and a half ago. The fact that the Democrat is on the edge is amazing. It just shows because Biden won by lots of points in Virginia. So the fact that it's so close,
like 8.
Yeah, I think it was 8. I was about to say 10, but I was like, that can't be that high. So I avoided saying it because I didn't want to make myself out to be a jerk. But yeah, it was the fact that it's so close, I think the Republicans are actually going to pull it out, which is amazing.
Okay, what about this? This is a completely off-topic hypothetical for you.
Okay.
Are you familiar at all with the ADA? The
Sure.
Americans with Disabilities Act?
Yes.
All right. Let's say hypothetically you're a man with a paralyzed face.
Okay.
So you probably qualify. It's something called Mobius syndrome. Probably qualify. Makes communication, eating difficult. So Disability Act qualification probably assumed.
Sure.
Okay. Let's say that you on your insides are a beautiful singer and performer, but on the outside you have trouble doing this, right? So instead you have to hire a band, for example, to perform a song that you created for America's Got Talent.
Okay.
Does America's Got Talent owe you the money that you paid the band as a reasonable accommodation for your disability, since without the band you would not be able to compete?
I think the answer is no, because the thing that's being rated is not only the composition, but the actual performance. So if you can have the same song performed by multiple different singers, that doesn't mean it's going to sound as good coming from every singer. So yeah, it's not a reasonable accommodation. Also, there's a First Amendment implication in there that would also run against the ADA analysis. So there's that.
What about if the reasonable accommodation was not to pay for the band, but to just advance you automatically to the TV judges round in 2022 rather than in 2021?
No, that's definitely not a reasonable accommodation. You're going to have to go through every step of the process that anyone else does. Now, whether or not they need to give you an accommodation as part of those process or processes, but the idea that you would skip ahead as a reasonable accommodation, that's not reasonable.
Right. I think I agree with you. I don't know. I'm not.
Who am I trying to convince?
No one.
Okay, just curious. Is this a hypothetical? Is this a hypothetical because someone in chat made a stupid?
No. This is a hypothetical because a stupid who's not in chat filed a federal lawsuit against America's Got Talent based on.
Oh, I need a piece of this. I need a piece of this. Send me that thing. I want to cover that stuff.
I'll send it to you.
Yeah.
It's my man Russell Greer, the world's greatest pro se litigant, who has sued Taylor Swift, Katy Perry, Selena Gomez, a random stripper. He has done so many great things. He has lobbied actively for legalized prostitution in Utah, followed by forced prostitution and cheaper rates for disabled people to be able to have access to.
I'm sorry, what?
He is phenomenal. Nothing can stop this man. No amount of discouragement, lost income, or losses in general can stop Russell Greer from going after those rights.
Okay.
He did.
I don't think forcing someone to provide that particular service is going to fly. No.
I think you need to read his pamphlet.
Uh-huh.
Why I want to make it legal for your daughter to sleep with a disabled person for $500. I think you need to read that pamphlet.
Well,
it might.
Why prostitution should be legal is a little bit different than why they should be forced to engage with that with a disabled person. The prostitution should be legal. It's a classical libertarian argument. So that's not that hard if you want to go down that road.
What would you
He almost
say
said you wanna go
to
down with that
filing
load.
in small claims court a case against Taylor Swift?
I think I read this one.
Hypothetically. Yeah, for not
Was this-
acknowledging your gift, right? Like you sent Taylor Swift a gift. She did not get on Instagram and acknowledge your gift. Therefore, you have sued her in small claims court in Utah with the big brain plan that small claims parties are not typically represented. So therefore, Taylor Swift would be forced to come to court in Utah in person, and then you could offer to settle with her for dinner, but it's not a date.
Okay, so let's just go with basic gift theory 101. In order for something to be a gift, it has to be without consideration, which means by legal definition, you're not getting anything in exchange for it. So if you gave someone a gift and you said, I didn't get a thank you, you're not entitled to a thank you because it was a gift.
Surprise
so you're not entitled to anything.
Well, that's what happens in prison.
Yeah.
He brought that suit in federal court in Tennessee, I believe, to try and force, through the judge's order, every celebrity to offer a disclaimer anytime they issue a thank you for a gift, that they would not always issue a thank you. And he sued Taylor Swift for this is after the small claims. He brought it to Tennessee and sued her for $100 million.
Once again, the legal definition of a gift precludes any legal expectation of anything in return. It's a gift. It's gratuitous. Yeah.
It's amazing. It's amazing. I'll send you the ADA case. It's his newest case, and it is, whoo, boy, it is great. Like
someone said, "Oh yeah, is up on a synced argument." Excellent. I might do that tonight then. Excellent. Very good.
Wait, what?
So apparently the synced up argument. I think I was talking about this when you weren't here. I'm going to cover the U.S. Versus Texas and women's health case. And I was just waiting for the OYA to sync up the transcripts, and apparently that actually happened. So I would expect then tonight we're going to do Supreme Court React and listen to the live audio.
Yeah, guys,
you're welcome to come if you just want to make your daily streams even longer.
I think that's going to be right during my dinner.
Yeah.
But guys, if you want to check that out, that is a really interesting case going on. Kurt's channel is in the description. You just click on that tag of uncivil law. It'll take you right there. If you are interested in how the Supreme Court arguments went in regards to the Texas they're calling it a 6-week abortion ban, even though that's not quite accurate.
Serious question. If I come across Dan Andrews writhing on the ground and about to die, am I legally obligated to render aid, or can I crack a tinny and laugh at the smut? So long as you don't interfere with him in any way, enjoy your beer. And thank you for the super chat.
But the fetal heartbeat
no way legal advice,
ban that's going on in Texas that has been brought now before the Supreme Court. And this is, if I'm not mistaken, the U.S. government's case against Texas, right?
There were two cases argued. They weren't consolidated for argument. They were argued separately. Maybe there will be a consolidated opinion. But yeah, Whole Women's Health, which was the private people suing, and U.S., which is the U.S. government suing, were both heard on the first.
Yeah, that'll be
exciting.
That'll be a very, very interesting case to follow. And last time we talked about this, your prediction was that we'd get a ruling maybe by the end of November or in the middle of December.
Yeah, I still think that's right, because the timeline of the oral argument was so accelerated. What was it, like 6 days or 7 days to go from congratulations, you have a U.S. Supreme Court case to you have to argue this case? And you and I had basically a panic on stream because what?
Yeah, because how are you going to put together?
How are you going to write this? How are you going to prep for oral argument?
Yeah, on novel issues as well. Like this is new stuff, at least in regards to the government and how the government is handling that. Let me see.
So that should be a fun stream tonight, where we go over and try to pick apart those arguments.
What time is that?
Yeah, I have to set a time. Oh Lord!
Roughly, so people know.
Let's say 7 p.m. Central.
7 p.m. Central. Okay, there you go. So that'll be there. No, right after this show is done, I think at 5:30, I have to pop over to Adam Krigler, his show, and summarize what's going on in the case. And then I have to eat dinner and get ready for my 11 p.m. show.
Cool.
So I'm a busy boy today.
You are busy, but that's good. It's good to be busy.
Yeah.
Thank you for sharing the time to spend with me. It's nice. I appreciate it.
Absolutely. That'll be great. Illegal Mindset is going to come on for some of tomorrow's show. I don't know how much.
Excellent. That'll be fun too.
I know. I've never had him on. I've only tangentially talked to him on like an Eric Hunley show.
Yeah, I was trying to talk to him before the Eric Hunley show on the cameras. Like, oh, you should come on, and he seemed a little taken aback or something. But I would love to have him on my show too, because he seems like a really cool guy.
Oh, well, let's stop fluffing him up too much. He is still a lawyer, so I mean, come on. Cool guy. I don't know. I don't know about that. Is that even possible?
There's some cool lawyers.
There's not many of us, but we're out there.
There must be, right?
There's got to be some somewhere. No, so this was
no, it's not legal advice about killing him. It's about
so,
not intervening.
40 minutes for the defense case, 34 for Bingers. Although I do think we got to credit time served on the defense for 30 to 60 seconds for that objection as well.
Well, he did say he didn't think it would be much longer than the prosecution, so I'll give him correctness for honesty.
That's
was
right.
Not much longer. So yeah, but those two speeches felt like very different lengths of time.
Mm-hmm.
That did not feel like 30 minutes or 34 minutes. It felt shorter than that.
Yeah.
Although it was still a little too long. The defense's case felt like it went on forever. Yeah.
Let's see. Are you calling it a day soon, or are you going to wait for the stream to start again? No, we're waiting for the stream to start again. We
want to hear some. We want to hear some actual witnesses who might actually be able to testify to some things.
Yeah, the court will go on until I think 4:30 or 5 p.m.
I wouldn't go that far, my friends.
I will be here the whole time. Kurt will be here as long as he wants to be, and we'll be here for the full analysis. Nate, the lawyer, says, "What about the defense calling the men killed victim? Bad move."
I think
very bad.
We mentioned that
the job a little bit.
Some people in the chat were saying that the judges,
other than Nick, most of us are still working the job while being on YouTube.
But I can't speak to that.
I legitimately would be here. Like,
no, he said during closing,
do this with
you have some
I really do
leeway, but I don't think during opening you had the same leeway.
You
have to have the facts. Lay it out.
And sometimes that's stressful.
So yeah, the I can tell you for absolute certainty that the prosecution is going to be arguing. They open the door for us to mention the word victim now. So now we have to have that whole argument. That's probably what we're going to do rather than calling back somebody. We're gonna have a
the night of August 25th, 2020.
Okay.
We'll use that.
We're just straight into this.
Reference.
Oh shit!
How long before that?
All right, guys. Well, that's right on 9 a.m. for me, so I'm going to go and head into the office. Where are we? So we'll pick it up right from there at 4 hours, 43 minutes, and 44 seconds as of tomorrow. Guys, thank you so much for joining me. I hugely appreciate it, and I do thank everyone that sent through the super chats. Just quickly, we had Flux sending through a $10 super chat. Thank you. The question for Natalie, we didn't get a response, unfortunately. Thank you for the stream, said Sparkle TBD. Not a problem. Can't do much but something for doing this. Thank you very much, Gigi. Gone from April 15th to June 1, eye surgery and recovery. Well, Rabbit, surely someone can put it on in the background so you can listen, so you can continue to be entertained. Mandy with the $5 for what's your and perhaps Australians' opinion on Russia's Putin and West Taiwan's Poo forming an alliance. I think that's all for show, frankly. I really do. I think that is... I'm not sure China's happy with what Putin's doing, and I think they're trying to rein him in. But that is what it is. If you have a policy, your life is not worth my... I have a policy, your life is not worth my stuff. Don't touch my stuff, and I won't end you, says Flux. Have I mentioned how glad I am you're going back over this? I think we all forgot how bad Binger and Launchbox are. Fuck Binger. If you're deer hunting and you hit someone behind a deer, yep, we talked about this. Yeah, and it was a completely different scenario, but Kyle, I very much appreciate the super chat. And then we had Maphanger the $10 for whether or not he could stand by and not render assistance to our state premier, which I have no issues with. But again, not legal advice. What work? What's that? Tell me about it. Adios, Rusty Panda. Have a great day at work. Thank you very much, Rabbit. Very much appreciated. Julia, this is fun. I only found Nick right after the Rittenhouse verdict. Well, I hadn't actually seen this either, so it's it's basically the point of why I wanted to go back and do this. So now what are you going to do? Good question. I will have a quick look, see if anyone else is live and where I can send you to. Let's have a look. Who's in the redirect? Okay. From what I can see is that there's actually no one currently live at the moment. So, guys, unfortunately, it looks like you're going to have to twiddle your thumbs for a little bit, at least until Joe goes live later, I suppose. But as always, guys, please remember, you are not a piece of shit. You do have value, and you contribute to society, especially by being here and hitting that like button for me. Very much appreciate it. How's the model coming along? Give it a shot. We're close. We're very close. I'm just starting to put on the side armor. Oh, for crying out loud. There we go. That's a bit better. So it's getting there. But yeah. All right. Just clock off work and Hayden's heading in. The internet is cool. Blame the time zones, people. Alrighty. Where are we?
Fuck this shit, I'm out. Fuck this shit, I'm out. No thanks, don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.